ಕೋರ್ಟ್ ಆಫೀಸರ್ ಹೈಕೋರ್ಟ್ ಮ್ಯೂಟ್ ಆಗಿದೆ.
Immediately after vacation happen.
Okay, maybe.
Notice ಆಗಿದೆಯಾ? Opposite notice ಆಗಿದೆಯಾ?
Notice.
ಗೊತ್ತಿಲ್ಲ ಸರಿ ನೋಡ್ರಿ ನೋಟಿಸ್ ಇರ್ಲೇ ಇದ್ರೆ ತರಿಸಿ ನೋಟಿಸ್ ಆಗಿದ್ರೆ ತರ್ಸಕ್ ಬರಲ್ಲ. ಓಕೆ
Age has been filing an application for the extended.
ಮೇಕ್ ಯೂಸ್ ಆಫ್ ಮೈಕ್.
Because of COVID, my lords, the age has been relaxed to file an application for appointment, my lords. That has not been considered and refused my appointment. That's okay.
Immediately after vacation.
My lords, kindly after 3 p.m. my lords, the
Huh?
endorsement has been issued. Endorsement has been sent that I have not entitled. That is why because of
ವಾಟ್ ಈಸ್ ದಿ ಅರ್ಜೆನ್ಸಿ ಬ್ರದರ್? ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ ನಾವೇ ತಗೊಳ್ತೀವಿ. ಪಾಪ ನಿಮ್ಗೇನೋ ಪ್ರೆಷರ್ ಇರ್ತದೆ ಕ್ಲೈಂಟ್ ನಿಂದ, ದೇರ್ ಫಾರ್ ಯು ಆರ್ ಮೂವಿಂಗ್, ವಿ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ದಟ್ ಆಲ್ಸೋ. ಏನು ಪ್ರತೀಶ್?
Transfer matter,
permitted to move vacation bench.
Great.
Lots for the state, I'm making a mention.
Ah.
Lots in the sub-register offices on 6/11/6/12, my lords have passed an interim order. Lots paragraph 1 and 3, there is some confusion with regard to the fact that in respect of 20 officers, 2 persons, my lords, who are covered under para 1 and 3 are claiming the same post and they assume charge without we actually giving the charge.
Whatever you want to do in such matters,
Please, my
you
lords,
take a decision. Don't worry about rest of the things.
please. We thought it.
Because that option will remain with you as the employer.
Please, my lords.
Okay.
Please, I'll leave.
And if some action is being taken, if you are found to be faltered by
Please,
that, you
please.
mention that, we mentioned to the court and court said like this.
Great,
You can have the clip also.
please, grateful.
All right.
Seat number 26 madam.
26
madam.
26 ah.
M. Nagaraj is brother is passed away madam, your worship.
I'm objecting, my lord.
Yeah, but death has happened, you want to object.
I
What is this?
let it be adjourned, my lord. The only request is the interim order was passed in 2023. There's effectively a stay across promotions across the state of Karnataka.
Agatte.
They have taken time.
Correct. The death in the family of the lawyer has happened
They've taken
Sorry,
time to file
call it.
rejoinder on 3
in the
occasions.
third week of January 2025 on the ground of demise in the family of arguing counsel. Okay, interim order to continue.
Taken time for rejoinder. It may be specified, let them file it later.
Death, brother. Death ಆದಾಗ ಹಂಗೆಲ್ಲ ಹೇಳ್ಬಾರ್ದು. Death is an event. Death results into automatic revocation of will. ಗೊತ್ತಿದೆಯಾ? Will revocation ಆಗಿಬಿಡುತ್ತದೆ. Death of the test, in the marriage of the, in the English law, if death happens of particular persons, by that revocation of will happen. So William on Will's rights, it's a very event it is. Yes.
For respondent number 3, ma'am. For the appellant method.
Brother, we are dismissing it. We have examined everything. We are dismissing the petition.
Much
We are requesting the KAT to take up the matter on war footing. Let him know where the litigant stands. Inta matters ಎಲ್ಲ ಬಹಳ late ಮಾಡಿದ್ರೆ meaning ಕಳ್ಕೊಂಡ್ಬಿಡ್ತದೆ. We have also said, don't be impressed by whatever we have said in the above, because whole matter was argued. Therefore, we had no option
Yes.
not to comment upon that. But ಇದನ್ನ ಕೊಡಿ. Sorry, we were mentioned not that.
Because
One-
K.
Okay, sorry,
my-
sorry,
my
not
lord-
that, not
My
that.
lord, KT
That-
is not in the
that's-
pictures.
We are listening to KAT. Okay. Sorry. Yes.
I was a bit astonished, my lord.
IA 3 of 2015 filed under 41 Rule 27 of CPC is allowed. Appeal is allowed. The impugned judgment of the trial court is set aside and the matter stands remitted to the trial court for the fresh disposal after affording opportunity for the plaintiffs as well as the defendants to adduce evidence in the matter. Trial court is directed to dispose of the matter expeditiously, preferably within a period of 8 months. Both the parties are directed to appear before the trial court on 22nd January 2025. Registry is directed to transmit the trial court records and the document file along with IA 3 of 2015 to the trial court within the aforementioned date. In view of the disposal of the main matter, all pending IAs do not survive for consideration and hence they are also disposed of.
Sorry.
Much obliged. Much obliged.
Spot number 1.
Second appellant.
IA 1 of 2023 filed under order 41 rule 27 of CP is allowed. RFA 1433 of 2014 filed by the defendant number 1 and 2 represented by LRs, and RFA 1525 of 2015 filed by defendant number 9 are allowed. RFA crop 1 of 2015 filed by plaintiff is dismissed. Consequently, OS number 7702 of 2004 filed by the plaintiff stands dismissed.
Dismissed.
Obliged.
Ah. Yes, Vishwanath, ಏನು?
Translated version ಹಾಕಿದ್ದೀನಿ office objection
Ah.
and then process fee I'll file it in the office malad, and as far as report they have to procure from the government, they have to say, and in the meanwhile I sought for stay of the further proceedings before the land grab committee.
PC is my lordship rejected.
Ah?
Year before charge is rejected.
That's what year before
Year
charges.
before charge is rejected. That is,
Hearing before charge.
yes, that is rejected by the. This is covered by your lordship earlier.
ಯಾವುದು?
15064
Where exemption is granted.
is
Where exemption is granted. ಹೌದಾ?
15064 of 24. 15064 of 24.
ಜಡ್ಜ್ಮೆಂಟ್ ನಿಮ್ಮಲ್ಲ ಜಡ್ಜ್ಮೆಂಟ್ ಕಾಪಿ ಇಟ್ಕೋಬೇಕು ಒಂದೊಂದು. ಪ್ಲೀಸ್ ಹೆಂಗ್ ಗೊತ್ತಾಗ್ಬೇಕು ನಮ್ಗೇನು ಅಂತ? ಎಷ್ಟು ಮ್ಯಾಟರ್ಸ್ ಮಾಡಿರ್ತೀವಿ ಅಂತ ನನಗೆ ಗೊತ್ತಾಗೋದಿಲ್ಲ.
I'll have a look.
ಅವ್ರಿಗೆ ಒಂದು ಕಾಪಿ ಕೊಡಿ.
Is this my lordship, Tahsildar reported that my lordship, as per the revenue records, my lordship he got the my lordship and that extent, but Tahsildar given report that he is encroached the government land. That is my lordship under inquiry.
Lords,
So question of fact is involved.
3 acres is not in dispute, but I am the purchaser. And so far as according to the report, 22 acres encroachment, and I am the last person. If it are 3 acres, man, I don't want.
Let him my
single bit of
lordship,
land,
let him my lordship, that land will,
that submission may be noted. my lord.
liberty is given to the government.
And
accept.
To take that entire.
Please.
No, there are RTC that have placed before this honorable court to substantiate that there are so many grants in this survey number 21.
ಅಲ್ಲ ನಿಮ್ದು ಹೇಳಿ.
Nandu 3 acres grant ಆಗಿದ್ದು I purchased. Thereafter, Deputy Commissioner initiated proceedings before the under section 163. Deputy Commissioner holds that the grant in favor of my vendor is denied, and thereafter 3 acres I am in possession. That's my grievance, my lord. So whatever this thing, only thing is one third party has filed an complaint before the land grab committee. On the basis of that complaint,
Saying-
now ಅದೇ land grab committee ಮುಂದೆ ಹಾಕಿದ್ದಾರೆ third respondent.
ಅಲ್ಲ ನೀವು ಥರ್ಡ್ ಪಾರ್ಟಿ ಹಾಕಿದಂತ ಕಂಪ್ಲೇಂಟ್ ನಲ್ಲಿ
Yes.
ಎಷ್ಟು ಎಕರೆ ಗ್ರಾಬ್ ಮಾಡಿರಿ
ನಾನು ಏನಿಲ್ಲ
ಅವ್ರು ಹೇಳೋದೇನ್ರಿ? ಅವ್ರು ಹೇಳಿದ್ ಹೇಳ್ರಿ ನಿಮ್ ಮೇಲೆ.
ಇದರಲ್ಲಿ ತಹಸೀಲ್ದಾರ್ ಏನ್ ಹೇಳಿದಾರೆ ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್ ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ, ಬಟ್ ತಹಸೀಲ್ದಾರ್ ಹೋಲ್ಡ್ ಸರ್ವೆ And he holds that 2 acres in possession of Jan Sebastian and 1 acre in possession of Jan Sebastian. That's what they have.
That is also finding given by the land
Subsequent-
grabbing court, my lord.
ಕ್ಲಾರಿಟಿ ಇಲ್ಲ ನಿಮ್ಮ ಸಬ್ಮಿಷನ್ ಯು
No.
ದೇರ್ ಇಸ್ ನೋ ಆರ್ಟಿಕ್ಯುಲೇಷನ್ ಎಟ್ ಆಲ್.
Please, my
ಬರೀ
lord.
ಇಂಗ್ಲಿಷ್ ಶಬ್ದ ಬರ್ತಾ ಇದಾವೆ. ನಾನ್ ನಿಮ್ಗೆ ಕೇಳ್ತಾ ಇದ್ದೀವಿ,
Yes.
ನಿಮ್ಮ ಮೇಲಿರುವಂತ ಅಲಿಗೇಷನ್ ದಲ್ಲಿ ಎಷ್ಟು ಎಕರೆ ನೀವು ಎನ್ಕ್ರೋಚ್ ಮಾಡಿರಿ ಅಂತ ಹೇಳಿದ್ದ ಕಂಪ್ಲೇನೆಂಟ್.
Complainant 22 acre ಅಂತ ಹೇಳ್ತಾರೆ.
ರಿಪೋರ್ಟ್ ಆಫ್ ದ ತಹಶೀಲ್ದಾರ್ ಸೇಸ್ ವಾಟ್?
ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್ ಅಂತ ಏನು ಹೇಳಿಲ್ಲ.
ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್ ಇದೆ ಅಂತ ಹೇಳಿದ.
Government.
ಅವ್ರು ಅದ್ರಲ್ಲಿ ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಒಂದ್ ಲೈನ್ ಸೇರಿಸ್ತಾರೆ. ಆಮೇಲಿಂದ ಅಗೇನ್ ತಹಸೀಲ್ದಾರ್ ಹೋಲ್ಡ್ಸ್ ಸರ್ವೆ and ತಹಸೀಲ್ದಾರ್ has conducted survey thereafterwards pursuant to that they have identified that 3 acres and 2 acres is in possession of this. I'll place this document.
You are in possession of 5 acres.
No,
For 3 acres.
2 acres plus 1 acre.
1 acre. I'm the purchaser. That's all, my lord.
ಅದು ಆ ಪ್ರಾಪರ್ಟಿ
That observation is also made by the land grabbing court, my lord.
ಏನಂತ
3 acres he got the right.
ಅವ್ರದ್ದೇ ಅಂತ.
ಹೌದು.
ಮತ್ತೆ ರಿಮೈನಿಂಗ್ ಪ್ರಾಪರ್ಟಿ ಎಲ್ಲ
Remaining
ಕೊಟ್ಟು ಬರ್ತೀರಿ,
government
ಹೇಳ್ತಾ
land
ಇದ್ರೆ
is
ಮಾತು
also-
ಮುಗಿಸ್ರಿ.
ನಮಗೆ ಏನು ಬೇಡ.
Tahsildar report, my lordship, government land is also encroached by the petitioner.
ಅದು ಈಗ 2 ಎಕರೆ ಪ್ಲಸ್ 1 ಎಕರೆ ನೀವು ಒಪ್ತೀರಾ?
Yes.
2 ಎಕರೆ ಪ್ಲಸ್ 1 ಎಕರೆ ಮೆಜರ್ಮೆಂಟ್ ಮಾಡಿ ಆ ಲ್ಯಾಂಡ್ ಅನ್ನು ಅವ್ರಿಗೆ ಬಿಡ್ರಿ. ಉಳಿದಂತ ಲ್ಯಾಂಡ್ ಅನ್ನು ಅಷ್ಟನ್ನು ಅವರಿಂದ ತಗೊಂಡ್ಬಿಡ್ರಿ. ಅಂದ್ರೆ 19 ಎಕರೆ ಬರ್ತದೆ. ಉಪಯೋಗಿಲ್ದ ಕೇಸ್ ನಡೆಸೋದ್ರಿಂದ ಏನ್ ನೋ ಯೂಸ್. ಯುವರ್ ಅಬ್ಜೆಕ್ಟ್ ಇಸ್ ಟು ಗೆಟ್ ದ ಲ್ಯಾಂಡ್ ಬ್ಯಾಕ್. ಹಿ ಈಸ್ ಅಗ್ರಿಯೇಬಲ್. ಹಿ ಈಸ್ ಸೇಯಿಂಗ್ ಐ ಆಮ್ ಅಗ್ರಿಯೇಬಲ್. ಮತ್ತೇನ್ ಕೇಸ್ ನಡೆಸೋದು ಅವನ ಮೇಲೆ, ಇದ್ರ ಮೇಲೆ?
Please,
ನಿಮ್ ಲ್ಯಾಂಡ್ ಬೇಕಪ್ಪ, ಲ್ಯಾಂಡ್ ತಗೊಳ್ರಿ ನೀವು. ಈ ಸುಮ್ನೆ ಅನಾವಶ್ಯಕ ಪ್ರೊಸೀಜರ್
now got the right in 3 acres.
ಬರ್ಕೊಡ್ರಿ.
In page number 51, observation is there.
ಇದು ಅವ್ರು ಹೇಳೋದು 2 acres 1 acre ಒಪ್ಕೊಂಡ್ಬಿಟ್ಟಾರೆ, ಇದನ್ನ ಕೊಟ್ಕೊಂಡ್ಬಿಡಿ. ಇನ್ನು ಓದಿದ್ದೆ ನಾವು ಮಾಡಿ ಅದನ್ನ ಬರ್ದ್ಬಿಡಿ ಅಲ್ಪ ಅಷ್ಟ್ ಮಾಡಿ ಮುಗಿಸೋಣ ಅಂತ. ಅವನ್ನೆಲ್ಲ ಸುಮ್ಮನೆ ಅನಾವಶ್ಯಕ 50 ಕೇಸ್ ಇಟ್ಕೊಳ್ಳೋದು, ಅದರಿಂದ ಏನು ಉಪಯೋಗ ಮುಟ್ಟಲ್ಲ. The way the cases are prosecution is conducted, we know how they are conducted ಅಂತ. At least he is saying 19 acres ನಾನು ನಿಮ್ ಗವರ್ಮೆಂಟ್ ನಾ ತಗೊಂಡಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. I will record that submission.
I leave it.
ಮಾಡಬಹುದಾ?
Please.
ಬರ್ಕೊಳ್ಳಿ. ನಿಮ್ದು ಮೆಮೊ ಕೊಡಿ. ನಾನು ಹಿಂಗ್ ಬರ್ದ್ಬಿಡಿ ಅದರಲ್ಲಿ. You can think this way. That now your case is that you are in possession of 3 acres, 2 plus 1 pursuant to sale deeds. Correct? Rest of the lands you are not in possession.
There are no claim over that.
You have no claim also, you are not in possession also. And government can do whatever it wants
But
to.
all if there is this thing, because as per the schedule, I am in possession, but if at all, if there is anything, let them take it, my lord. But they demarcating 2 acres and 1 acre, that's all.
ನಮ್ಗೆ ಬರ್ಕೊಡಿ. ಆ ರೀತಿ ನೀವೇನ್ ಕೇಳ್ತಾರ ಸ್ವಲ್ಪ ಕ್ಲಾರಿಟಿ ಇರ್ಲಿ ಬರ್ದು ಕೊಡುವಾಗ. ಏನಂತ ಬರೀತೀರಿ? ಕೂತ್ಕೊಳ್ಳಿ ಸ್ವಲ್ಪ ಹೊತ್ತು ಪಾಸ್ ಹೋಗ ಬರ್ಕೊಡಿ. ಅವಸರ ಮಾಡೋದು ಬೇಡ. ಮತ್ತೆ ಅದು ನಿಮ್ಗೂ ತೊಂದರೆ ಆಗ್ಬಾರ್ದು, ಗೌರ್ಮೆಂಟ್ಗೂ ತೊಂದರೆ. ಅಟ್ ಲೀಸ್ಟ್ 19 acres 18 22
22, 29 acres.
19 acres ನಿಮ್ಗೆ ಏನು ಕ್ಲೇಮ ಇಲ್ಲ.
ನಮ್ದೇನಿಲ್ಲ, ಬೇರೆಯವರು ಇದ್ದಾರೆ ಅದಕ್ಕೆ.
ಅದು ಬಿಡಿ, ನೀವು ಬೇರೆ ಬಗ್ಗೆ ತಲೆ ಕೆಡಿಸ್ಬೇಡಿ. ನಿಮ್ದು ಹೇಳಿ. ಪಾಸ್ ಓವರ್. ಅದನ್ನ ಬರೀ ಬರ್ದು ಒಂದ್ಸರಿ ನೀವು ನೋಡಿ ಅವ್ರಿಗೂ ತೋರಿಸ್ಬಿಡಿ. ರಫ್ನೆ ತಗೊಂಡು ಬರ್ಕೊಂಡು ನಂತರ ಗ್ರೀನ್ ಶೀಟಿಗೆ ಹೋಗಿ.
Petitioner, my lordship.
Ah.
Objection is that, my lordship.
My lordship,
Brother,
serial number 5 and serial number 16 is connected, my lordship.
5 ಮತ್ತು 16
Please, my lordship.
ಏನಿದೆ?
ಅದನ್ನ my lordship, suspension order challenge ಮಾಡ್ತಾ ಇದ್ದೀನಿ ಸ್ವಾಮಿ.
ಹಾ.
And 24/8
ಇವಾಗ ಸಸ್ಪೆನ್ಷನ್ ಆಗಿತ್ತು.
24/8
27/8/20,
8/24
ಎಷ್ಟು ತಿಂಗಳಾತ ಈಗ?
2 months.
2 months.
27/8/9.
8 ಎಂಟನೇ
Yes,
ತಿಂಗಳು.
8ನೇ ತಿಂಗಳು ಆಗಸ್ಟ್ ಅಲ್ಲಿ.
4 ತಿಂಗಳ?
4 ತಿಂಗಳಾಯ್ತು.
ಎರಡಲ್ಲ.
But my lord,
But-
very serious irregularities, my lord. The other day we have, my lords have heard similar matter. This is irregularities happening in the jail, my lord, central jail.
That matter,
Similar type, my lord.
similar
Similar
type.
type.
Yes, my lord.
Then
Here, my lord,
ಯಾವ ಡೇಟಿಗೆ ಹಾಕಿವ ಅದನ್ನ
ಅದು ನೋಟಿಸ್ ಮಾಡಿದ್ರಿ ತಾವು.
ಯಾವ ಡೇಟಿಗೆ ಹಾಕಿದ್ರಿ ಅಂತ
After vacation ಅಂತ ಹೇಳಿದ್ರಿ.
ನಂಬರ್ ಇದೆಯಾ?
Yes, my lord, I have the number. I have
Hello.
the number. I can give that.
Um,
But my lord, here, my lord, they are not
4
possessing
months,
mobile.
6 months ಗೆ ಇದು ಎಕ್ಸ್ಪೈರ್ ಆಗಿ ಹೋಗ್ತದೆ.
ಅಲ್ಲ, one submission.
ಹಾ.
Submission. Kindly see the my lordship. A1 ಏನಿದೆ ಸ್ವಾಮಿ, ಅದರಲ್ಲಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇದೆ ಸ್ವಾಮಿ, kindly.
ಏನಂತ?
Statement.
ಕರೆಕ್ಟ್, ಈಗ ಹೆಂಗ್ ನಾವು ಡಿಸೈಡ್ ಮಾಡೋದು ಈಗ ಬೇಕು ಇದೆಲ್ಲ ಇಟ್ ರಿಕ್ವೈರ್ಸ್ ಕನ್ಸಿಡರೇಷನ್.
Entry order my lordship.
ಹೇಳು ನೋಡು,
No, my lord.
ಅಲ್ಲಿ ಕೊಟ್ಟಿಲ್ಲಲ್ಲ, ಅಲ್ಲಿ ಡಿಸ್ಮಿಸ್
ಅಲ್ಲಿ
ಆಗಿದೆ,
dismiss, please dismiss ಆಗಿದೆ ನೋಡಿ.
ಅಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇತ್ತಾ?
ಅಲ್ಲಿ entry ಮಾಡಿರಿ.
ಹಾ.
My lord, a prisoner who was convicted for life imprisonment was found to be outside the lockup, my lord. Barricade.
Kind my lordship, page number
And my lord,
21.
they were possessing of,
FIR statement my lordship.
they can
The A1
substantiate, my lord.
A1 statements kindly my lordship.
AT has passed a detail.
A1 ಸುದರ್ಶನ್ ಮೋಡನ್ ಈತನ್ ತನ್ನ ಹೇಳಿಕೆಯಲ್ಲಿ ದಿನಾಂಕ 23
MFSC case is made out, my lord.
my lordship.
ನೋಡೋಣ, ನೀವು ನೋಟಿಸ್ ಮಾಡ್ಕೊಳ್ಳಿ,
Please.
ನೋಟ್ ಮಾಡ್ಕೊಂಡು ನೋಡೋಣ. ಬರ್ಕೊಳ್ಳಿ, ಇಶ್ಯೂ emergent notice. Learned AG is requested to accept notice for respondents. Call in the third week of January 2025. First.
16
ಬೇಡ,
months.
ಅದು 16, yes,
See.
16.
Obliged.
ಇದ್ರ ಜೊತೆ ಮಾಡೋದು ಬೇಡ, ಇನ್ನೊಂದು ಅಮ್ಮಲ್ಲಿ ಜೈಲದು ಏನಿದೆ. ಹಾ. Yes.
May I please?
Yes, sir.
There are two office objections, my lord.
Ah.
One is that I have not made Tahsildar as a part.
ಅವ್ನು ಮಾಡ್ಬಿಡಿ.
ಮಾಡ್ತೇನೆ, but this property
Ah.
is within the limits of corporation next to railway station. Tahsildar has nothing to do.
ನಥಿಂಗ್ ಟು ಡೂ ವಿತ್ ದಟ್ ಅಂತನಾ?
That is
ಬಟ್
what.
ರಿಪೋರ್ಟ್ ಗಿಪೋರ್ಟ್ ಏನಾರ ಕೊಟ್ಟಿದ್ರ ಅವರು?
ಇಲ್ಲ, ಏನು ಕೊಟ್ಟಿಲ್ಲ ಅವರು.
ಏನು ಕೊಟ್ಟಿಲ್ಲ.
It is only BBMP which is coming into it. And the second objection.
ಅದು ಇಸ್ ಇಟ್ ರೆವೆನ್ಯೂ ಲ್ಯಾಂಡ್?
No,
It's not a revenue land also.
urban land next to railway station.
No, urban land also can be a
Oh,
revenue.
it can be.
There is a Bangalore village.
I am not saying that. Anyhow, it is not a revenue land. Plans are sanctioned by the BBMP. And construction was made about 5-6 years ago. And the BBMP itself says there is no encroachment on the road.
ಎಲ್ಲಿದೆ?
I invite my lord's attention to and page 82, my lord, annexure H. This is given by the assistant executive engineer, who is the present complainant. Kindly see the last 2-3 sentences from page 83. ಇರುವುದು ನಮೂದಿಸಲಾಗಿದೆ. ಆದ್ದರಿಂದ ಪಶ್ಚಿಮದಲ್ಲಿ ರಸ್ತೆಯಲ್ಲಿ ಯಾವುದೇ ಒತ್ತುವರಿ ಆಗಿರುವುದು ಬಂದಿರುವುದಿಲ್ಲ. ಈ ಎಲ್ಲ ಅಂಶಗಳನ್ನು ತಮ್ಮ ಅವಗಾಹನೆಗೆ ಹಾಗೂ ಮುಂದಿನ ಸೂಕ್ತ ಕ್ರಮಕ್ಕಾಗಿ ಸಲ್ಲಿಸಲಾಗಿ ಸದರಿ ಪ್ರಕರಣವನ್ನು ಕೈ ಬಿಡಲು ಈ ಮೂಲಕ ಕೋರಲಾಗಿದೆ
ಅಂತ ಇವ್ರು ರಿಪೋರ್ಟ್ ಕೊಡ್ತಾರೆ ಕೋರ್ಟಿಗೆ.
ಅದಾದ್ಮೇಲೆ
ಕೋರ್ಟಿಗೆ ಈ ರಿಪೋರ್ಟ್ ಯಾರಿಗೆ ಕೊಟ್ರು? ಇದನ್ನ ಯಾರು ಕೊಟ್ರು ಅಂತ ಗೊತ್ತಿಲ್ಲ. ಸಹಾಯಕ ಕಾರ್ಯಪಾಲಕ ಅಭಿಯಂತರರು ಕೊಟ್ರು. ಯಾರಿಗೆ ಕೊಟ್ರು?
ಶಿವಕುಮಾರ್ PSI BMT ಆಫ್ BMTF police ಠಾಣೆ.
And now on the present complaint is by the very same engineer, stating that there is encroachment. But first of all, my lord, on the northern side, there is no road. They say encroachment on the northern side of the road of my property, but my property hasn't got a road on the northern side, which is indicated in the sale deed under which I have purchased the property. I have also produced the sale deed, my lord. Annexure A. My lord finds it in the schedule of this sale deed on page, my lord, 35. Road is on the western side, not on, not.
ಅದು
on the-
ನೀವು ಬರ್ಕೊಂಡಿದ್ದು.
ಅಲ್ಲ, ಇದು sale deed.
Sale deed is a private document. Anything can be written.
Anyhow, this is all
Public document ಏನಂತ ಇದೆ ಇದ್ರ ಬಗ್ಗೆ.
public document. His own report, there is no encroachment on the road.
No, but subsequently he said he himself has lodged the complaint. It is not that the first complaint, first report is gospel.
Yes. All this is,
Produce it,
all this-
ಯಾವ stage ಇದೆ matter?
all this
This is
is,
also rejection of HVC.
all this is,
HVC ಆದ್ಮೇಲೆ.
2 suits are pending where injunction order is in my favor.
But they are not parties.
They are not.
ಹಾ,
I understand.
ನೀವಿಬ್ರು
But
ಏನಾರ suit
therefore,
ಹಾಕೊಂಡು ಏನೋ ಒಂದ್ ಮಾಡ್ಕೊಂಡ್ರೆ
He has,
ಅದ್ನೇ
the complainant, my lord, is the one, is the neighbor, not actually engineer. It is through him, he is doing all this from last about 10 years, ever since I have purchased the property, and now it's a residential complex, already completed 5 years ago, not allowing the customers to buy it because of this man stating that litigation is pending before this court, that court, and all other courts. It is all at the instance of the neighbor. And this honorable court, my lord, recently he filed a writ petition before this honorable court. My lord finds the order, just a minute. The order of this honorable court, my lord, on the writ petition on page 107, my lord.
So ಅಶೋಕ್ ಕಿಣಿಗಿ ಸಾಹೇಬರ್ದು.
Civil suits are all pending. Kindly see the last portion of the order, my lord. The same person, that is a neighbor who files it. He says, in view of the same, as the suits are pending before the civil court without expressing any opinion on the merits, the petitioner has not made out a ground to entertain the writ petition.
Till next date, don't precipitate the matter.
You
It
are not
requires
in a party.
examination.
Now, presently you are not in a party.
Huh?
Tahsildar is not in a party.
Complaint ಹಾಕಿದ್ದಾರೆ.
Complaint.
Complaint,
Assistant Executive Engineer, BBMP has filed it. Why Tahsildar should be made a party?
He is not made a party here.
ಅದು the officer ಹತ್ತು ಹೇಳ್ತಾರೆ ಅದನ್ನ ಬಿಡಿ. Why they should be made a party? Office objection as to non-implement of, non-arraying of the Tahsildar being unsustainable is overruled.
the second
Issue
one,
emergent notice. Learned AG is requested to accept notice. State house officer, station house officer ಇಲ್ವಾ?
Station house officer. is still-
BMTF ಇದ್ರು, ಸ್ಟೇಷನ್ ಹೌಸ್ ಆಫೀಸರ್ ಇದ್ರೆ ನೀವೇ ಅಪೀರ್ ಆಗ್ತೀರಿ. ಅದೇ ಇಶ್ಯೂ
BBMP
ಎಮರ್ಜೆಂಟ್
ಪರ.
ನೋಟಿಸ್.
BBMP ಗೆ appear.
ಅಲ್ಲ, ಇದು ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ನೀವೇ ಅಪೀರ್ ಆಗ್ತೀರಿ.
ಅದೇ BMTF,
BMTF
BMTF ಗೆ ನೀವೇ ತಾನೆ.
Please.
ಯಾಕಂದ್ರೆ it is held to be police station. Learned AG is request to accept notice for response number 1. ಇವರು ಯಾರಾದ್ರೂ Sri PS Karthikeyan, Learned Panel Council is requested to accept notice for second respondent. Till next date of hearing, the proceeding pending before the special court in case number LGCT, criminal number 310 of 2023 shall not be precipitated. Call in the third week of January 2025.
Him to supply one copy.
Eh?
Supply one copy to the court.
I'll immediately.
ಅವ್ರಿಗೆ ಕಾಪಿ ಕೊಡಿ.
He put the copy. Great.
Yes.
Lords, I appear for the petitioner's counsel, my lords, we
Yes.
question the seniority list principally on the ground that 324 posts which were added to the cadre strength by the amendment to the cadre and recruitment rules have not been taken into account for working out the quota.
May make one submission.
Not taken into account.
That's may
Not
make
taken
one
into
submission.
account at all. Annexure A2, my lords,
The order is of the year 2022, my lords. On
Huh?
13, on the order of the tribunal is 39/22, my lords. I had filed caveat then, my lords. The caveat has expired. I may be permitted to file wakalat for 4 of the
Notice
respondents. Please, my lords.
ಕೇಳೋ ಸ್ಟ್ರೆಂತ್ ಆಡ್ ಆಗಿದ್ದು ಕೌಂಟ್ ಮಾಡ್ಲಿದ್ರೆ ಹೆಂಗ್ ಸೀನಿಯಾರಿಟಿ ಮಾಡ್ಲಿಕ್ಕೆ ಮಿನಿಮಮ್. What the tribunal says about that?
Tribunal says, my lords, the posts created between 57 and 84 have been taken into account whenever the posts were created. And the posts create agidde by annexure A2 in the year 1987. They simply say, my lords, that government has said so and we accept it. There is no application of mind on that aspect, my lords. The finding of the tribunal on that aspect is at page 89, para 31.
Requires consideration covered by judgment ಆಗ್ತದೆ.
My lords, that has been taken note of and subsequently pursuant to the order. They have implemented the order this month.
They have not implemented.
The
Anyway,
They-
notice ಮಾಡ್ಲಿಕ್ಕೆ ಏನ್ ತೊಂದ್ರೆ?
Notice.
It requires consideration for correct. Issue emergent notice. Learned
Correspond.
ಅಷ್ಟೇ ಪಾಯಿಂಟ್ ಮೇಲೆ ಇದೆ, ಬೇರೆ ಏನು ಉಳಿದೇನು ಸಂಬಂಧ ಪಡಲ್ಲ ಅನಿಸ್ತದೆ ಅಲ್ವಾ?
ಇನ್ನೊಂದು
ಪ್ರಶ್ನೆ ಬರೋದಿಲ್ಲ.
there are two other issues, that is the subsequently.
Okay.
One,
Issue
two, my lord.
emergent notice,
One.
learned AG requested to accept notice for
1 and 2, my lord.
1 and 2.
Yes.
My lord, sir, notice to 39 and onwards may be dispensed with respondents because they are also promotees sailing in the same boat.
Notice to
39 to 57.
notice to respond numbers 39 to 57 is dispensed with for the time being on the submission of learned senior advocate appearing for the petitioners, on the ground that they too sail with the cause of the petitioners.
Four ಹೋಗ್ಬೇಕಲ್ಲ?
Shri
Aditya Chakradagiri.
Aditya
R Chakradagiri.
Shri so and so accepts notice for
3567, my lords.
3567. Emergent notice to the rest. Okay,
That
next. Debenture transfer issue. Short point ಏನಂತಂದ್ರೆ, they say that the transfer is made, it's made within about 7 months. But they say the reason it is made is, one, there is a disciplinary inquiry pending. Disciplinary inquiry ಏನಾಯ್ತು, it appears to be targeted. The reason is, about 30 districts ನಲ್ಲಿ, he is a deputy director of planning. The
Director of?
Planning in child welfare department. ಈ milk powder supply ಮಾಡ್ತಾರೆ KMF ಇಂದ. They supply milk powder. After the supplies are made, the director has to issue a check to the KMF to give this money, disperse this money. Usually there is some time lag in giving this money. It happens in the government. A general notice was issued against all deputy directors of 30 districts. Now that is taken as a ground to transfer. This is how they have done it. This is one reason. Second reason, Lord, they say is, Adam Lord, either where you have taken up that ground? Lord, this is a in your application, where have you taken up that ground? ಅಲ್ಲ ಅದನ್ನ ಹೇಳಿಲ್ಲ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲಿ, ಬಟ್ ದಟ್ಸ್ ದ ಸಿಚುವೇಶನ್. ಜನರಲ್ ಇಟ್ಸ್ ಅ ಜನರಲ್ ಅದ್ರ ಮೇಲೆ ಟ್ರೀಟ್ ಮಾಡಿರ್ತಾರೆ ಟ್ರೈಬ್ಯುನಲ್. ಒಂದು ಇನ್ನೊಂದು ರೀಸನ್ ಏನ್ ಮಾಡಿದ್ದಾರೆ ಅಂದ್ರೆ, ಅನದರ್ ರೀಸನ್ ವಾಟ್ ದೇ ಹ್ಯಾವ್ ಸ್ಟೇಟೆಡ್ ಇಸ್, ಅಂದ್ರೆ ಟ್ರೀಟ್ ಪಿಟಿಷನ್ ದಲ್ಲಿ ಎಲ್ಲಿ ಹೇಳಿರಿ? ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಹೇಳಿದ್ದೀನಿ, ಬಿಕಾಸ್ ದೇರ್ ಇಸ್ ಅ ಎನ್ಕ್ವೈರಿ ಪೆಂಡಿಂಗ್, ದೇ ಹ್ಯಾವ್ ಟ್ರೈ ಟು ಡೂ ಇಟ್ ಅಂತ. ಬಟ್ ಆಕ್ಚುಲಿ ಇಟ್ ವಾಸ್ ಅ ಈ ಕೈಂಡ್ಲಿ ಸಿ ದ ಟ್ರಾನ್ಸ್ಫರ್ ಆರ್ಡರ್. ಆಮೇಲೆ ಇನ್ನೊಂದು ರೀಸನ್ ಹೇಳಿದ್ದಾರೆ. ಸೆಕೆಂಡ್ ರೀಸನ್ ದೇ ಸೇ ಇಸ್, there is an allegation that kindly see annexure A, one second. Kindly see annexure page 42, annexure A3. ಕಾರಣ ಕೇಳುವ ನೋಟಿಸ್. Page 40, annexure A3. ಉಲ್ಲೇಖ 42.
ಸರ್ಕಾರದ I'll just read the ಉಲ್ಲೇಖ ಮಾಡಿ. ಸರ್ಕಾರದ ಕಾರ್ಯದರ್ಶಿಗಳು ಮಹಿಳಾ ಮತ್ತು ಮಕ್ಕಳ ಅಭಿವೃದ್ಧಿ ಹಾಗೂ ವಿಕಲಚೇತನ ಮತ್ತು ಹಿರಿಯ ನಾಗರಿಕ ಸಬಲೀಕರಣ ಇಲಾಖೆ ಬೆಂಗಳೂರು ಇವರ ಪತ್ರ. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಕ್ಷೀರಭಾಗ್ಯ ಮತ್ತು ಮಾತೃಪೂರ್ಣ ಯೋಜನೆಯ ಲೆಕ್ಕ ಶೀರ್ಷಿಕೆ ಅನುದಾನವನ್ನು ಈಗಾಗಲೇ ರಾಜ್ಯ ಸರ್ಕಾರದಿಂದ ತಮ್ಮ ಜಿಲ್ಲೆಗೆ ಬಿಡುಗಡೆಗೊಳಿಸಿದ್ದು, ಸದರಿ ಲೆಕ್ಕ ಶೀರ್ಷಿಕೆಯ ಬಿಡುಗಡೆಯಾದ ಅನುದಾನದಲ್ಲಿ ಕೆನೆದರಿತ ಹಾಲಿನ ಪುಡಿ ಬಾಕಿ ಮೊತ್ತವನ್ನು ಆದ್ಯತೆಯ ಮೇರೆಗೆ ನಿಯಮಾನುಸಾರ KMF ಸಂಸ್ಥೆಯವರಿಗೆ ಪಾವತಿಸಲು ಈಗಾಗಲೇ ಸರ್ಕಾರದ ಕಾರ್ಯದರ್ಶಿಗಳ ಅಧ್ಯಕ್ಷತೆಯಲ್ಲಿ ನಡೆದ ಸಭೆಯಲ್ಲಿ ತಿಳಿಸಲಾಗಿದ್ದು ಸಹ 8.7 ಕೋಟಿ ಮೊತ್ತದ ಗಳನ್ನು KMF ಪಾವತಿಸಿಲ್ಲವೆಂದು ಆರೋಪ ಮಾಡಿರಲಾಗಿತ್ತು. ಈ ಸಂಬಂಧ ಅಂದ್ರೆ ನಾನೇನ್ ತಗೊಂಡಿಲ್ಲ ಅದನ್ನ, ನೀವು ಅದನ್ನ ಆ ಅಕೌಂಟ್ ಇಂದ ಆ ಅಕೌಂಟ್ ಬರ್ಸಿಲ್ಲ ಅಂತ.
ಮೈಸೂರು ಜಿಲ್ಲೆಯ ಶಿಶು
ಆಮೇಲೆ ಆರೋಪ 1 ಕೈಂಡ್ಲಿ ಸೀಮ್ ಲಾಟ್ ಇಟ್ ಅಪಿಯರ್ಸ್ ಟು ಬಿ ಕಾನ್ಕಾಕ್ಟೆಡ್ ಅಂದ್ರೆ ಇಟ್ ಅಪಿಯರ್ಸ್ ಟು ಬಿ ಟಾರ್ಗೆಟೆಡ್. KMF ಸಂಸ್ಥೆಗೆ ಮೈಸೂರು ಜಿಲ್ಲೆಯಿಂದ ಹಾಲಿನ ಪುಡಿ ಸರಬರಾಜು ಒಟ್ಟು ಬಾಬ್ತು 8 ಕೋಟಿಗಳಷ್ಟು ಬಾಕಿ ಉಳಿಸಿಕೊಂಡಿರುವುದು. ಸದರಿ ಲೆಕ್ಕ ಸದರಿ ಲೆಕ್ಕ ಶೀರ್ಷಿಕೆಯಡಿ ಸರ್ಕಾರ ಆದೇಶ ಉಲ್ಲಂಘಿಸಿ ನಿಯಮ ಬಾಹಿರವಾಗಿ ವೆಚ್ಚ ಭರಿಸಲಾಗಿದೆ. ಆಮೇಲೆ ಸದರಿ ಲೆಕ್ಕ ಶೀರ್ಷಿಕೆಯಡಿ ಆಹಾರ ಸಾಮಗ್ರಿಗಳಿಗೆ ಪಾವತಿಸಲಾಗಿದೆ.
ನಿಮ್ಮ ಸ್ಟೇಟ್ಮೆಂಟ್ ಫಸ್ಟ್ ಚಾರ್ಜ್ ಯು ಹ್ಯಾವ್ ರೆಡ್ ನೌ.
Yes,
ವಾಟ್ ಈಸ್ ಯುವರ್ ರಿಪ್ಲೈ ಟು ದಟ್?
ನಾನು ರಿಪ್ಲೈ ಕೊಟ್ಟಿದ್ದೀನಿ.
ಮೈಸೂರು ಜಿಲ್ಲೆಯ ಶಿಶು
I have given a reply that is almost the 4 months back. I have given a reply. Reply is reply. And after the reply, no further action is taken. They have accepted the reply virtually. They have virtually accepted the reply. But all these objections are taken only for the purposes of taking a reason to transfer me. Reply. And they have virtually accepted my reply. ಆಮೇಲೆ ಇದಾದ್ಮೇಲೆ
ಐಟಮ್ ನಂಬರ್ 4 at page 43.
ಪ್ಲೀಸ್
ಓದಿ. ವರ್ಷಾಂತ್ಯದಲ್ಲಿ
ಈ ಲೆಕ್ಕ ಶೀರ್ಷಿಕೆಯಡಿ ಬೇಡಿಕೆಗೆ ಅನುಗುಣವಾಗಿ ತಾಲೂಕುವಾರು ಯೋಜನೆವಾರು ಅನುದಾನ ಮರುಹಂಚಿಕೆ
ಪ್ರಸ್ತಾವನೆಯನ್ನು ಸಲ್ಲಿಸಲು ವಿಫಲವಾಗಿರುವುದು. ಉತ್ತರ
ಇದರಿಂದ
ನೋಡಿ.
ರಾಜ್ಯ ವಲಯದ ಯೋಜನೆಗಳ ವೆಚ್ಚಕ್ಕಾಗಿ ಅನುದಾನ ಕೊರತೆ ಉಂಟಾಗುತ್ತೆ ಎಂದು ಆರೋಪ ಮಾಡಲಾಗಿದೆ.
ರಿಪ್ಲೈ ನೋಡಿ.
ರಿಪ್ಲೈ ಕನ್ಸಿಡರ್ ಮಾಡಿದೆ. 2023-24 ಕರಡು ವಾರ್ಷಿಕ ಆಯವ್ಯಯ ಬೇಡಿಕೆ ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ಸದರಿ ಲೆಕ್ಕ ಶೀರ್ಷಿಕೆ 2235 ರಡಿ 3439.67 ಲಕ್ಷಗಳಿಗೆ ಬೇಡಿಕೆ
ಲಕ್ಷ ಬೇಡಿಕೆ ಸಲ್ಲಿಸಲಾಗಿರುತ್ತದೆ.
ರು 918.78 ಲಕ್ಷ ಅನುದಾನವನ್ನು
ಬಿಡುಗಡೆಯಾಗಿದ್ದು
ಬೇಡಿಕೆ ಸಲ್ಲಿಸಲಾಗಿದ್ದು ಹೆಚ್ಚುವರಿ ಅನುದಾನ ಬಿಡುಗಡೆ ಆಗಿರುವುದಿಲ್ಲ.
ಪ್ರಸ್ತಾವನೆ ಸಲ್ಲಿಸೇನೆ ಅಂತ ಹೇಳ್ತಾರೆ.
Not only this, he is misbehaved with the lady staff by misusing his official power. He is misusing his official power. He is misbehaving with the lady staff.
There is no
That is
notice.
also an allegation, my lord.
ಎಲ್ಲಿದೆ ಅದು?
We kindly see the impugned order, my lord.
ನೋಟಿಸ್
Page 7, my lord. Page 7 of the impugned order.
ಅಲ್ಲ, ಇದು ದಿಸ್ ಇಸ್ ಅ ಡಿಸಿಪ್ಲಿನರಿ.
This is one thing, my lordship. Counter claim and counter claim is there, my lordship, as per the Ashok Kumar Agarwal judgment. That is a matter of my lordship evidence.
ಅಲ್ಲ, ಲೇಡಿ ಜೊತೆ ಮಿಸ್ಬಿಹೇವ್ ಮಾಡ್ಯಾರ ಅಂದ್ರೆ ಎಲ್ಲಿದೆ?
Page 7 impugned order.
Page 7 of impugned order.
Please.
Annexure
22.
page number 20. Sorry.
Page number
Page number 22. Continue.
22.
No, in the transfer order they mentioned lot.
ಎಲ್ಲಿದೆ ಟ್ರಾನ್ಸ್ಫರ್ ಆರ್ಡರ್?
Transfer order is at page annexure A5 page 52.
52.
Yes, 23/7/24. There they say in the bottom notes, I am transferred. They say ಕ್ರಮ ಸಂಖ್ಯೆ 1 ವರ್ಗಾವಣೆ ಸಂಬಂಧಿಸಿದಂತೆ ಶ್ರೀ HR ಸುರೇಶ್ ಅವರ ವಿರುದ್ಧ ಸಾರ್ವಜನಿಕರಿಂದ ಬಹಳಷ್ಟು ದೂರುಗಳು ಹಾಗೂ ಮಹಿಳೆಯರೊಂದಿಗೆ ಅಸಭ್ಯ ವರ್ತನೆ ಕುರಿತಾಗಿ ಹಲವು ದೂರುಗಳು ಸ್ವೀಕೃತವಾಗಿದೆ. ಅದರ ಮೇಲೆ ಯಾವುದೂ ನೋಟಿಸ್ ಕೊಟ್ಟಿಲ್ಲ.
ನಿಮ್ ಫೈಲ್ ತೋರಿಸಿ, ಯಾವ ಮಹಿಳೆಯರಿಂದ ಯಾರಿಂದ ಕಂಪ್ಲೇಂಟ್ ಬಂದದೆ ಅಂತ ತೋರಿಸಿ.
File I will get it.
Government issue notice.
Yes.
Learned AGA is requested to accept notice for respondents 1 and 2. 1, 2 and 3 ಏನೋ ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ ಬರ್ತೀರನಾ?
ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ ನಂಬರ್
1 and 2. Issue emergent notice to respondents 3 and 4. Learned AGA is requested to produce. That's what.
for 2024 serial number 8 ಇಲ್ಲಿ
ಇದು ಗವರ್ಮೆಂಟ್ ಇದೆ ತಾನೇ ಫೈಲ್
ಇದೆ.
ಪ್ರೊಡ್ಯೂಸ್ ದ ಫೈಲ್ at 2:30 ಟುಡೇ. ಆ ಫೈಲ್ ತರಿಸಿ ನಾವು ನೋಡ್ತೀವಿ ಯಾವ ಲೇಡೀಸು ಆ ರೀತಿ ಮಿಸ್ಬಿಹೇವ್ ಮಾಡ್ಯಾನೆ ಅನ್ನೋ ಬಗ್ಗೆ ಯಾರು ಹೇಳಿದಾರೆ.
ಡೆಪ್ಟಿ ಡೈರೆಕ್ಟರ್ ಪ್ಲಾನಿಂಗ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್
ತರಿಸಿ 2:30 ಬನ್ನಿ.
ಎಸ್ ಬಟ್ ಕೆನ್ ಬಿ ನಾಳೆ
ನಾಳೆ ಬೆಂಚ್ ಇರಲ್ಲ.
ಆಯ್ತು 2:30 ನೆಕ್ಸ್ಟ್ 2:30 ಪ್ಲೀಸ್
ಲೇಡಿ ಜೊತೆ
ಆಯ್ತು.
ಮಾಡೋರ್ನೆಲ್ಲ ಇಲ್ಲಿ ಇಟ್ಕೊಂಡ್ರೆ ಕೆಲಸ ಮಾಡಕ್ಕಾಗಲ್ಲ ಅವ್ರನ್ನ.
ಆಯ್ತು ನಾಳೆ ಸಾರಿ ಇವತ್ತೇ 2:30
ಇವತ್ತೇ 2:30.
ಎಸ್ ಬಟ್ 9 ಆಲ್ಸೋ 8 is also connected
8 and 9
8 and 9 connected
ಸೇಮ್ ಆರ್ಡರ್.
please
ಅಂತ ತರಿಸಿ 2:30 ತರಿಸ್ಬೇಕು. ಆರ್ಡರ್ ನಂಬರ್ ಕೊಡಬೇಕು. ಕಾಪಿ ಆಫ್ ದಿಸ್ ಆರ್ಡರ್ ಟು ಬಿ ಶೇರ್ಡ್ ವಿತ್ ದಿ ಲರ್ನೆಡ್ AGA. ಎಸ್.
And for the petitioner's minute is regarding reversion minutes, lordships. Similar.
Technical matters.
Please, madam.
It is not an identity murder. They are not the parties. Murder kindly see murder. The order passed by this 200 tribunal murder. Against the order murder, annexure A7 murder 146 before the KAT. Same order, there is no doubt. But I agree with that murder. But your lordship kindly see. Against the-
Immediately after vacation. Immediately after vacation.
Otherwise they will revert me.
ಯಾವಾಗ?
No, murder. There is murder kindly see murder. The
ಅವ್ರು ಕೇಳಿ ರಿವರ್ಟ್ ಮಾಡಿ ನಿಮ್ಗೆ ಹೆಂಗ್ ಗೊತ್ತಾಗ?
Alla reversion.
Appear for whom?
But I filed an application for
You
implementing
private
application before the KAT. But what happened to Supreme Court? But your lordship.
Do you revert him?
But the order has been passed. But your lordship annexure.
That is their apprehension.
But
If
there
you
is a
say, then we'll tell him. Don't
Alla-
have that impression.
contempt, we have filed a contempt before the tribunal. But the order was challenged before this tribunal. There was an interim order stay granted. Thereafter interim order came to be vacated. But your lordship, that again the same petition was approached before the tribunal. Copy. Sorry. Same petition approached this on the tribunal. Stay initially granted, thereafter stay was vacated. But the Supreme Court has said, but your lordship.
Anyway, reversion till vacation ಮುಗಿಯೋರಿಗೆ reversion
ಅಲ್ಲಿ ಕಂಟೆಂಪ್ಟ್ ನಮಗೆ ಪ್ರಮೋಷನ್ ಕೊಡ್ಬೇಕು ಅಂತ ಆರ್ಡರ್ ಮಾಡಿದ್ವಿ ನಾವು
ಬರ್ಕೊಳ್ಳಿ.
There are vacancies.
AGA requested to
but
accept
the
notice
date
for
of
this.
eligibility only
The petitioner shall not be reverted
Trainee officers
Till-
too.
next date of hearing. Call this matter immediately after court vacation.
but your lordship for a moment mado Supreme Court has said mado your lordship no mado your lordship mado page number 180 mado same matter
produce
went
it.
up to Supreme Court mado
Huh?
before the KAT mado the page number 180 mado Supreme Court judgment is mado annexure A8 mado before the KAT mado
No, page number
1
206.
206
206 minute. We have produced the.
relevant page is page last but one parameter.
ಏನಂತ ಹೇಳ್ತದೆ?
But therefore, may I read that last one parameter of that
Number?
Relevant page over 214 minutes.
214. Therefore,
214.
yes,
Please minutes.
therefore, got it.
Last paragraph.
Therefore, some of them
Some of them had
had filed an original application and thereafter approached the High Court, wherein some interim orders were passed contrary to the spirit of the order of this court dated 28/9/2012. This fact makes it clear that despite striking down of the 1998 rule, which extended the benefit of the transfer to the promotion post to training officer and cadres below to the extent of 33 1/3%, certain employees were promoted under the garb of 1998 rule and they are continuing on the promotion post. In the said background, we have heard the learned counsel appearing on behalf of the parties at length, including the learned senior counsel appearing for the interviewer. After hearing and on perusal of the provisions which are under challenge and the reasoning as given by the tribunal and the High Court in detail, particularly in para 18, 19 and 19, we are in complete agreement with the same. Therefore, the appeals are devoid of any merit and hence dismissed. As far as the employees were wrongly promoted and were given financial
Which class he
benefit.
will fall?
Yes, financial benefit. Yes, but he is, yes, madam.
Ah.
He is also, before the Supreme Court, he also challenged that. the financial benefit, that is left to the government as far as the financial benefit is concerned.
Correct, which order comes in the way?
But now, pursuant to the order of the Honorable Supreme Court and the order of the tribunal, but the annexure A8 came to be, which is under challenge, impugned order before the tribunal, that has been passed.
Correct. With kindly read where the Supreme Court order comes for issuing interim order.
But the reversion,
Government has to take the decision.
they have taken decision.
Government has taken the decision.
Yes, madam.
That is being challenged.
Yes, madam.
That challenge failed there.
Yes, madam.
Therefore, he is here. So till 2 weeks nalli ಏನಾಗ್ತದೆ? Where is the violation of the interim order of the apex court? Apex court gave liberty to the government to do or not to.
Financial, only financial benefit.
No.
Only financial.
Done or
Only
consent
financial.
shall be open for state government to take a decision with respect to such benefits and pass appropriate orders. Only financial benefits.
Yes, madam, exactly.
This is in relation.
Therefore,
Right.
madam, they have not been.
This is in relation to the promotions made after the rules were struck down, my lord.
Correct.
Now, we were promoted before the rules were struck down, my lords. We were promoted during 2003 and 2006, my lords.
No, brother.
Please, my
Kindly-
lords.
Kindly complete. This one is clear. That despite striking down the 98 rules, which extended the benefit of transfer to the promotional post to training officers and cadres below to the extent that an employee is this is post striking down. of
Please,
the
my lords.
rules.
Please, my lords.
But, madam, then, madam, we filed an application before this tribunal.
The
Tribunal
matter
allowed.
was,
Madam, that is what, madam, challenge before this court.
strike down ಆದ್ಮೇಲೆ promote ಮಾಡ್ಯಾರ ಇವ್ರು.
ಮಾಡಿದ್ದಾರೆ.
Illa, illa.
ಮಾಡಿದ್ದಾರೆ.
Pending, madam, that was a pending, which struck down the rules which are challenged before the tribunal. During that period, madam, they have been promoted. Ultimately, rules were struck down. That is why, madam, the interim order was granted to the Supreme Court only to the TOs who are directly promoted. Your Honor, kindly see.
ಒಂದ್ ಸೆಂಟೆನ್ಸ್ ಆದ್ಮೇಲೆ ನಿಲ್ಬೇಕು ಅಂದ್ರೆ ಅಸೆಸ್ ಮಾಡ್ಬೇಕಲ್ಲ.
Sorry,
You
madam.
want
Sorry,
that
madam.
we should not consider anything at all.
Sorry, madam.
ಇಲ್ಲಿ ಒಂದ್ ನಿಮಿಷ ನಿಧಾನವಾಗಿ ಉತ್ತರ ಕೊಡಿ. ಇವ್ರ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಇನ್ 2003 ಆಗಿದೆ ಕರೆಕ್ಟಾ?
Please.
No, madam, they were,
3.
3 and 6.
3 and 6.
madam, that is to,
Please, my lord.
that is to, madam, your Honor, that is why, madam, Honorable.
ನಾವು ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಿಕ್ಕೆ ನಿಮ್ಮ ಫಾಸ್ಟೆಸ್ಟ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಅನ್ನು
Sorry, sorry, madam.
ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ದಟ್.
Madam, that is protection was granted by the Honorable Supreme Court.
ನಾವ್ ಇನ್ನೂ ಹೇಳಿಲ್ಲ. ನಾವು ಅರ್ಥ ಮಾಡಿಕೊಂಡಿದ್ದು ನಿಮ್ಗೆ ಹೇಳ್ತಾರೆ.
Sorry, sir.
ಅದು ಹಿಯರಿಂಗ್ ಅಂದ್ರೆ ನಮ್ಮ ಮನಸ್ಸಿನಲ್ಲಿ ಏನಾಗ್ತಾ ಇದೆ, ನಿಮ್ಮ ಮನಸ್ಸಿನಲ್ಲಿ ಏನಾಗ್ತಾ ಇದೆ, ಎರಡು ಅಡ್ಡಿಡಿಯಂ ಬರ್ತಾ ಇದೆಯಾ, ಅದು ಹಿಯರಿಂಗ್ ಅಲ್ವಾ? ಈಗ ನಾವು ನಿಮ್ಗೆ ಕೇಳ್ತಾ ಇದ್ವಿ, ಇವರನ್ನ ಪ್ರಮೋಟ್ ಮಾಡಿದಾಗ, ಅಪಾಯಿಂಟ್ ಮಾಡಿದಾಗ ಆ ರೂಲ್ಸ್ ವೇರ್ ದೇರ್, ಕರೆಕ್ಟಾ?
Yes, madam.
Subsequently rules were struck down. ಅದು ಕರೆಕ್ಟಾ?
True, my lord.
Yes, madam.
ಇಲ್ಲ.
True, my lord.
ಕರೆಕ್ಟ್. ಆ ಸ್ಟ್ರೈಕ್ ಡೌನ್ ಆದ್ಮೇಲೆ ಗವರ್ಮೆಂಟ್ ಅಗೇನ್ ಪ್ರೊಮೋಟೆಡ್ ದ ಪೀಪಲ್ ಬೇಸ್ಡ್ ಅಪಾನ್ ಸ್ಟ್ರೈಕ್ ಡೌನ್ ರೂಲ್ಸ್.
No, no, no.
ಇದಲ್ಲ.
ಇಲ್ಲ,
ಆ ಕೇಸ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಮುಂದಿತ್ತು.
ಇಲ್ಲ, ಇಲ್ಲ, ಇಲ್ಲ. Rules struck down ಮಾಡಿ, madam, rules were framed in 98. That was challenged before the KAT. KAT struck down that rule. Then matter went to High Court. High Court, there was an interim order, protection was granted, not to revert them. Then, madam, High Court ultimately upheld the order of the tribunal. Against that order, Supreme Court SLP was filed. In the SLP, there was an interim order stating that promotion that is produced as an actually A6 before the
A6.
A6. Page in my KAT, before the KAT, page 144. It's a page in A6. Before the KAT, actually A6.
142.
Yes, madam. Prima facie, we are of the opinion that even though there can be no justification for carving out a quota for degree holders in the two cadres below the cadre of training officer, there would be no impediment in creating the quota within the same cadre. Issue notice restricted to the question as to whether the quota provided by the management under the Karnataka Employment and Training Service Recruitment Rules 98 would be protected so far as the certain number of posts to the degree holders within the same cadre. All these persons who are degree holders in the feeder cadre of the training officer shall not be reverted in the meantime. Therefore, madam,
Shall
that
not be reverted.
reverted. Yes, madam, that was the protection. Ultimately, that was the SLP was dismissed.
ಅದರಲ್ಲಿ ಇವರೆಲ್ಲಿ ಬರ್ತಾರೆ ಅಂತ?
They are the parties.
He was also party.
Yes, madam. He
You-
was
all are
party.
all are parties, my lord.
Yes,
Huh?
All are parties, my lords. Even the
No, whether you were party.
yes.
Please, my lords.
But then Supreme Court has struck down, rejected your SLP.
Sir, we are not on the fight in respect of that rule, my lords, sir. But we were promoted before that rule was struck down, my lords. That is our grievance before your lords, my lords.
Correct.
And
But afterwards, rules are struck down.
true, my lords, 2008, my lord.
Come to 143. Then what says appears to be true now. 143, page 143 of your paper book.
Please, my lords.
143 dalli
Struck
rule
down.
is struck down.
Please, my lords.
So whatever has been done under the rule also goes. Ex nihilo nihil fit, where the structure falls down,
Please, my lords.
nothing remains.
Please, my lords. But
Party to this.
true, my lords. But as per the order of the Supreme Court, my lords, relevant page 231, my lords.
230, you have read the second part.
Please, my lords. No, my lords.
Huh?
Citation, my lord.
What is the second part? 230,
It starts from
214.
231, my lords.
231,
Please, my lords. The relevant page is 233, my lords.
33.
Para number 5, may I read, my lord.
Prospective.
The prospective declaration of law is a device innovated by the apex court to avoid reopening of settled issues and to prevent multiplicity of proceedings. It is also a device adapted to avoid uncertainty and avoidable litigation. By the very object of prospective declaration of law, it
ಇದು
is
ಯಾವ ಕೇಸ್ನಲ್ಲಿ ಇದೆ?
ಇದು ಬೇರೆ ಕೇಸ್ citation, my lord.
ಇದಕ್ಕೆ ಹೆಂಗ್ ಸಂಬಂಧಪಟ್ಟದ್ದು? This has already Supreme Court itself said, na?
True, my lords, but the Supreme Court says, my lords, regarding the persons who were promoted after the rule was struck down, my lord. Kindly see page number, my lords.
That, see,
Please, my lords.
Supreme Court prospective overruling, etc., everything all right.
Please, my lord.
But that was not applied by the Supreme Court in your case.
My lord, 214 may kindly be seen, my lords. Page number 214.
Ah.
See, as far as the employees, this is decision of the Supreme Court in our case, my lord.
ಎಲ್ಲಿದೆ?
As far as employees who were wrongly promoted, my lord.
Correct.
And who were given financial benefits in pursuance of
98
to
rules.
98 rules which were struck down, my lords.
Are concerned.
Are concerned, my lords, not ours. my lords.
ಓದ್ಬೇಕು. ಮುಂದೆ ಓದ್ಬೇಕು.
It
ಅವ್ರಿಗೆ
shall-
ಏನ್ ಮಾಡ್ಬೇಕು ಅಂತ ಹೇಳಿದೆ
It
Supreme
shall be open to the state government to take a decision with respect to such benefits and pass appropriate orders, my lords.
ಈ ಬೆನಿಫಿಟ್ಸ್ ಇದೆಯಲ್ಲ,
Please, my lords.
ಆ ಅಮೌಂಟ್ ನಿಮ್ಮಿಂದ ರಿಕವರ್ ಮಾಡ್ಕೋಬೇಕು ಬೇಡ ಅನ್ನೋ ಬಗ್ಗೆ
But we were promoted before rules were struck down, my lords.
that arise because of that question arise only when you were promoted before they were struck down.
The-
Once it is struck down, it goes to the first day of incorporation.
True, my lords.
Unless the court which is striking down otherwise says, that's the law.
Please.
ಕೋರ್ಟ್ ಹೇಳ್ಬೇಕು, ಇಲ್ಲಿವರೆಗೆ ಮಾಡಿದ್ದನ್ನ ರಿಟೈನ್ ಮಾಡ್ರಿ, ಇನ್ ಮುಂದೆ ಮಾಡಬೇಡ್ರಿ, ವಿ ಆರ್ ಸ್ಟ್ರೈಕಿಂಗ್ ಡೌನ್ ಅಂತ ಹೇಳಿದ್ರೆ ಅವಾಗ ಮಾತ್ರ ನೀವು ಹೇಳೋದು ಕರೆ. ಅವಾಗ ಪ್ರಾಸ್ಪೆಕ್ಟಿವ್ ನೀವೇನ್ ರೂಲಿಂಗ್ ಸೈಟ್ ಮಾಡಿದ್ರಲ್ಲ,
Please, my lords.
that comes into play. That is not the case here.
But we were promoted during 2003 and 2006, my
ಸರಿ
lords.
ಮಂತ್ರ ಹೇಳ್ದಂಗೆ ಹೇಳಿದ್ರೆ ನಿಮಗೆ were promoted when the rules were still law in operation ಅಂತ. After vacation to call after vacation. Correct ಇದೆ ಅವ್ರು ಹೇಳೋದು. Therefore, he's worried that we are granting entry ಮಾಡೋದು. ಅಲ್ಲಿ ಇನ್ನೊಂದು
It is rejected.
fix ಇದೆ.
It is not granted entry.
Demand ಮಾಡಿದ್ರೆ
ಹಾ.
They work in that post, they are entitled to retain the potential. Right here. That promotion itself should be retained or not. That the government has to take decision on anyway. He cannot be. He can be recorded. ಈ ಬೆನಿಫಿಟ್ ಅನ್ನೋದು ಪ್ರಮೋಷನ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿ ಅನ್ನೋದು ಅದೆಲ್ಲ correct.
May I
Take
request, my
after
lord?
it.
Kindly direct the honorable tribunal members to dispose of the case at the earliest possible time. my
On
lords.
rejection
May be
of
disposed
interim
of.
order, they are here, my lord.
ಬರ್ಕೊಳ್ಳಿ.
It may be disposed of, my lords, in the way that.
Learned counsel appearing for the petitioner having argued the matter now submits that his clients would be happy if the tribunal disposes of the subject application
Please.
as early as possible. First, learned the AGA appearing for the respondents who vehemently opposed the petition, is graciously agreeing with this proposal. First, in the above circumstances, this petition is disposed of, requesting the tribunal to take up petitioner's applications at the earliest, and dispose them of. ಒಂದೇನಾ ಎರಡಿದೆ?
ಒಂದೇ.
Dispose,
ಎರಡಿದೆ, ಇನ್ನೊಂದು
dispose the
ಅದ-
same
ಅದು-
along with connected matters if any.
ಅದು ಕ್ಲೋಸ್ ಆಗಿದೆ ಪಾರ್ಟ್ಲಿ ಎಲ್ಲ
Close ಆಗಿದಾ?
ಪ್ಲೀಸ್
ಇಲ್ಲ,
ಅದೇ ಆರ್ಡರ್.
ಅದು ಫೈನ್. Merit-
ಬೇರೆ ಯಾವ ಇದ್ರೆ ಅದು
merit-
ತಗೊಂಡು ಮಾಡಿಬಿಡ್ಲಿ ಅಂತ ಹೇಳ್ತಾ
ಅದೇ, ಅದು.
dispose of.
But I filed, I'm filing an application for impleading, have not been made as a party,
ಎಲ್ಲಿ?
tribunal.
ಅಲ್ಲಿ ನೀವು ಮಾಡ್ಕೊಳ್ಳಿ, ನಾವೇ ಇಲ್ಲಿ ಹೇಳೋಣ.
ಗ್ರೇಟ್.
ಇಲ್ಲಿ ನೀವು ಪಾರ್ಟಿ ಆಗಿರಿ ಇಲ್ಲ.
ಇಲ್ಲ, ಅದನ್ನು ಸರ್ವ್ ಮಾಡಿ ಬಂದೆ.
ನೆಕ್ಸ್ಟ್.
For the appellant in this matter, my lord.
I pay for the respondent, my lord.
Early hearing, 2015 matter.
Maybe
13-14 ತೊಳ್ತಾ ಇದ್ದೇವೆ ಈಗ. Second week of February ಹಾಕ್ಬೋದು.
Much obliged.
In application in IA number 1 of 2024, seeking early hearing having been favored, call this matter in the second week of February 2025.
In the
If,
in time, I will file, my lord.
File ಮಾಡಿರಾ?
It is not filed in
If paper books are filed. First.
Name may kindly be deleted.
ನಿಮ್ದ?
First
Name.
name ತೋರಿಸ್ತಾ ಇದೆ.
All.
Great.
Great question. The request in this application that I have made is for
Yes.
The petitioner company before your lordships is also under the ambit of the IRP proceedings, which I've got produced the order along with my application.
You argued at length,
There-
right? Then we
Yes,
made
yes,
this
my lord,
order.
yes. The difficulty was the parent company
Time
was,
cord ಇನ್ನೂ ಸ್ವಲ್ಪ ಬೇಕಾದ್ರೆ amount ಕೊಡ್ಲೇಬೇಕು.
my request is
Alteration ಇಲ್ಲ.
10 lakh rupees may be ordered to be deposited in the next 1 week. I will deposit 10 lakhs. The remaining amount I'll deposit in the next 15 days, my lord. Some condition, some relaxation may be given, my lord.
The application seeking a modification of interim order dated 4/12/2024 does not merit consideration since all aspects were considered and then this interim order was made. First, therefore, the said application, although is rejected, petitioner is granted additional time of 15 days for complying with the said order. Failing which, we'll give 4 weeks for complying with the said order, failing which the petition itself may be dismissed. Okay.
Much obliged.
And for the petitioner, please.
Madlingappa,
A number 1 and 2, a dispensation application, my lord.
all dispense.
Yes.
ಏನಿದೆ?
Facts of the case, my lord. This petitioner is a builder. He is a builder. He is entered into a sale agreement with the respondent, my lord, on 26/11/2015, my lord.
ಅಲ್ಲಿ ಏನಾಗಿದೆ ಈಗ?
ಅದಾದ್ಮೇಲೆ ಸ್ವಾಮಿ ಟ್ರೈಪೇಟೆಡ್ ಅಗ್ರಿಮೆಂಟ್ ಮಾಡ್ಕೊಳ್ತಾರೆ. ಬ್ಯಾಂಕು ಇದರಲ್ಲಿ ಲೋನ್ ಕೊಡುತ್ತೆ ಸ್ವಾಮಿ. ಬ್ಯಾಂಕ್ ಲೋನ್ ಕೊಟ್ಮೇಲೆ ಈ ರೆಸ್ಪಾಂಡೆಂಟು ಕ್ರೋನಿಕಲ್ ಡಿಫಾಲ್ಟರ್ ಮಾಡ್ಯಾಡ, ಯಾಕಂದ್ರೆ ಅವರು ಬ್ಯಾಂಕಿಗೆ ಲೋನ್ ಕಟ್ಟಲ್ಲ ಸ್ವಾಮಿ. ರೆಸ್ಪಾಂಡೆಂಟು ಇನ್ ದ ಮೀನ್ ವೈಲ್ ಅವರು OA ಆಗ್ತಾರೆ ಸ್ವಾಮಿ. OA ಆಗಿದಾಗ ಇವ್ರೇನು ಮಾಡ್ತಾರೆ, ಅದನ್ನು ಸಪ್ರೆಸ್ ಮಾಡಿ ಇಲ್ಲಿ ಕರ್ನಾಟಕ ಸ್ಟೇಟ್ ಕನ್ಸ್ಯೂಮರ್ ಕಮಿಷನಲ್ಲಿ CC ಆಗ್ತಾರೆ ಸ್ವಾಮಿ. ಅಮೌಂಟ್ ಇದು 44 lakhs ಸಮಥಿಂಗ್ ಕೊಡ್ಬೇಕು ಅಂತ.
ಅಲ್ಲಿ ನೀವು ಬ್ಯಾಂಕ್ ನೀವು ಹೇಳಿಲ್ಲ ನಿಮ್ ನೋಟಿಸ್ ಆದ್ಮೇಲೆ
ನಾವು ನಮ್ಮನ್ನು ಪಾರ್ಟಿ ಮಾಡಿ, ಬಟ್ ನಾವು ಹೋಗಿಲ್ಲ ಸ್ವಾಮಿ ಅಲ್ಲಿಗೆ. ನಮಗೆ ನೋಟಿಸ್ ಸರ್ವ್ ಆಗಿದ್ರು ಕೂಡ ನಾವು ಅಪಿಯರ್ ಆಗಿಲ್ಲ.
ಮತ್ತೆ
ಬ್ಯಾಂಕಿಗೆ ಅಲ್ಲ, ಇದು DRTಗೆ ಅಪಿಯರ್ ಆಗಿಲ್ಲ. ವಿ ಆರ್ ನಾಟ್ ಅಪಿಯರ್ಡ್.
ಕನ್ಸ್ಯೂಮರ್ ಫೋರಂ ನಲ್ಲಿ ಪಾರ್ಟಿಸಿಪೇಟ್ ಮಾಡಿದಿರಲ್ಲ?
ಇಲ್ಲ ಸರ್, ನಮಗೆ ನೋಟಿಸೇ ಬಂದಿಲ್ಲ.
ನೋಟಿಸ್
ಬಂದಿಲ್ಲ. ಬಟ್ ಅದು ಎಕ್ಸ್ಪರ್ಟ್ ಅಂತ ಮಾಡಿದ್ದಾರೆ. ಸೊ ವಿ ಹ್ಯಾವ್ ಚಾಲೆಂಜ್ ದಟ್ ಆಫ್ಟರ್ ಫೈಲಿಂಗ್ EA ಎಕ್ಸಿಕ್ಯೂಷನ್ ಪಿಟಿಷನ್ 3/22. ಅದಾದ್ಮೇಲೆ ಸ್ವಾಮಿ NCDRCಗೆ ಹೋಗಿದ್ವಿ. NCDRC ಅಲ್ಲಿ ಕೈಂಡ್ಲಿ ಸಿ
Page number 29, my lord. First appeal, 862 of 2023.
29.
House, page number 29.
ಅವ್ರು ಏನ್ ಹೇಳಿದ್ರು?
ಅವರು ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ, ಇದರಲ್ಲಿ ಬ್ಯಾಂಕ್ನವ್ರಿಗೆ ಏನು ಅಮೌಂಟ್ ಕೊಡೋದು ಕೊಡಿ, ಉಳಿದ ಅಮೌಂಟ್ ಬಿಟ್ರೆ ನಿಮಗೆ ಕೊಡಿ, ಇವರಿಗೆ ಕೊಡಿ ಅಂತ ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ. ಪೇಜ್ ನಂಬರ್ 29, 31 ಅಲ್ಲಿ ಲಾಸ್ಟ್ ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ. ಅಕಾರ್ಡಿಂಗ್ಲಿ ವಿ ಡಿಸ್ಪೋಸ್ ದಿ ಅಪೀಲ್, modify the state commissioners so and so on.
Refund the loan amount.
House. Immediately we filed review application before the same NCDS, my lord. Same adenilla, there is no ground, so better you comply with the earlier order anta FA ಮಾಡ್ತಾರೆ sir. After that, sir, sir.
Issue emergent notice. Interim order as prayed for till next date of hearing.
Please. Matlab.
Same nimdena?
How's sir?
Adu same?
How's same?
Call 14, 15 together.
Stay. Matlab.
Order ಮಾಡ್ಬಿಡು. ಕೊಡಿ.
Lordships, appear for petitioner. I'm
You
withdrawing
have
the
done accident to go court property now.
apologies, Lordship. I'm withdrawing the petition, Lordships.
Then no compensation need to be paid. Counsel for the petitioner has filed memo dated so and so, seeking leave of the court to withdraw the petition. First, memo reads as under. Next paragraph. Learned AGA on being asked says
Yes.
no objection for granting leave. First, in the above circumstances and in terms of the memo, petition is disposed of as having been withdrawn.
Grateful.
Petitioner, my lord. Sees my lordship reappreciation of evidence, my lord. Even he is admitted in the cross-examination, my lordship, that amount is given to provide apartment to the constable post. Kindly see. 146 page number in cross-examination.
146.
146.
ಈ ಕೆಲಸ ಕೊಡಿಸುವ ವಿಚಾರದಲ್ಲಿ ಹಣದ ವ್ಯವಹಾರದಲ್ಲಿ ಚನ್ನಕೇಶವ ಅವರನ್ನು ಮುಂದಿಟ್ಟುಕೊಂಡು ವ್ಯವಹಾರ ನಡೆಸಿದ್ದೆ ಎಂದರೆ ಸರಿ.
ಕೆಲಸ ಕೊಡಿಸುವ ವಿಚಾರದಲ್ಲಿ. Subsequently, my lordship, his wife is met with an accident in 2016. My lordship, that amount is the claim by the department. That is contrary to, my lordship, the statement given by the complainant and DGO.
ಆ ರೀತಿ ಇಲ್ಲ.
Please, my lord. That is, they have only consider, my lordship, subsequently when second SOCAS notice issued to the complainant, my lord, the accused, DGO. He says that, my lordship, that amount is taken for his wife medical expenses. That is considered. But
ನೋಡ್ಲಿಕ್ಕೆ ಹೋಗಿಲ್ಲ.
please, my lord.
Admission and issue emergent notice and interim order as prayed for till next date of hearing. This interim protection is granted after noticing the alleged admission of the delinquent employee in the inquiry. A copy whereof avails at annexure. ಯಾವ annexure ಅದು admission ಮಾಡಿದ್ದು?
ಅದು cross-examination
ಎಲ್ಲಿದೆ?
annex A13.
A13.
ಡಿಪೋಷನ್ ಆದ್ಮೇಲೆ cross-examination ಮಾಡಿದ್ರು. Deposition commence from 136. Sanna Bore is complainant.
Relevant part of which occurs at page running page 146 of the petition. Okay. ಏನು ನೋಡೋದಿಲ್ಲ ಏನಿಲ್ಲ
My lords on, sorry, my lords on 28/11 had issued certain directions to the BDA. We are partly in compliance of the directions, my lord. We request your lordships to grant us a little more time in the matter, my lords, to complete the.
ಯಾಕೆ ಲೇಟ್ ಮಾಡ್ತಾ ಇದ್ದೀರಿ?
ಅಲ್ಲಿ
ಅವ್ರ ಪಾಪ ಅವತ್ತು ಬಂದು ಕಣ್ಣೀರ್ ಹಾಕಿದ್ರು ಕೋರ್ಟ್ ನಲ್ಲಿ.
ನಾನು ಸ್ವಲ್ಪ ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡ್ತೀನಿ ಸರ್.
ಹಾ.
The two actions to have.
ಅಲ್ರಿ ಎಷ್ಟು ಟೈಮ್ ಕೊಟ್ರೆ ಮುಗಿಸ್ತೀರಿ?
January 2nd week ದಯವಿಟ್ಟು ಕೊಡಿ.
ಮಾಡ್ಬಿಟ್ಟು ಕಟ್ಕೊಳ್ಸಿ ಬರ್ಕಡಿ.
ನಮ್ದು
Panel council appearing for the ಏನದು?
we have complied on our part.
In your part, they have complied with that.
Documents ಕೊಟ್ಟಿದ್ದೀವಿ, furnish
Documents have been given.
ಹಾ.
Documents have been.
Learned council appearing for the
Sir, one allotment letter has been issued, my lord.
for the appellant has filed a memo nadu?
Memo, my lord.
A memo along with certain documents
Documents showing that. we have-
reporting compliance of our order dated 28/11/2024 so far as his client is concerned. First stop. He complains that despite such compliance, the respondent BDA is not adhering to the terms of the order. First stop. Learned panel, senior panel counsel appearing for the BDA in all fairness submits that if some more time is granted, there would be compliance of the said order in letter and spirit. Please. First off. He also tells us that whether appellant has complied with or not would be looked into in the meanwhile.
Please, my lord.
Meanwhile. First off. Next one, in the above circumstances, the timeline fixed by our order dated 28/11/2024 for accomplishing the mandated tasks is extended by 4 weeks.
Please, my lord.
Astral finally,
ಮಾಡ್ತೀನಿ.
final, first off. If BDA, despite compliance with the appellant, fails to comply with, comma, the personal presence of the commissioner may be directed,
Please, my lord.
in addition to levying heavy costs. Okay.
Please, my lord. Oblige, my lord.
Yes.
Yes, madam. I'm sorry, I anticipated 5 minutes.
They're held up there.
I'm sorry, madam. I'm so sorry about yesterday.
ಈಗ ಎರಡು ಪ್ರಶ್ನೆ ಹೇಳ್ತು.
Yes.
Again, we examined it. 391, 392 that.
Correct. I'll address that. Yes, yes.
The implementation of the scheme.
Correct.
Failing which 392(5).
392(2), which is winding up.
Class
392(2).
You are right.
Correct.
392(2) ಕೇಸ್ ಹೋಗ್ಬಿಟ್ರೆ ಅವಾಗ ಇವ್ರ ಕೇಸ್ ಜೊತೆ ಬಂದಂಗ ಆಗ್ತದೆ. It's a different ground.
Then again, it goes back to the company has to be ordered to be wound up.
Therefore, in similar matters, I saw some judgments.
Yes.
Judgments ನೋಡ್ಲಿಲ್ಲ ನಾನು. Commentary in ರಾಮಯ್ಯ ನೋಡಿದೆ.
Yes.
ಅದರಲ್ಲಿ ಅವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ ಆ ಟೈಮ್ ನಲ್ಲಿ, ಈಗ ಆಲ್ರೆಡಿ ಪರ್ಟಿಕ್ಯುಲರ್ ಪ್ರಾಪರ್ಟಿ ಇಸ್ ಡಿಸ್ಪೋರ್ಡ್ ಆಫ್, ಅದಕ್ಕೆ ಅಟ್ಲೀಸ್ಟ್ ಅದನ್ನ ಅಪ್ರೂವಲ್ ಹಾಕೋಬೇಕು. ಇರೋ ಪ್ರಾಪರ್ಟಿಗೆ ನೀವು ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡ್ಬೇಕು, ಆ ರೀತಿ ಮಾಡ್ಬೇಕು. ಅದರ್ವೈಸ್ ಸ್ಕೀಮ್ ಅನ್ನು ಮಾಡಿ ಏನು ಉಪಯೋಗ? ಯಾರು ಎಂಟೈಟಲ್ ಟು ಟೆಲ್ ಇಟ್, ಸ್ಕೀಮ್ ಅದಕ್ಕೆ ಅಪ್ರೂವ್ ಮಾಡಿದ್ರಿ ಅಂತ ಕೇಳ್ತಾರೆ ಈಗ ಅವ್ರು ಮುಂದೆ. ಇಟ್ಸ್ ದ ಡ್ಯೂಟಿ ಆಫ್ ದ ಕಂಪನಿ ಕೋರ್ಟ್ ಟು ಎನ್ಶೂರ್ ಇಂಪ್ಲಿಮೆಂಟೇಷನ್ ಆಫ್ ದ ಸ್ಕೀಮ್.
Supervise.
ಹೌದು.
In fact, I'll address all those arguments. But in fact, what I intend to take your lordships to today is, although substantial time has already been taken, but since this is an important issue, my lords, I thought what your lordships may have to consider is the scheme of section 391, 392 There are judgments which explain the object, the scheme of those two provisions. Also, my lords, with the added issue here of a company that is ordered to be wound up under 433. So what I intend to submit is this, my lords, and I'll take my lords through the judgments at a relevant stage. Initially, my lords, this company was set up, it was doing well, it was in the chemical business. I won't go into the issue of the employees yet, my lords, because that may not be relevant at this stage. Then, my lords, they fell in bad times. BIFR tried to revive the company. They could not. In the meantime, some of the creditors had already approached this honorable court seeking winding up. Eventually, my lords, under section 433, the company was ordered to be wound up. Now, could my lords kindly see section? Correct, my lords. And
That came to be recalled in the law.
yes, only thing I want to point out, under 433, there are various factors that need to be considered before a company is ordered to be wound up. All of them are irrelevant except clause E, subsection E.
Companies Act.
If the company is unable to pay its debts.
Correct.
So if the company judge is of the opinion that section 433, man.
E. 433.
433, yes, ma'am. 1956 Act, not the
Correct,
new one.
correct, correct.
So a company, clause E, my lords.
If
Yes,
the
a
company.
company may be wound up
Debts.
if the company is unable to pay its debt. So therefore, my lords, what the company court has to consider is this. Are the assets of the company sufficient to pay off the debts of all its creditors, its debenture holders, its shareholders, possibly employees, and so on? Now, if the answer to that is yes, then every effort has to be made to keep the company going. But if the answer to that is no, and there is no alternative to revive this company, then the company will have to be wound up. And this is important, my lords, with the intention of what? With the intention of ensuring that all of its stakeholders, I'm using the word stakeholders because there are shareholders, there are creditors, and so on. All of them are paid their share of the pie, as much as is available in the company.
On a rateable basis.
On a rateable basis. That's right. 529A will apply and so on. Similar is the scope of now, my lords, the new act, the IBC, also works on the same principle. When a company is admitted into insolvency, what the NCLT attempts to do is keep the company going. But if the debt is admitted, if the debt is not discharged, then it goes into insolvency. And then what the IBC, what the NCLT is mandated to do is try to see if the company can be kept afloat. So they form a committee of creditors. All the creditors put their minds together to see if the company can be kept afloat. Only after that, there is a scheme which is proposed. If the scheme is accepted by the NCLT, the company is kept afloat. Somewhat similar is the scheme over here. So what I'm submitting is this one. The company was originally directed to be wound up because it was found that it is unable to pay its debts. Then it was set aside. Once again, it was ordered. That your lordships is aware of. Then my lords may kindly come. What happened is this SDV Ironworks was actually not a creditor, not a shareholder, was nobody.
Second respondent.
The sixth respondent, I think, SDV Ironworks. What they did, my lords, some of the creditors assigned their loans to the respondent number 6. No. There are some of the loans were assigned to this SDV Ironworks. I'll take my lords through the scheme of all of this is there in the preamble to the scheme of arrangement. So they stepped into the shoes of a creditor. That is when SDV Ironworks, a right accrued to SDV Ironworks to propose a scheme of arrangement under section 391. Now, my lords, kindly see section 391 because that right is available only to two persons. So if I was not a creditor, that is, if SDV Ironworks was not a creditor, there could not have been a scheme of arrangement proposed by SDV Ironworks.
391.
Yes. So power to compromise or make arrangements with creditors and members. Where a compromise or arrangement is proposed, A, between a company and its creditors or any class of them, B, between a company and its members. So therefore, only two categories of persons, company and creditors, company and members. Members is loosely for those who have subscribed to the shares. So the shareholders really, in other words.
Shareholders.
So creditors or members, these are the only two categories of persons who can propose a scheme of compromise or an arrangement under section 391. So SDV Ironworks, my lords, by virtue of the fact that some of the loans were assigned to it, stepped into the shoes of the creditors and they proposed a scheme. So then, my lords, may kindly see, originally it was the court, then it became tribunal, may, on the application of the company or of any creditor or member of the company, so only two categories again, or in the case of a company which is being wound up, of the liquidator, order a meeting of the creditors or a class of creditors or members or class of members, as the case may be, to be called, held and conducted in such manner as the court directs. So therefore, my lords, on an application made by either the creditors or the members, or there is an additional category where in this case also that is applicable, the official liquidator also had a right, in addition to creditors and members, the OL also could have filed an application. Of course, in this case, one of the creditors themselves came forward. Then, my lords, so therefore, this scheme of arrangement was proposed. Meeting was held, your lordships. I took your lordships through the minutes of that meeting.
Where workmen were not permitted, etc.
Yes, where a learned advocate of this honorable court was appointed as chairman of that meeting. All the secured, unsecured creditors, debenture holders, and I think shareholders were in the meeting. All of them gave their unanimous consent to this scheme of compromise or arrangement. And then that report was placed before before this honorable court, before the learned company judge. It was then, my lords, that one of the impugned orders was passed, whereby that scheme of arrangement with one modification regarding KIDB, which may not be relevant, that was accepted. And then that order of winding up was recalled. So that is the scheme. So why I'm submitting this is this. The creditors, the stakeholders really at this stage are the creditors or the members. They are the ones who have an interest in reviving the company or in arranging, entering into a scheme of arrangement or a compromise. It was done by one of the creditors. Subsequently, what happened is now the employees have come forward. I'm not saying that they don't have a right to come forward. They do have, because if my lords would then come to section 392, so where the court, now it's tribunal, where the, I'll just read out.
Power of court to enforce compromise.
Shall have power to supervise the carrying out of the, I skipped. Where the High Court makes an order under section 391, sanctioning a compromise or an arrangement in respect of a company, it shall have power to supervise the carrying out of the compromise. Kindly mark this, Madam. You shall have the power to supervise the carrying out of the compromise or arrangement, and may at any time of making such order or at any time thereafter.
At any at the time of making.
Oh, I'm so sorry. May at the time. I'm so sorry. May at the time. I'm so sorry. May at the time of making such order or at any time thereafter, give such directions in regard to any matter or make such modifications in the compromise or arrangement as it may consider necessary for the proper working
of the compromise
or arrangement. Then subsection 2, if the court aforesaid is satisfied that a compromise or arrangement sanctioned under section 391 cannot be worked satisfactorily with or without modifications, it may either on its own motion or on the application of any person interested in the affairs of the company, make an order winding up the company. Therefore, my lords, to exercise powers under 391 confers supervisory powers on the court to ensure that the scheme is implemented effectively. And under subsection 2, if the court is satisfied that the compromise cannot be worked, therefore the court.
391 power to enter into organized compromise.
That is 391.
Correct.
390
supervision of the court.
Now,
to ensure compliance.
Correct.
Suppose compliance is difficulty with the court can suggest modifications
on
its own or on the application.
Or on the application of any, the word used is any person interested in the affairs of the company. So what I'm submitting is this one. When a company is ordered.
What is meant by person interested in the company?
In fact, that fell for consideration of the court, and it was interpreted to mean it cannot be restricted to only the two categories of persons under 391.
Others also like employees,
yes,
workmen.
So it could be anyone. In all fairness, I have to submit that. So it cannot, one interpretation it was advanced by the learned counsel in that case was that 391 speaks of only two categories. This also can only be two categories. That the Supreme Court itself negative. So that may not arise. So any person interested in the affairs of the company. What I'm submitting is this one. Under 433, section 433, the company order to be wound up because it's unable to pay its debts. The interested parties in entering into a scheme of arrangement or compromise are two persons, members or the creditors. The scheme of arrangement is to protect their interests. As a corollary, the supervisory power of this court is to protect the interests of the persons in whose favor the scheme of arrangement or compromise is entered into. Therefore, my lords may kindly see the scheme of arrangement itself. All of this, my lords, is that my lords will find at page, in the OSA itself, at page 60.
Company application 237.
In the OSA number 8 of 60.
ಇದರಲ್ಲೂ ಇರ್ಬೇಕಲ್ಲ?
ಅದರಲ್ಲೂ ಇರಬಹುದು.
ನೀವು ಅದನ್ನೇ ತೊಗೊಳ್ಳಿ. You take that one only.
Yes.
We will take up that one.
Very
Where is the scheme, brother? 136. 130 ಇಂದ begin ಆಗ್ತದೆ. 31 ಅಲ್ಲ? Scheme of arrangement for revival of so and so limited. ಇರ್ಲಿ.
ಯಾವ page?
ಅಲ್ಲ ನಮ್ಮ ಸ್ಕೀಮ್ ಹೋಗಿ ನಮಗೆ ಸ್ಕೀಮ್
When I refer to page numbers, okay, my lords.
ಪ್ಯಾರಾಗ್ರಾಫ್ಸ್ ಹೇಳಿ.
Paragraphs here. Very well. My lords may kindly see, it starts at from paragraphs A, B, 1, 2, 3, 4, all gives a background to how this, the
Correct.
background to this.
Correct.
Kindly see paragraph 9. That is what I was submitting. That's when this SDV Ironworks enters this
9
paragraph 9.
5.
SDV Ironworks, the propounder of the scheme, a proprietorship concern, so and so. Kindly see the last but third line. Desirous of reviving the company, approach the following secured creditors of the company, amongst others. The following secured creditors assigned the debts held by them in favor.
of
So
the
therefore,
propounder.
IDBI on the next page, IDBI and IFCI assigned their debt to SDV Ironworks.
Correct.
Then paragraph 10. By way of the above said assignment of debts, the propounder stepped into the shoes of the secured creditor of the company. Thus, the present scheme of arrangement proposed for revival of the company in its capacity as creditor. The propounder is having a group of companies, so and so there. Then my lords may kindly come to paragraph 12.
Propounder would bring.
Yes, my lords. The propounder would bring in the required amount for the revival of the company and implementation of the scheme. Upon the revival, the company will pursue the objects which are authorized by its memorandum of association, which is clauses. Kindly mark this, as 3B, and then it refers to A, 1 and 2 of the memorandum of association.
ಏನ್ ಹೇಳ್ತದೆ ಇದು?
Kindly, that is there. I don't know whether Rakesh Nimdral MOA area, memorandum of association.
Huh?
That is there in the appeal. It's there in the appeal which Mr. Shankar had. Memorandum of association. 71.
Page number?
Association, my lord, annexure A.
Annexure A, I think, in the same, no? I don't know.
Mr. A.
Page 22.
Correct.
Page
Same,
73,
same.
in this
Same.
page 73.
Yes, but page 73 of the memorandum of appeal.
You are right.
ಮೊದಲನೇ ಪುಸ್ತಕ. ಹೇಳ್ತವ್ರು. Ink page 73.
Correct.
The objects of the company, my lords, my lords, just come, if my lords were to come back to paragraph number, I think, where is that? 12, ಯಾವ page? Paragraph 12, kindly, my lords, I'd request your lordships to mark
After
clause
scheme,
3B.
Scheme.
Yes, my lords, scheme ಅಲ್ಲಿ, paragraph number 12.
ನಿಮ್ಮ ಪೇಜ್ ಏನು?
ಇದರಲ್ಲಿ page 64.
You're right.
Therefore,
12, the propounder would bring in.
correct. The required amount. Second sentence, upon the revival, the company will pursue the objects which are authorized by its memorandum of association, which is clause 3B bracket A, 1 and 2. Now kindly see, Maras, at page 73. 3B, it's a little hazy in my copy, but I'm not sure whether the court copy is
No,
clear.
73.
73, yes. I think the objects, 3B reads towards the, Malas has it, page 73, 3B.
3B. ಯಾವ page ಅದು?
Here, this memorandum of association, Roman 3 is here, Malas, the objects for which the company is established. Then there is A and then bracket B. Page 7.
From bottom third para.
3B.
3B,
Correct, correct.
Malas found 3B. So the objects incidental ancillary to the attainment of the main object. That's, I'm just constructing the sentence.
Objects are the?
Yes, ma'am. The objects incidental, I think, ancillary, the attainment of the main objects. For the attainment of the main object.
Objects of?
Objects incidental to ancillary or the
Attainment of the main objects.
You're right.
My lords, may kindly see on the, at page 75, clause 14. Clause 14, my lords, I think third para from top.
ಏನ್ ಮಾಡ್ಯಾರೆ ಈ ಪ್ಯಾರಾಗ್ರಾಫ್ಸ್ ಮೇಲೆನ ಸ್ಟಿಚ್ ಮಾಡಿಬಿಟ್ಟಾರೆ.
I think it starts with, my lords, to sell lease.
To sell lease.
To sell
You are
lease, exchange, mortgage, or otherwise dispose of the property, assets or undertaking of the company or any part thereof for such consideration as the company may think fit, and in particular for shares, whether fully or partly paid up, and so on. So factually, my lords, the law.
To sell that property also was recognized in the scheme itself.
Yes, ma'am. In fact, the objects under 3B are so wide in scope. If just as an example, although it's not specific, kindly see the last page of this memorandum of association, page 80. One of the objects also, page 80, just only by way of illustration, ma'am, just to, again, it's not complete, but to C2. That is midway through the page, C2.
To carry
other
on
objects
business
as financiers, commercial agents, mortgage, so on. So therefore, the objects of the company, what the scheme of arrangement proposed is, we will carry out the objects of the company under 3B. 3B includes, among, of course, inter-alia, the right to sell, lease, mortgage, or otherwise dispose of the immovable properties of the company. To therefore, my lords, on a factual basis itself, to submit that what the company is now doing is entirely extraneous to its objects may not be factually correct. Well, I'll come to the legal aspect also.
ಅಲ್ಲ ಅದು ಆ aspect ತನಕ ನಾವು ಹೋಗೋದೇ ಇಲ್ಲ.
Yes, ma'am.
ಈಗ ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು ಏನು ಅಂದ್ರೆ
ನಾವು ರಿಯಲ್ ಎಸ್ಟೇಟ್ ಬಿಸ್ನೆಸ್ ಮಾಡ್ತಾ ಇದೀವಿ.
ಅದ ಬಿಡಿ, ರಿಯಲ್ ಎಸ್ಟೇಟ್ ಆಗಲ್ಲ.
Oh, I'm so sorry.
ಅಲ್ಲ ಅವ್ರು ಹೇಳಿದ ಹಂಗೆ.
Correct.
ಬಟ್ ಇಟ್ ಬೈ ನೋ ಸ್ಟ್ರೆಚ್ ಆಫ್ ಇಮ್ಯಾಜಿನೇಷನ್ ದಟ್ ಕ್ಯಾನ್ ಬಿ ರಿಯಲ್ ಎಸ್ಟೇಟ್ ಬಿಸ್ನೆಸ್. ಅಲ್ಲಿ ಅದು ಮಾಡಬಾರ್ದು ಅಂತ ಹೇಳ್ಯಾರ. ಬಟ್ 3B ಪ್ರಕಾರ ನೀವು ಆಪರೇಟ್ ಮಾಡಬಹುದು ಅನ್ಕೊಂಡ್ರೆ ದಟ್ ಈಸ್ ಇಂಪ್ಲೈಡ್ ಇಂಟ್ರಿನ್ಸಿಕಲಿ ಬಿಲ್ಟ್ ಇನ್ ದ ಸ್ಕೀಮ್
ಆಫ್ ಅರೇಂಜ್ಮೆಂಟ್. ದಟ್ ಇಸ್
ನಂಬರ್.
yes.
ಅವ್ರದ್ದೇನು ಅಂದ್ರೆ ಆ ಪ್ರಾಪರ್ಟಿ ಮಾರಿದ್ದು ಹೋಯ್ತು, ಆಯ್ತು, ಏನೋ ಆಯ್ತು, ಉಳಿದಂತ ಪ್ರಾಪರ್ಟಿಯಲ್ಲಿ ಯಾಕೆ ಇಂಡಸ್ಟ್ರಿ ಮಾಡ್ತಾ ಇಲ್ಲ ಅನ್ನೋದು ಅವ್ರ ಕಂಟೆನ್ಷನ್.
One more, same dimension. This document is dated 81. In 81, they had only leasehold rights. They did not have the absolute rights to the property. It was given on lease to them.
Subject to subsequent sale.
That's not the property included in the assets at that time.
ಅಲ್ಲಿ once feeding the title by estoppel ಆಗತ್ತದು,
which is
feeding the grant by estoppel.
In fact, memorandum of association is like very probably a bad example. It's like the constitution of the company. Like what constitution is to us, it lays down, it's the mother document which says these are the objects, so therefore there may be rights,
and
duties.
It should be ancillary to that. Ancillary chemicals and drugs. They have to manufacture.
Anyway,
yes, that's how.
Those who are buyers, they are not here. Number one. Number two, there is no prohibition for selling the property at all. What is prohibited is doing real estate business. Real estate business is defined, explained in many judgments. Therefore, that will not, within
No,
that
not
parameter,
applicable, not
it will
applicable.
not fit at
Not-
all.
yeah.
What you should have said was, you could not have alienated the property.
Accept.
That you could have said, but we did not entertain that also. Because 2B,
Yes.
2B is inbuilt in the scheme itself.
Yes, yes, proven.
Therefore, you can't say, you can't sell the property. Why it becomes necessary? It was in debts, or it will contract debts. Debtors will extract their price of their pound of flesh. So naturally, they have sold the property. All right. Now we are asking you, ಎಲ್ಲ ಮಾಡಿದ್ ಸರಿ ಇದೆ.
Whether we can now, no, there on a.
ಇದಕ್ಕೇನ್ ಮಾಡ್ತೀರಿ ಅಂತ ಅವ್ರು
Yes, but there on a legal aspect, Malas. Now again, which is why then moving away from the factual
There
aspect.
is a statement on record to show that they have got this SDV has got assigned the dues payable to 3 banks. So there's only one Canara Bank left. Canara Bank is 4,71,000. Rest of it, he had purchased, he had taken over the liability. That is there in the statement. I'll show it to you. 1 minute.
That's not disputed.
ಅದೊಂದು
No, no,
ಇಷ್ಟನೇ
not
ಇಲ್ಲ
important,
ನಮ್ಗೆ.
but very vital. Please turn to page 50. You have this,
Wait, 50.
First book.
50.
Yes, OS 8, our appeal. Paragraph 15, page 50, ink page 50. The company is indebted to the following secured creditors
As
as per
per
the
the interest audited balance sheet dated 31/3/2006. IDBI,
IDBI, IFCI, Standard Chartered Bank
Chartered
and
Bank,
Canara Bank.
Canara Bank.
1, 2, 3, the next para. Of the above secured creditors, IDBI Bank Limited and IFC assigned the debts in favor of the propounder, that's Paganti, and the Standard Banks also.
4 lakhs
assigned
ಅಲ್ಲದು,
the debts.
4 ಕೋಟಿ.
Yes, that. Therefore, the situation is there are no debtors except Canara Bank, 4,71,000. That, so therefore 4 lakhs.
471 lakh.
My mathematics is a little hazy.
Number, mathematics ಬೇಡ, ocular truths.
No, I didn't score more than 0.
ನಮ್ಮವೇನು ಭಾಳ ಡಿಫ್ರೆನ್ಸ್ ಇಲ್ಲ ಬಿಡಿ. ಅಷ್ಟೇ. All right, Mr. Wilgold. ಎಲ್ಲ ಸೇಡ್ ಅಂಡ್ ಡನ್. ಅವ್ರು ಹೇಳೋದೇನು ಅಂದ್ರೆ ಉಳಿದಿದ್ದಕ್ಕೆಲ್ಲ ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡ್ಬೇಕಲ್ಲ ನೀವು.
Correct, Malas.
ಅದನ್ನು
Now-
ಮಾಡ್ತೀರೋ ಇಲ್ಲೋ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದಾರೆ.
Now the question really is this, Malas. When the scheme of arrangement says it shall do what is there in 2B. Now the question I ask myself is, should the court or rather than putting the question to the court, should any person interested in the company force me to do a business which possibly in my commercial wisdom is no longer financially feasible? Because that's why I took my loss through the entire scheme. Finally, my lords, why is the scheme entered into? To keep my creditors and or members happy. If they are getting paid off, they are more than happy if the company comes out of winding up. There is not a single creditor before this honorable court. There's not a single debenture holder. There's no shareholder. Because this scheme, and I would submit this with great respect, this scheme has been successfully implemented. Otherwise, they would have come forward and said, I have not been paid. So therefore, why did the company go into winding up? Because I was unable to pay my debts. Somebody came forward and said,
Scheme is not confined to, you read that section, we agree.
yes, madam.
Clause E,
Yes.
which you read.
Unable to pay debts.
Unable to pay debts. ಅದು ಗ್ರೌಂಡ್ ಫಾರ್
Correct.
ಡಿಸೊಲ್ಯೂಷನ್ ಆಫ್ ದ ಕಂಪನಿ.
Correct.
ಆ ಗ್ರೌಂಡ್ ನಿಮ್ಗೆ ಅವೈಲೇಬಲ್ ಇಲ್ಲ, ಯಾಕಂದ್ರೆ ಡಿಸೊಲ್ಯೂಷನ್ ಮಾಡ್ತಾನೆ ಇಲ್ಲ ಈಗ.
Correct. No. No.
ರಿವೈವಲ್ ಆಗ್ತಾ ಇದೆ. ಆನ್ ದ ಅದರ್ ಹ್ಯಾಂಡ್,
True.
ರಿವರ್ಸ್ ಆಫ್ ಇ,
True.
ಮೋಸ್ಟ್ಲಿ ಈ ತಿರುಮುರು
So
ಬರ್ಕೋಬೇಕಾಗ.
therefore, the question really is, my lords, when the company is being revived, why I said that was why the company sank is because I was unable to pay my debts. Whether it is to employees or creditors is immaterial. I was unable to pay my debts. Now the company is sought to be revived. Now, how can the company be revived? I ask myself, by putting it in a position where it is able to pay its debts, which is why the scheme of arrangement.
Only for the payment of debts.
That is what 391 says, Manoj. Then
That's all
finally,
right. But revival scheme, kindly read that.
yes, Manoj. Now, which is what I'm submitting, Manoj. Now, what I'm getting at is this: how I make myself financially and commercially viable. There should be some play at the joints available to me, which is why this compromise arrangement also is loosely worded. And nobody, and I say nobody, of course, the court has supervisory power, but nobody, particularly some ex-employees, could force me to do the business that I was doing in 1980. Well, for example, chemical business may have been thriving then. right now it may be completely financially disastrous to manufacture chemicals. Can I be forced to manufacture chemicals? That's what I,
Correct. You cannot be.
yes.
Does it mean that scheme cannot be given effect to it?
No, of course, no, which is what I'm
ಅದಕ್ಕೆ ಏನ್
saying.
ಮಾಡ್ಬೇಕು ಅಂತ?
That's what I mean. Now, your lordship asked the absolute pertinent question. Now, the question is, can the scheme be given a go-by to? Now,
cannot
it certainly cannot. Now, the scheme, that is why I was submitting. The scheme, my lords, is in the interests of the stakeholders, particularly the creditors and the members of the company. As long, and that's why I said, why I entered into winding up is because, why I was ordered to be wound up is because I could not pay my debts. Now, somebody has come forward and said, I will pay all your debts. Please get this company out of the water. They are underwater. Please help me get this company out of the water. I will pay all your debts. Now, those people who I told I will pay off all their debts, they have been paid, which is why there was no application filed by them.
Correct.
So the creditors, IDBI Bank, IFC, Canara Bank.
Let us see the scheme itself.
Yes, my lords, may kindly come to, I was reading page 64 of the appeal.
Correct.
I read para 12, my lord.
Since 13 Nodi.
Yes, my lord.
Since the property of the
Is
company
situated in prime industrial location, the same can be better utilized again for carrying out the objects of the company. And which is why, my lord, I was saying the objects, the memorandum of association is like a constitution. It has to be read as a living organism, as was interpreted by the Supreme Court. So it can't be read in a myopic manner to say main object is to manufacture chemicals. I will hold you to that, irrespective of the fact that you will incur a loss. So, my lord, which is why I'll just produce.
That may not be correct. It's
Correct,
all
madam.
because many business decisions have to be taken.
Correct, madam. And times change. No, for
Times change,
example, just to give an example, something that was a business that was thriving in the 80s, possibly telephones, landlines. Somebody who manufactured who uses landlines these days? Everybody uses mobiles. So can it be said that my main object was to manufacture telephones then? Even in 2024, you please manufacture telephones, which means I will send you back into the water. So that is why I was submitting that there has to be some play at the joints, and my memorandum of association is broadly worded. Accordingly, the scheme of arrangement also is broadly worded, which says I will do it in accordance with 3B. And 3B includes, inter-alia, the right to sell the properties.
Come to 16, para 16.
Yes, ma'am. The scheme will also have a social objective in as much as if the scheme is approved and the company stands revived, employment opportunity can be provided. Besides the employment opportunity, the state exchequer will stand to gain by way of future. That's true. Correct, madam. That's there. Now, employment is generated. Perhaps not for.
Not necessarily to them.
Exactly. That's all I'm saying. Employment is generated.
Not necessarily to those people.
That's all my point. Your lordship said it.
Because it does not say to the employment opportunities to the workmen. And
they are, with great respect, they are on a worse footing because they were not employees as on the date of winding up. They were erstwhile employees. So therefore, this clause also cannot be interpreted to mean that I will give employment. That's all. That's all.
That we don't agree with them. If they argue, they did not argue that also.
Yes.
They say employment opportunities have to be generated. That is one of the objectives of the scheme approved scheme.
No, in fact, even assuming, I'm not admitting that it's a real estate business also generates employment. There will have to be agents.
So your case is that you are not.
I'm not a real estate. I'm just assuming. That's why I said assuming. Please don't take it from me. I'm just saying, the worst case, if your lordships were to say I'm doing real estate.
Real estate will generate the employment for a specific period.
Correct.
And thereafter, you sell it and they also go.
Yes. It is sold to industries who are doing manufacturing. So those kindly see, from a larger perspective.
So immediate way, though not immediate. In a mediate way, employment
is being generated. So there are other industries that are being set up over there. It may not be chemical, of course. It may be something else. Then, my lords, may kindly see on the next page, page 66. 66, secured creditors. Again, this is a, my lords, has it? The company is indebted to the following secured creditors. So therefore, the scheme takes care of the interest of the secured creditors, IDBI Bank, IFCI, Standard Chartered, and Canara Bank. Those are the four main secured creditors as on 31/3/2006. What the scheme says is this: of the above secured creditors, IDBI Bank Limited and IFCI assigned their debts in favor of the propounder, and the Standard Chartered Bank, assignee of ICICI Bank, assigned their debt in favor of United Trading Company, which is one of the sister concerns of the propounder. The propounder has undertaken to settle the claims of the secured creditor as per the arrangement.
ನೀವು ಕೊಡುವಂತ ಪ್ರಶ್ನೆ ಬರೋದೇ ಇಲ್ಲ.
Yes, ma'am. So that anyway, that is paid off to the secured creditor. Now, for example, what Mr. Shankar was saying, Canara Bank. If Canara Bank was not paid 4 crore 47 lakhs, would they have kept quiet for 10 years? It's impossible. So they have.
ಕರೆಕ್ಟ್, ನೀವು ಕೊಟ್ಟಿರಲಿಲ್ಲ ನಮ್ಗೆ ಹೇಳ್ಬಿಟ್ರೆ ಮುಗಿದೋತು. ಅವ್ರು ಏನ್ ಮಾಡ್ತಿದ್ರು?
There's no dispute there. We have paid. There is no dispute there at all. The secured creditors' interests have been taken care of. I anyway entered into the shoes of 1, 2, 3, IDBI, IFCI, and Standard Chartered. Only Canara Bank was remaining. Canara Bank has been paid.
The economic buoyancy is higher now. Economic buoyancy is higher.
Higher.
Then clause D, Malus, these are unsecured creditors. One is Government of Karnataka, 2 KIADB, 3 other unsecured creditors. These also, Malus, we have paid. There is no dispute there. KIADB has been paid.
You say secured and unsecured creditors are.
Yes, ma'am. So therefore, in other words, the scheme of arrangement has been implemented fully insofar as secured and unsecured creditors are concerned.
Learned senior advocate, Mr. Vikram Huligol submits that the scheme is consciously worded bit expensively. Semicolon. One of the main objects of the scheme is to pay off the outstanding debts to the secured and unsecured creditors as is mentioned in paragraph
12.
12. 12.
Page 64. Ma'am.
Class second alva. Class C and D capitals.
Oh, I'm so sorry.
C and D.
C and D. C, D, and in fact, E and F also. E takes care of debenture holders. F takes care of shareholders.
C, D, E and F.
F.
E and F. Semicolon. The amount has been paid to these entities. First. Next paragraph. Clause 12 of the scheme, sorry, clause 12 of paragraph A of the scheme.
Yes.
Inbuilds clause number Roman capital 3B bracket nalli capital A adadmele 1 and 2 of the memorandum of association and therefore in so many words, liberty is reserved to the company in question to effectuate the objects as enumerated in the MOA. First up, that very object is expensively worded in the said MOA. First up. Next paragraph. He argues that clause 6 in capital paragraph A, which refers to generating of employment opportunity, has to be construed in the context
Clause 16, I
And
think.
that is-
One will stitch agade.
16. 16, correct, you are right. 16. As a social objective. And no right accrues in favor of the former workmen stroke employees of the company. Going by its very terminology. Full stop. Therefore, workmen cannot invoke this clause. Ex-workmen cannot invoke this clause. That's your contention.
Yes, sir.
Next paragraph. He also submits that the alienation of property is permitted under
This is
clause
clause
75, alama?
clause 3B 14.
Clause 3 na?
Yes, madam. A memorandum of association,
3BCL another.
3B,
3,
3B, page 73,
clause 3,
bracket B,
Roman 3, capital.
yes, Roman 3.
Roman 3
Class 14 ಅಲ್ಲ?
B,
of 14,
yes, madam.
14.
At page 75.
At running page 75 of OSA 8 of 2016. First off, it permits selling of inter-alia, selling of the property also. First off,
Actually, your
at
lord,
this stage, learned senior advocate Mr. S.P. Shankar points out that at the subject property which has been now alienated was held by way of lease only.
And they did not have right to sell, therefore it can't be read as
And
an
therefore-
enabling class.
They had no right to sell the subject property. First. However, subsequently pursuant to order in WP number
AIDB order. WP number 14961 of 21,
14961 of 1991,
2021.
2021. One of us has directed the KIDB to grant sale deed.
Yes,
Correct?
execute the sale.
Execute sale deed in terms of allotment letter
Yes,
and also the provision of this scheme itself. Correct.
It was excluded from the scheme. my lords. This
Because they made memo and they are.
correct, they delete.
Okay. First, accordingly, sale deed has been executed. And therefore, doctrine of feeding the grant by estoppel becomes invocable. Okay.
Just one, Samit points out, madam, clauses.
Also said,
Yeah.
you would take up you will speak to the other industry to whom we have sold that property.
Yes,
To impress them to generate employment.
very well.
First. He, Mr. Vikram will go, that senior advocate. Consistent with the assurance given to the company court. Bracketnally. Justice Anand Bhaira Reddy. Comma. Would impress the buyer of the allotted land, comma, to take projects for generating employment consistent with para 16
Yes. Of the scheme of,
of clause B, Nadu.
clause A, I think. A,
clause A of the approved scheme. First. Yes.
Can I just make one submission? The memorandum of association, I only pointed out clause 60, clause 14. 12 and 13 also relate to immovable properties. At page 74, running on to 75.
12 and
12 and 13 also relate to immovable properties. I read only clause 14 at page
for the
7.
MOA.
Yes, ma'am, of the MOA. Page 74, kindly see right at the bottom.
Para 16 anta
Alla,
ಹೇಳಿದ್ವಿ.
para 16 is for generating employment.
ಅದಕ್ಕಿಂತ ಅಲ್ಲ 16 in your MOA. Sorry. 14 in your MOA.
Just kindly see two clauses above that.
ಗೊತ್ತಾಯ್ತು. ಅಲ್ಲಿ 14 in the MOA ಅಂತಿದೆಯಲ್ಲ. ಅಲ್ಲಿ clauses 11, 12 and 14.
12, 13.
12, 13 and
12,
14.
12, 13.
12, 13 and 14 ಅಂತ ಬರ್ಕೋಬೇಕು. Yes.
Yes, ma'am. So this in
Perhaps may not be correct. I held it here. Unless I have said it here, registered said it.
ಏನಂತ ಹೇಳ್ತದೆ?
That may play, that should generate employment, employ.
ಅಲ್ಲ ಅವ್ರು ಹೇಳೋದು ಈಗ.
ಅಲ್ಲ.
In terms of your contention.
ಅಲ್ಲ ಅದಕ್ಕೆ that is not so in the document of sale.
No, now they take up, it's not there.
I think that.
It's not there. Wait,
That-
it cannot be also, obviously.
Sale
Because
deal
he would not
ಬರ್ದಿರಲ್ಲ.
have agreed for paying
ಅಲ್ಲ,
it.
ಅಲ್ಲ, ನಾನು
headache
ಅದಕ್ಕೆ
at all.
ಹೇಳ್ದೆ ಅಂದ್ರೆ, ಇಲ್ಲ,
But
ಪಾಪ,
how,
I'm worried about the statement comes from senior. Otherwise, I would not have bothered. I leave it there. He shall not make a statement which will be controverted by anybody. That I want to
no,
protect.
his statement is consistent with
No,
Justice Anand Bhaira Reddy's observation, which is pretty earlier
ಅಲ್ಲ,
advocate has
no,
given.
if they had provided in the sale deed that they should generate ನಂತರನೇ ಎಂಪ್ಲಾಯ್ಮೆಂಟ್ ಕೊಡಬೇಕು, ದೇಶ ಉದ್ಧಾರ ಮಾಡ್ಬೇಕು ಅಂತ ಇದ್ರೆ ಪರಲ್ಲ. ಇದು ದೇಶ ಉದ್ಧಾರ ಆಗ್ಲಿಲ್ಲ ಅಷ್ಟೇ. ದಟ್ಸ್ ದಿ ಪಾಯಿಂಟ್.
Ah.
ಅದಕ್ಕೆ ಕಾಂಟ್ರವರ್ಷಿಯಲ್ ಪಾಯಿಂಟ್ಸ್ ಅವಾಯ್ಡ್ ಮಾಡ್ಬಿಡಿ. ಯಾಕೆ ವಾಟ್ ಇಸ್
Mr. Shankar, it is in the order which you read thrice.
I'm aware of it. All that I'm saying is, since it comes from two senior advocates, it should be verifiable. 1, 2, it should not be controverted tomorrow. 3, it should not run counter to the memorandum of article. It avoid ಮಾಡಿದ್ರೆ ನನಗೆ I have no objection. The line of thinking is different, and your lordship's likely conclusion in this is not going to hurt me. Therefore, avoid ಮಾಡೋದು ಒಳ್ಳೆಯದು. I don't want this to be stated. Somebody else should not say, ಅವರು ಮಾಡಿದ್ರಾ ಬೇಡ. That's the
ಅಲ್ಲ ಇಲ್ಲಪ್ಪ ನಾಳೆ ಎಂಪ್ಲಾಯೀಸ್ ಈಗ ಯಾರಿಗೂ ನಾಳೆ ಸೆಲ್ ಮಾಡಿಬಿಟ್ರು ಎಂಪ್ಲಾಯ್ಮೆಂಟ್ ಇಲ್ಲ ಹಿಂಗಾದ್ರೆ ಏನ್ ಮಾಡ್ಬೇಕು ಅಂತ ನಮ್ ವರಿ.
is to protect lawyers and senior lawyers. ಅಷ್ಟೇ, ಬೇರೆ ಏನಿಲ್ಲ. ಯಾಕೆ ಲಾಯರ್ಸು ತಪ್ಪು ಮಾಡ್ಬೋದು. ಅದನ್ನ ನಾವು ಹಾಕಿಲ್ಲ, ಅವ್ರ ಬಣ್ಣ ತೆಗಿಬೇಕಿಲ್ಲಿ. ದಯಮಾಡಿ
ಶಂಕರ್ ಮಿಸ್ಟರ್ ವಿಕ್ರಮ್ ಇದೆಯಲ್ಲ, ಆನ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಆಫ್ ಕೌನ್ಸಿಲ್ ಆನ್ ರೆಕಾರ್ಡ್ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು. You're right. Because you can't give that.
Correct, that's true.
But you better argue ಮಾಡ್ಬೋದು. He can act, not you.
That's true.
ಅದಕ್ಕೆ on instructions of council.
most of us downloaded from the computer. Computer is not, AA has not come to computer yet. If AA had come, if they had fed this information that there is a
Mr.
covenant.
Wilgol has to thank him now.
Well, absolutely. Always thankful.
For protecting your
Well,
interest
it
and
may hurt
reminding our
me, but I will not
limitations.
hurt him.
Correct.
Always grateful.
You're right, you're right. Yeah, on instructions of arguing council on record. Okay. Yes.
My lords, just in support of what I was submitting vis-a-vis the scheme of section 391 and 392, I just place on record just one Supreme Court judgment I'd like to read out. My lords. It is the leading judgment on page 67 of that compilation.
Compilation.
There's one compilation, although it seems hefty. I'll just read some paragraphs. It makes for also, it throws tremendous amount of light on the scheme of 391 and 392. My lords, may kindly see at page 67, this is the third judgment, S.K. Gupta versus K.P. Jain. Kindly see para 12 of that judgment, my lords, which is at page 75.
Right.
Section 391, well, has it? Para 12.
Yes.
Section 391 envisages a compromise or arrangement being proposed for consideration by members and or creditors of a company liable to be wound up by the Companies Act 1956. Compromise or arrangement has to be between creditors and or members of the company and the company as the case may be. It was always open to the company to offer a compromise to any of the creditors or enter into arrangement with each of the members. The scheme in this case is essentially a compromise between the company and its unsecured creditors. The scheme, when sanctioned, does not merely operate as an agreement between the parties, but has statutory force and is binding not only on the company, but even dissenting creditors or members as the case may be. The effect of the sanction scheme is to supply by recourse to the procedure thereby prescribed the absence of that individual agreement by every member of the class to be bound by the scheme, which would otherwise be necessary to give it validity. That is Kaisare Hind. Further, Section 391(1) itself, by specific and positive provision, prescribes who can move an application under it. Only the creditor or member of that company or a liquidator in the case of a company being wound up is entitled to move an application proposing a compromise or arrangement. By necessary implication, anyone other than those specified in the section would not be entitled to move such an application.
ಇದು on maintainability of 391, 390,
Correct. Yes, but no, in this, not really. In fact, I'm supporting that. I'm not saying that application is not in the context of an argument raised in this case that a non-member or a non-creditor cannot file an application under 392. The court said, no, locus standa is well settled. 392, anybody can file an application. But while discussing that, certain observations were made vis-a-vis the scheme of 391, 392. Kindly see next paragraph, para 13. When a scheme is being considered by the court in all its ramifications for according its sanction, kindly mark this, it would not be possible to comprehend all situations, eventualities, and exigencies may arise while implementing the scheme. When a detailed compromise and or arrangement is worked out, hitches and impediments may arise. And if there was no provision like the one in Section 392, the only obvious alternative would be to follow the cumbersome procedure as provided in Section 391(1), which is, again, by approaching the class of creditors or members to whom the compromise and or arrangement was offered to accord their sanction to the steps to be taken for removing such hitches or impediments. This would be unduly cumbersome and time-consuming, and therefore the legislature, in its wisdom, conferred power of widest amplitude on the High Court under Section 392, not only to give directions, but to make such modifications in the compromise and or arrangement as the court may consider necessary, the only limit of the power of the court being that such directions can be given, this is important, can be given and modifications can be made for the proper working of the compromise and or arrangement. The purpose underlying Section 392 is to provide for effective working of the compromise and or arrangement once sanctioned and over which the court must exercise continuous supervision. And if over a period there may arise obstacles, difficulties, or impediments, to remove them again, not for any other purpose, but for the proper working of the compromise and or arrangement. This power either to give directions or to overcome difficulties, or if the provision of the scheme themselves creates an impediment, to modify the provision to the extent necessary, can only be exercised so as to provide for the smooth working of the compromise and or arrangement. To effectuate this purpose, the power of the widest amplitude has been conferred on the High Court. And this is a basic departure from the scheme of the UK Act, in which provision analogous to Section 392 is absent. The sponsors of the scheme under Section 206 of the UK Act have tried to get over the difficulty by taking power in the scheme of compromise or arrangement to make alterations and modifications as proposed by the court. But the legislature, foreseeing that a complex or complicated scheme of compromise or arrangement spread over a long period may face unforeseen and unanticipated obstacles, has conferred power of widest amplitude on the court to give directions and, if necessary, to modify the scheme for the proper working of the compromise or arrangement. The only limitation on the power of the court, as already mentioned, is that all such directions that the court may consider appropriate to give or make such modifications in the scheme must be for the proper working of the compromise and or arrangement.
14.
Yes, subsection 2 provides the legislative exposition as to who can move the court for taking action under Section 392. Reference to Section 391 and subsection 2 of 392 merely indicates which compromise or arrangement can be brought before the court for taking action under Section 392. The reference to Section 391 does not mean that all the limitations or restrictions on the right of an individual to move the court while proposing a scheme of compromise or arrangement have to be read in subsection 2 merely because Section 391 is referred to therein. Unlike section 391, section 392 does not specify that a member or creditor, or in the case of a company being wound up, its liquidator can move the court under section 392. On the other hand, the legislature used the expression, any person interested in the affairs of the company, which has wider denotation than a member or creditor or liquidator of a company. In fact, the ambit of the power to act under section 392(2) can be gauged from the fact that the court can suo motu act to take action as contemplated by section 392(1), or it may act on an application of any person interested in the affairs of the company. That's what I was submitting. So initially, even I was examining from the aspect of whether they can even maintain this application, but that stands covered. As long as you are...
Even otherwise, if they bring certain things to our
court can
notice,
suo motu
court
take it.
itself can
But
do it.
as I was submitting, the only restriction is the court has to ensure that any directions given or any modifications made therein are for the proper working of the compromise and or arrangement, which is why I'm also taking one step back, that compromise or arrangement is entered into with creditors, shareholders, and so on. Now, what your lordship, what this honorable court must do is, if there is any deviation from that, and in any deviation which results in any prejudice being caused, then the court must bring us back in line and say, no, you had said you will do this. Your activities now is compromising the interest of the very creditors who entered into this arrangement, which is almost like a contract. So if you deviate from the contract, the supervisory power is to sort of bring us in line with the contract and say, direct specific performance and say, please do this. Your arrangement said this, you do it. Or if it is unworkable, for whatever reason, let us say, Manoj, there is one of the scheme of arrangement is to manufacture some product. That
It's not possible.
that product
Law prohibits manufacturing.
prohibits. Then the court can modify and say, you undertook to manufacture this. Now it's become illegal. I'll modify your scheme. Otherwise, it's strictly speaking, it's like it is akin to a breach of the contract being the scheme of arrangement. So that's why what I was submitting. And finally, section 392(2) give that residuary power to the court to order winding up, which is a very drastic power, which basically is the power of the court to say, you have entered into a compromise to get out of the water. I will push you back into the water. Is only when a finding is arrived at that no working, no modification, nothing is possible. You have to, therefore, which is why I started with 433. That's
Has
right.
to be, if it goes to that level, then section 433E it
That's
will
right.
give to.
Therefore, you entered into a compromise with creditors. It may not be with all the creditors. It may be by way of a class. But if in any way that arrangement is compromising the interests of anyone, I will try and modify the scheme. But if I still cannot arrive at any working solution, then I will send you back underwater. I will wind you up again. So which is, it's a very drastic power.
Like retrievable breakdown of
Sorry,
matters. Court should ensure.
irretrievable breakdown of
irretrievable, correct. Yeah, absolutely
Arrange-
correct.
We
Absolutely.
can say arrangement.
Arrangement, that's right.
And then while seeing that, then 433E
Yes,
has to be kept in view.
kept in mind. So
If
therefore,
433E is otherwise complied with, then it will not travel to that,
that's
and
right.
that will be.
Because again, that can be inferred from the wording of section 391, which confers a right only on creditors and members. So creditors and members will say, I admit that this company cannot pay its debts, which is why it is in winding up. Or the third party can also do it, and OL also can do it in this case. So there are three parties actually in the case of winding up: the creditors, members, or the OL. Any one of them can come forward and say, this company was not able to pay its debts, but here I am coming out with a scheme to keep this company afloat. The court will examine the scheme. The company court will examine the scheme, see its feasibility, ensure that all the interests are protected, and then the sanction is given to the scheme. And after that, the supervisory powers to ensure that this scheme that you have entered into does not compromise anybody's interests, primarily the people with who you entered into this compromise. Of course, now the question may also arise as to why 392(1) says any person interested. It is
391 is bit different.
391 is different. Possibly, Manoj, there may be people who are left out of the scheme altogether.
Like employees.
Correct, Manoj. Now the question that then we go back to square one. Were they employees? No, Manoj. I'm not going to the extent of saying they're not at all interested in the company. That may be too far-fetched. But
no, we can't say they're interested in the company.
Yes.
Scheme need not be in the interest of the company as the main objective. It is in the interest of the creditors.
Correct. And or members.
Members.
Yes, absolutely correct.
That way. So if they are employees as on that day,
Yes.
then they may say,
Possibly.
because
Yes.
we will not be able to generate bread for our
That's
family,
right.
therefore we are. But that question perhaps may not arise.
May not arise.
Because even otherwise we have power.
Yes.
And coupled duty.
Correct.
To ensure compliance with the scheme.
Absolutely.
So your submission is there is substantial compliance
With
with
the
this
scheme,
scheme.
there is
So
compliance with this-
391, 392, 393, these questions will not arise.
would
is
not
your
arise, yes,
submission.
ma'am. And therefore the question of, I would respectfully submit, the question of sending the company back into winding up or liquidation may not arise in this case because the scheme is given effect to, and the scheme is in the interests of the stakeholders, specifically the members and the creditors. And as I pointed out, the scheme protects all their interests. And as I was submitting, of course, I'm on instruction of submitting all their interests, all payments have been made. And as a corollary, even if 1 rupee was not paid to any of the banks, the Lordship knows how quickly the banks will come to DRT or wherever. So there is all of that. So therefore, my lords, the scheme has been fully, substantially implemented. Of course, there may be some people who are aggrieved. For example, these ex-employees. But my lords, their grievance would lie elsewhere. Now, they may have to go, as Justice Arvind Kumar directed, to go to the Labour Commissioner or to the Labour Court to have that. And at that point in time, yes, if that liability then accrues, as on today also, there is no liability vis-a-vis these employees. Tomorrow, I was assuming there's an adjudication under 33C2. Then, of course, the company would be bound. And because now the company has stepped into the shoes of the SDV has stepped into the shoes of the erstwhile Shrishma Fine Chemicals. If there is an order passed against SDV is bound to comply with the order, but at an appropriate stage.
Okay.
This one more judgment in that, Manas, I'll leave it at that. There is a Bombay High Court judgment which is at page 1. Now, also, Manas, in all fairness, I must submit that this Bombay High Court judgment was set aside and remanded on a limited aspect of the fact that certain procedures were not followed. But I would respectfully submit the law laid down was not unsettled by the Honorable Supreme Court. So kindly see, Manas, page 1 itself.
Learned senior advocate Mr. Vikram Hoilkar submits that the approved scheme in question, having been substantially complied with, no case is made out for invoking 391 and 392.
Yes.
92.
391, but only 392 is there at this stage because this is post approval. Pre-approval is 391, post-approval is 392.
Ali 392. 393 nu tondre ನೀವು ಇಲ್ಲ 392 ಅಲ್ಲ
392.
392 of Companies Act. In support of his submission, he presses into service the apex court decision in SK Gupta versus KP Jain, 1979, 3 SCC 54. All. Some music is also necessary for life. Particularly paragraphs 12.
I'm so sorry.
13 and
Para 16 also is very important. I'm so sorry. I had marked it. I forgot to read that.
The court suo moto acts.
Yes. Kindly see on the next page.
Attention of the court. ಅದನ್ನೇ ಹೇಳ್ತಾ ಇದ್ದೀವಿ ನಾವು.
Correct.
Who drew the attention of the court is not that important.
Not
because
important.
suo moto power
No,
we have.
that paragraph further on the next page, page 78, makes certain relevant observations regarding the power to order winding up. Around 6 lines from the top.
78.
Running page 78.
You're right.
This is a continuation of para 16. The
16.
sentence starting with, again, this approach.
Ah.
Again, this approach is inconsistent with the language employed in 392(2), in that the court can wind up the company under section 392(2) if and only if it is satisfied that the compromise and or arrangement sanctioned by it cannot be satisfactorily worked with or without modifications. The court has to reach an affirmative conclusion before acting under section 392(2) that the compromise and or arrangement cannot be worked satisfactorily with or without modification. It follows as a corollary that if the compromise or arrangement can be worked as it is or by making modifications, the court will have no power to wind up the company under 392(2).
Para 16 ಒಂದು ಹಾಕೋಬೇಕು.
Because my class reiterated in this Bombay.
ಸೊ ಇದು ಒಂದ್ ರೀತಿ ಬೇಲ್ ಕೊಟ್ಟ ಮೇಲೆ ಕ್ಯಾನ್ಸಲ್ ಮಾಡುವಾಗ ಏನ್
Cancel
restriction
ಮಾಡ್ತಾರೆ.
ಬರುತ್ತೆ, ಆ ರೀತಿ ಬಿಲ್ಡ್ ಮಾಡಿದ್ದಾರೆ ಇದನ್ನ. Where have you taken up this contention in your pleadings?
The company in the OSA, my lords, this issue may not have arisen at all simply because it was arising out of.
Of course, that will not arise. But in the 392 petition ದಲ್ಲಿ
Application, no, just.
at least ಎಲ್ಲರೂ ಅಲ್ಲಿ ಇಲ್ಲಿ ಎಲ್ಲರೂ ಒಂದ್ ಕಡೆ ಹೇಳ್ಬೇಕಲ್ಲ, ಇದೆಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಯ್ತು.
I'll just point it out. Could my lords give about 2-3 minutes? Mr. Samit will just try and pull it out. I'll just take my lords through the judgment in the meantime.
The other judge,
The Bombay High Court judgment. I'll close with that.
you said that it is set aside, but on
It was
some other.
remanded on the ground that in the case of one Meghal Homes, in fact, interestingly, my lords, Meghal Homes answers a question which arose in my mind. If my lord sees section 391(1) says a scheme of arrangement can be entered into between company creditors, company members. Then it speaks of in a company in winding up by the OL. So one doubt I had in my mind was whether it can only be by way of the OL. That Meghal Home says no, there is power inherent in the creditors and members. OL is in addition to that power. But in Meghal Homes, it went on a slightly different. So therefore, the Bombay High Court
That
judgment.
extent it is liquidated.
Yes, ma'am. And it was remanded back for, I'm not sure what happened. And there was some observations regarding locus standi in this Bombay High Court judgment, which I'm not relying upon, where I think some third-party interveners were not, including Meghal Homes themselves, were not permitted to intervene. The Supreme Court set it aside and said, rehear the parties.
So they also will have.
Yes, ma'am. They also will have a right of
But
audience.
anyway, you are not a much.
I'm not on
You don't
that.
deny their
I'm
locus
not.
standi at
Absolutely.
all.
I'm not.
Therefore.
The distinction feature is continuous supervision, continuing supervision. The court's continuous supervision or continuing supervision, which would 391, 392. That's what it's like in Gupta's case. That's observed.
Correct. No, that's right. That's what Gupta says. But suppose continuous supervision is not the affairs of the company that is, whose winding up order is recalled.
Takes us nowhere.
Yes, it will not take us time. It will make the courts at the board of directors.
Please.
That's not the object.
It's an
Once the
exercise in.
scheme is in substance implemented, then duty of the court comes to an end. It appears that way.
Correct. And,
If
can
you
I
are
just
wrong,
answer
allowed
that?
to edit.
And then what happens? Your Lordship is absolutely right. Then what happens is, then once the company goes back into liquidation, then again all the creditors so on line up as under 529A and they will get paid off. So oddly enough, if assuming your Lordship were to direct winding up once again, 3 of the secured creditors have assigned their debt to me. Canara Bank has been paid, shareholders, all their dues are
No,
settled.
all creditors are
No,
paid is your stand.
Correct, nobody's left.
Then
Even if I'm
what
ordered-
you are going to do after winding
After
up?
winding up, possibly pay myself because I had the debt was assigned to me.
Instead of being constructive, it should be destructive. It could be destructive, this approach. That's where we stop.
If I may.
Was my kind. Sorry, sir. That Bombay High Court judgment.
I said that. Anything more to be said about that?
Yeah, there's some, interestingly, Maras, here, although it was vis-a-vis 391, the scheme itself propounded not revival of the erstwhile business of the company that was ordered to be wound up, but to actually disposal of its assets itself. And the Bombay High Court said, yes, if in the commercial wisdom of the creditors,
It may dispose of.
if you want to dispose of, if they have agreed to it, the court can't say, no, don't do it. So kindly see paragraph 3. Correct. Just about in para 3, page 1 itself, I won't take too much time, I understand.
No,
I won't.
We are learning.
Only
At least I don't have much exposure to company law, except that reading 1 or 2 books on that Singh during college days and Ramaya, only selective reading it. That will not be sufficient. Therefore, we told Samit to request you to come here.
And of course, he's been of excellent assistance, if I may say so.
Page 1.
Page 1 itself, at para 3, my lords, of course, I don't want to narrate.
These appeals arise.
Yes, my lords, these
Right.
appeals arise. My lords may kindly come about maybe 9 or 10 lines. The learned company judge,
Has, however,
has, however, held that the scheme submitted for sanction is not for revival of the company, but for disposal of its assets. And if the scheme is for disposal of assets by undertaking its development, then it is better that the official liquidator dispose of the property. The shareholders sponsor the scheme and so of workers, committee of workers have preferred these appeals, impugning the judgment of the learned company judge. So the issue raised was, can a scheme, of course, that issue specifically does not arise in this case, but I'm going one step further and saying, even if my scheme said I want to dispose of the assets, the court, the company court could still have approved it, saying that it need not always be traced back to the original object or the original activity of the company. May kindly see, there is one, I won't read it or not, kindly see para 23 at page 12. I won't read it out, but my lords may kindly just make a note. This is, they've extracted heavily from this judgment called Mafatlal, my lords, where 391 was discussed. It's a very lengthy judgment. I think that's also a part of the compilation, but I won't trouble my lords reading it.
Hmm. 392 is post-sanction supervision.
Post-sanction, exactly. That is what Mafatlal makes a distinction. Pre-sanction is 391. The learned company judge will have to see the scheme, ensure that it protects everyone's interests, and give it seal of approval saying, yes, please go ahead. Post-approval is the power under 392. And para 27, my lords, at page 13.
The main question.
Yes, my lords. The main question that falls for our consideration is whether the learned company judge was right in holding that the scheme is liable to be rejected, as it was not for revival of the company, but for disposal of its assets, and therefore it would be desirable that the official liquidator himself disposes of the company's property. Under section 391(1), only a creditor or a member of that company or liquidator, in the case of a company being wound up, is entitled to move an application proposing compromise or arrangement. The scheme proposed in this case is for revival of the company and for sale of the part of the assets of the company. The scheme contemplates payment of the creditors, including workers. The company has entered into an arrangement with sponsors for development and transfer of the property. All the assets of the company are not sold or disposed of. The scheme provides that after paying off the creditors, if funds are available to the company will start a viable industry in any part of Maharashtra. The scheme involves development of the property of the company, the other property of the company, such as Srinivas House and the godown located at Senapati Bapat Marg, Mumbai, are continued to remain the property of the company. It is thus seen that the scheme as it stands contemplates revival of the company. It is for the shareholders to decide as to what business they would carry out if the company is revived.
It cannot say revival of the company, any business or something like that.
So as long as you keep the company afloat, and how does one keep the company afloat? As long as the asset side is more than the liability side. If you have enough assets to pay off your debts, it is always in the interest of the general public for the company to stay afloat. So that's what.
Yes.
So far as that judgment, my lord, I will furnish Supreme Court judgment, my lord, that was overturned.
That's
later
what
on.
he said. He said that it is already remanded.
So far, exactly on this point, what happened later in the division bench, when it had gone before the division bench, my lord, one of the condition was modified as to what was agreed by the shareholders. It was modified stating that new industry will be started under.
No, we may not travel to that level at all.
May not be necessary. May not be necessary.
Out of academic interest, perhaps he is saying that. We will
Because
not travel to that level at all now.
Because that 391 stage has been crossed already. Now it's the
post-sanction approval.
Again, that's on the same page. Last, the underlined portion, there's an extract from one Vasant Investment Corporation.
Correct.
The same page. Once the company is reconstituted, it will be open to the company to carry on such business as its memorandum of association warrants. And it will be open to the company as it is open to any other company to get its memorandum of association altered in accordance with the provisions of law. The scheme, therefore, does not require sanctioning any ultra-virus act on part of the company.
So the board's power to manage affairs of the company would remain intact only.
Absolutely. Otherwise, what would happen is, even 10 years down the line,
Many changes will happen.
Many changes. happen.
Exigencies are.
Technological changes happen, other changes happen in the world. We have to move with the times. So if it, I mean, not admitting, but if it means real estate is the way to go forward, real estate. Manufacturing mobile phones is the way to go forward, manufacturing mobile phones. And that is purely within the commercial wisdom and expediency of the company and its board itself.
And they can't say you cannot sell property at all.
Absolutely. If it is in
It
the
also again within the managerial powers of the
correct, absolutely.
board itself.
And also the supervisory power. of-
Unless that comes.
Yes.
In the implementation of the scheme.
Absolutely
itself.
correct.
That
And
is the
implement-
limitation.
100%. And if it comes in the way of implementation of the scheme, this honorable court has supervisory power to bring us in line and say, you have stepped out of line, please come back and implement the scheme. And having implemented the scheme allows that 392 phase stage also may have passed in this case, would be my respectful submission. That's all. You've taken enough time. I'm sorry.
No, in fact, I should say thank you because
No, I'm
I learnt little company law.
I'm,
Otherwise, perhaps we would have done some, we do not know.
I'm
Perhaps
grateful.
we would have written a wrong judgment, maybe in their favor, maybe in your favor, we do not know. But the company law, certain things became clear.
For all of us, it was a learning process.
My lord, I may be permitted to make few submissions. May be permitted to make few submissions regarding the submission made by senior counsel, my lord. So far as the first argument is concerned, that the scheme provided that both the clause 1 and 2 of the memorandum of association can be conducted by the company, and hence they are permitted to sell the land of the company. Lord, memorandum of association and articles of association are basic constitution of any company, my lord. Every company will have, if they don't have even that clause, at that point of time, my lord, they don't have any power to sell the property. So the ancillary clause will be there in every company's in the memorandum of association. That does not mean it is its main object of the company. To
Incorporated, that
It is
very
incorporated.
paragraph is incorporated at A12.
No, my lord. 3B.
A14. 12, paragraph 12 of the 14 is your memorandum of
Correct,
association.
correct. That's what I think.
A12 of the approved scheme itself.
If that is the interpretation, kindly take that scheme, my lord.
A scheme is angry on me. That very often I'm turning to it. You can tell me, I verbatim, I can reproduce that also. Now, so many times I was.
What they say is on clause 12, which says, my lord, 3B, A1 and 2. A1 and 2.
B is
it is-
into bracket 1 and 2.
It
Next
is-
it follows.
It is not happily worded. It had to be either 3A, 1 and 2 and 3 clause B. Or it had to be,
Been worded like that and it is there.
my lord, if that is there, it will.
So you can't change it.
No, my lord.
You
If,
may say happily or unhappily.
alala,
If approved anta.
if that is the interpretation, if they cannot even go to clause 12. 3B, A1 and 2, then 1 and 2 has to be restricted. There is no 1 and 2 in 3B.
No, where is the restriction for alienation of the property?
Please, my lord. No.
So that.
Kindly take, my lord, the very scheme that what they have read is preamble of the scheme. The scheme had not yet come.
All right, what are the salient features of the scheme? Tell us.
Salient features of the scheme.
Is payment to creditors assured
Aste
the
alla.
secured
Kindly take-
creditors, unsecured creditors and others.
Please, my lord.
This is the
Kindly
basic
take
idea.
page 139 of my
13?
application. 237 of 2023. 139. Scheme.
139.
That is clause number 2. Now, if your lordships may kindly take definition clause
139 2.
139 Melgade, the scheme.
Scheme.
That is where it starts.
Correct.
This is what we are going to do.
Ah.
The scheme, clause 2. The propounder undertakes to settle all dues of the employees of the company as per the one-time settlement. The company shall also offer employment opportunity to its employee upon commencing the commercial production after revival of the company. Now there is a word commercial production. If importance has to be given to 3B, now 12 is not there, my lord.
This is dated what?
This is the scheme.
No, dated what?
In 2013, my lord, when they had filed the application.
But by that time, you were no longer the employees.
Alla, navidvi, on rolls, that is the person who is appearing. There is two different, my lord, few of them were retrenched. few of them were on rolls as on the date of winding up of the company. They were still considered as the employees of the company.
Meaning as the employee.
I'm instructed to submit that there was nobody on the rolls except for Mr. Vasu, who was present in the court.
But
At the
OSA
date
is
of
there.
winding up, the company, nobody.
There is OSA we had filed, even we were considered an employee. It is at our instance that it was once again remanded. Even I am also one of the participant or I am the one of the party. Now kindly take.
Were you a party to the writ appeal? Where court took the contention, writ petition, court took the contention, the stand that it does not amount to transfer. And therefore 25 FF is not, we were not a party.
No, because
We were
few of
still
them
there.
were before them, that only they were retrenched, my lord. Those are one group of employees.
Anyway,
There were another.
we'll hear it some other day because only 1.5 days court is working now. Therefore, we'll not close this matter. We'll hear it after further hearing. We'll do that.
One.
ನಿಮ್ದು ಒಂದು ರೈಟ್ ಅಪ್ ಕೊಡಿ ನಿಮ್ಮ ಆರ್ಗ್ಯುಮೆಂಟ್ ಎಲ್ಲ ಆಗಿದೆ ಅಲ್ಲ ಆ ಪ್ರಕಾರ ರಿಟರ್ನ್ ಸಬ್ಮಿಷನ್
No, incorporating this, we'll give a fresh one.
Heard at length, greater length. First, post this matter, when this combination sits, we don't know what will happen after sits, after vacation.
Grateful.
Let us talk. ಅಲ್ಲ ಇನ್ ದ ಮೀನ್ ವೈಲ್ ನೀವೇನ ಆಫರ್ ಕೊಟ್ಟಿದ್ರಲ್ಲ ಅದನ್ನ ಸೀಲ್ಡ್ ಕವರ್ ಮಾಡ್ಕೊಂಡು ನಮಗೆ ಕೊಡಿ. ಆ ಆಫರ್ ನಿಮ್ಗೆ ಅಫ್ಕೋರ್ಸ್ ಎಲ್ಲ ಅದು ಇರ್ಲಿ ನಮ್ಮ. Thank you, Mr. Wilgold, Mr. Shankar and other advocates also. Yes.
That should we give it to the court officer or on the next date? That sealed cover. Because next date.
ನಿಮ್ಮ ಆಫರ್ ಏನ್ರ ಇದ್ರೆ.
I'm sorry, ma'am.
ನಿಮ್ಮ ಆಫರ್ ಏನ್ ಮೊನ್ನೆ ಹೇಳಿದ್ರಲ್ಲ ನೀವು.
So shall we, in a sealed cover, shall we hand it over to the court officer?
ಬೇಡ, ಈ ಆಫರ್ ಹಂಗೆ ಇರ್ಲಿ. Just will keep it in our view. Because ಏನೇನ್ ರಿಪರ್ಕಷನ್ ಇದೆ ಗೊತ್ತಿಲ್ಲ ಅದಕ್ಕೆ. Thank you, sir. Okay. Yes. Okay.
Serial number 20.
Ha.
One resolution, 2011 resolution, which the learned senior relied upon by referring to a memo and said that, my lord, that has been referred into subsequent 2014 resolutions. But we have tried to trace it. It is not in our custody. It is, we are checking with the Justice Keshav Narayan Committee 1. There also we have sent an intimation for that. And one to Justice Kempanna Committee, which had overlooked the illegalities of such deletions. Of that, probably that is one where we're searching, Lord. Before that, Lordship may accommodate us by, they have asked for 2-3 days, Lord. Both the committee.
2-3 days ನಾಗ ಯಾಕೂ ಸಾಧ್ಯ ಇಲ್ಲ. ಏನೇ ಇದ್ರು
after vacation.
After vacation ಹಾಕ್ಬೇಕು.
Yes. Already entire resolution is 44-14 leaders. Entire gist is already there in that.
ನೀವೇ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತೇವೆ ಅಂತಾರೆ. ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಲಿ ಏನು ಗೊತ್ತಾಗಬೇಕು. If he wants to substantiate his stand by producing some material, we can't say that we will not give you time. He will not generally, he is one, there are many counsel advocate, but one of them is he will never seek any adjournment at all unless it is genuinely needed. Call this matter for further hearing when this post vacation, when this combination sits. Okay.
Please.
Okay. ಮಿಸ್ಟರ್ ಹೊಳ್ಳ ಬನ್ನಿ ಈಗ ಅವ್ರಿಗೆ ಟೈಮ್ ಬೇಕು ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಒಂದು ಶಾರ್ಟ್ ಅಕಾಮಿಡೇಷನ್ ಕೊಡೋಣಂತೆ ಮಾಡ್ಕೊಂಡು ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಅವ್ರೇನೋ ಒಂದು ಯಾವ್ದೋ ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತಾ ಇದ್ದೀವಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಲಿ, ನೋಡ್ಕೊಂಡು ಮಾಡಿದ್ರ ಆಮೇಲೆ ನಿಮ್ನು ಅದ್ರ ಮೇಲೆ ಕೇಳ್ಕೊಂಡು ವಿಲ್ ಡೂ ದಟ್.
ಏನು ಹೇಳಕ್ಕಾಗಲ್ಲ. ಇದು ಮೂರನೇ ಸತಿ ಟೈಮ್ ಕೇಳ್ತಾ ಇದ್ದಾರೆ.
ಜನರಲಿ ಹಿ ವಿಲ್ ನಾಟ್. Yes.
Please. Please.
Yes. ಕೊಡಿ ಮೆಮೊ ಬರೆದ್ರಾ? ಕೊಡಿ ತೋರಿಸ್ಕೊಡ್ತೀನಿ ಯಾವ ರೀತಿ ಇದೆ. ನೋಡಿದ್ರಾ ಈ ರೀತಿ ಮಾಡ್ಬೋದಾ? ಇದನ್ನ ನೀವು ಸಪೋಸ್ 3 acres ನಾಳೆ 8 ಮಾಡಿದ್ರೆ ಏನ್ ಮಾಡಕ್ ನೀವು? ನಾಳೆ 8 ಮಾಡಿದ್ರೆ ಏನ್ ಮಾಡಕ್?
ಇಲ್ಲ ಮಾಡಿ. I'll write.
ಮತ್ತೆ ನಾಳೆ ನೀವೇ ಹೋಗ್ತೀರಿ ಐ ಆಮ್ ಸೇಯಿಂಗ್ ಎನ್ ಎಕ್ಸ್ಟ್ರೀಮ್ ನಾಟ್ ಯು.
I know, man.
ಮತ್ತೆ ಇದನ್ನ ಮಾಡಿ ಏನು
Writing ಅಲ್ಲಿ
ಟೈಪ್ ಮಾಡ್ಕೊಂಡು ವರ್ಡ್ಸ್ ನಲ್ಲಿ ಬರೀಬೇಕು. ಸರ್ವೆ ನಂಬರು, ಅಮೌಂಟ್, ಏಜ್, ಮಾರ್ಕ್ಸು ಇವನ್ನೆಲ್ಲ ವರ್ಡ್ಸ್ ನಲ್ಲಿ ಬರೀಬೇಕು. ನಾಳೆ ಏನಾರ ಚೇಂಜ್ ಆಗ್ಬಿಟ್ರೆ ಮಾಡ್ಬೇಕು. 3 ಇದ್ದಿದ್ದು 8 ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ರೆ ಮುಂದೆ ಹೋಲ್ ಥಿಂಗ್ ವಿಲ್ ಬಿ ದಟ್ ಓನ್ಲಿ. ಹಂಗಾಗಿ
Shall I write it in the words there? Shall I write it?
ಅವ್ನು ಟೈಪ್ ಮಾಡ್ಕೊಂಬನ್ನಿ. ಇನ್ನೊಂದು ಇದು ಇರಲಿ, ಇದ್ರ ಜೊತೆ ಅದನ್ನು ಹಾಕೊಳ್ತೇವೆ. ಟೈಪ್ ಮಾಡಿ ಎಲ್ಲ ಪೀಸ್ ಸೈನ್ ಮಾಡ್ಕೊಂಡು ತೊಂಬರ್ರಿ.
This observation, my lordship, already this observation already reflected in the my lordship land.
The order itself there is there. That is the reason we decided. ಅಂತ ಕೇಸ್ನಲ್ಲಿ ನೀವು ಪ್ರಾಸಿಕ್ಯೂಟ್ ಮಾಡ್ತೀರಾ ಅವ್ರನ್ನೆಲ್ಲ. ಸೇಲಿಗೆ 3 acre 2 + 1 acre you have agreed that it belongs to him ಅಂತ.
ಅವ್ರು ಹೇಳೋದು 29 acres ಅಂತ. How can I encroach 29 acres?
Report of the Tahsildar. It is in favor, in your favor only.
No, respond number 3, who is the complainant?
Avun bidi complainants always they will have some hyperbola, power, parabola ಎಲ್ಲ ಇರ್ತದೆ. ಅದೇನು ದೊಡ್ಡ ಪ್ರಶ್ನೆ ಅಲ್ಲ.
Notice.
ಇನ್ನೊಂದು ಇದನ್ನ ಮಾಡಿಕೊಡಿ, ಟೈಪ್ ಮಾಡಿಕೊಡಿ. ಇಲ್ಲ ಇನ್ನೊಂದು ಬರ್ದು ಕೊಡಿ.
ಆಗ್ಬೋದು.
Allowed in terms of memo. ಈ ರೀತಿ ಮಾಡ್ಬೋದು ತಾನೆ?
Please,
dispensed with. ಮಾಡ್ಬೋದು.
ಟೈಪ್ ಮಾಡಿಸ್ಕೊಡ್ತೀನಿ.
ಟೈಪ್ ಮಾಡಿಸ್ಕೊಡು, ಸೈನ್ ಮಾಡಿ 2 ಸೈಡ್ ಮಾಡ್ಕೊಂಡು ಕೊಡ್ಬೇಕು. ಸರ್ವ್ಡ್ ಕಾಪಿ ಅಂತ ಅವ್ರ ಮೇಲೆ ಆಗಬೇಕು. ಬಟ್ ವಿಲ್ ನಾಟ್ ಸೇ ದಟ್ ಯು ಹ್ಯಾವ್ ಅಗ್ರೀಡ್ ಎಟ್ಸೆಟ್ರಾ. ಇಟ್ ಶುಡ್ ನಾಟ್ ಕ್ರಿಯೇಟ್ ಅದರ್ ಪ್ರಾಬ್ಲಮ್ ಟು ಯು. Yes. Well, only thing is ಅಲ್ಲಿ ನೀವು ಇನ್ನೊಂದು ಸೆಂಟೆನ್ಸ್ ಬರೆದಿಲ್ಲ. It is in the possession of the government. Government may do anything ಅಂತ.
ಅಲ್ಲ ಅದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ, ಯಾಕಂದ್ರೆ
ಗೊತ್ತಿಲ್ಲ.
ಅದು RTC
ಬೇರೆ ಯಾರು ಇದ್ದಾರೆ?
ಅಲ್ಲ RTC ಬೇರೆಯವರು ಇದ್ದಾರೆ, ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೀನಿ ನಾನು.
ಹಾಗಾಗಿ ನಿಮ್ದಿಲ್ಲ ಅಂತ ಹೇಳ್ಬೋದು ಅಷ್ಟೇ.
I am confined only to, that is the reason, my lord, 3 acres.
All right. 371 J Madhya. Final hearing we are not taking.
Lord, I had requested yesterday, my lord.
Huh?
One matter at serial number 30. It's
ಏನದು?
a short question, point, my lord, that obtained interim order, my lord.
I appear, sir.
My lord, against the KT has refused to grant interim order, my lord. Against that, they had preferred this writ petition. Matter pertains to transfer. My lord, 29/10/2024 interim order was granted by my lords. They had asserted that, my lord, the petitioner has put decades of service spotless. Department inquiry is pending against, joint inquiry is pending, my lord.
Joint
moreover-
inquiry is pending.
Yes, my lord. And moreover, from last,
Pending ಆಯ್ತು.
charges are proved.
Found guilty.
Alla, charges, second show cause notice we have issued, my lord. And moreover, my
how?
lord, his transfer order dated 3/10/2024, he's transferred from Chikmagalur to Chamarajanagar. He's in that post from last 8 years.
In the said.
Yes, my lord.
In the
And he's taken charge. What's up?
They have already taken charge also.
Yes.
ಇವಾಗ ತಗೊಂಡಿದ್ದಾರೆ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಕೊಟ್ಟರು ಕೂಡ ದೇ ಹ್ಯಾವ್ ನಾಟ್ ಇಂಪ್ಲಿಮೆಂಟೆಡ್ ನಾವು ದ
So
ಟ್ರಾನ್ಸ್ಫರ್
you have been there since last 8 years.
ಹೌದು ಅಲ್ಲಿ
What is your right?
ಅಲ್ಲಿ ರೈಟ್ ಅಂದ್ರೆ ಆನ್ ದ ಟ್ರಾನ್ಸ್ಫರ್ ಗೈಡ್ಲೈನ್ಸ್ ವರ್ಜ್ ಆಫ್ ರಿಟೈರ್ಮೆಂಟ್ ತಗೊಂಡಿದ್ದು
ಯಾವಾಗ ರಿಟೈರ್ಮೆಂಟ್ ನಿಮ್ದು?
ಇನ್ 1.5 year
ಅದು ವರ್ಷ ಆಗಲ್ಲ ನಾವು.
One and a half.
ಅಲ್ಲ ಇಲ್ಲಿ ಹೇಳ್ತಾರೆ ಸೇವಾವಧಿ ವಿಸ್ತರಿಸಬಹುದು ಅಥವಾ ಕಡಿತಗೊಳಿಸಬಹುದು.
clause
Guidelines ಅಲ್ಲಿ yes, my lord, it is in the guidelines.
clause 7(1)(a) on the
And
basis of
moreover, they have made false submission, my lord.
Nothing is
Sorry,
there.
My lord,
I
kindly see the.
I
interim
never
order,
do
my
that
lord.
false submission.
Anyway, ಒಂದ್ಸರಿ anxiety ಅಲ್ಲ, false ಅಂತಲ್ಲ.
I beg the
You
pardon.
can say undue.
Yes.
Exactly, undue. I say sorry for that also. I fairly admit.
Learned AGA draws our attention to our order dated 29/10/2024, which is structured on a premise that the service of the petitioner is spotless. First off, she points out that the disciplinary inquiry is halfway through. And presently it is at the stage of second show cause notice.
Yes, my lord.
And therefore, obviously, service cannot be said to be spotless. First, she also tells us that the petitioner has been in Chikmagalur,
Yes, my lord.
in Chikmagalur since last 8 years. 8 years, which militates against the transfer guidelines. Retention period being 3 na?
2 years.
Being 2 years only. First, there is no reason to doubt this version. Since it is a matter of record. First, learned counsel appearing for the petitioner submits that his client is in the verge of retirement, and therefore he should be permitted to remain at Chikmagalur itself. First, this is bit difficult to countenance. Verge of retirement anta yaವಾಗ ಅಂತೇವೆ ನಾವು? How many years, how many months?
2 years. 2 years.
2 years ಅಂತ
2 years.
clause 7(1)(a) ದಲ್ಲಿ 2 years ಅಂತ
But that again is curtailable.
Yes.
again curtailable. May on decision.
First, however,
May one submission. Now the present position is that to the transfer place he reported. The transfer may not survive this petition, may not survive also.
may not survive it.
Cannot survive because now those.
Yeah. In all fairness, petitioner
Please,
submits
please.
that
Please.
his client having already reported for duty at the transferred place, that is Chamarajanagar,
Chikmagalur to Chamarajanagar.
Chamarajanagar. Pursuant to transfer order, petition itself may be disposed of as having become infructuous.
Please.
First, next paragraph. In view of 11th sentence, in view of this fair stand, nothing survives for consideration in the matter. First, in the above circumstances, petition is disposed
Please.
of.
I am
Like-
sorry, with an,
No, no.
no, not an intentionally I have not made.
Even
Please.
Madam Kulkarni
Please.
did not intend that you lied or something. No,
Because,
just it's not true ಅನ್ನೋ
please,
ಅರ್ಥದಲ್ಲೇ ಹೇಳಿದ್ದು.
please, oblige.
Kind intelligence, my lord,
Bill number 29, my lords, your lordships. Covered by judgment, my lords, it is a.
ಎಲ್ಲಿ ಮಾಡೋದಾಗ್ತದೆ? ಯಾವ
My lords, kind intelligence, my lords. Serial number 23, my lords. This is a suit for declaration that has been decreed in favor of respondent, my lords. Small site. The standard sale lead, my lords, that has been, my lords, opposed by the respondent, that was decreed, my lords. The date may be fixed in January, my lords. Serial number 23, my lords.
ಯಾವ year suit ಅದು?
16, my lord.
2016.
Appeal is 16, my lords. Suit is of 12, my lords. Appeal of 16, my lords, the year 16.
ಯಾರು ನಿಮ್ಮ opponent?
That's,
May I please lordships? I appear for the appellate lords in item number 23, my lords.
Yes, Mr. Patil.
Please, lords.
ಹಾ. ಏನೋ 2012 ಸೂಟ್ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
ಹೇಳ್ತಾ ಇದ್ದಾರೆ,
ಫಸ್ಟ್ ವೀಕ್ ಆಫ್ ಫೆಬ್ರವರಿ ಹಾಕ್ಬಿಡ್ತೀವಿ.
ಅಡ್ಡಿಲ್ಲ sir.
it's,
We are told that suit is of the year 2012. Although appeal is of the year
23.
2016. First up. in view of that, call this matter in the first week of February 2025.
Grateful, my lords.
Minutes.
Huh.
Serial number 29 minutes, you last.
ಈಗೆಲ್ಲ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗ್ತದೆ ಈಗಾಗಲೇ
Covered by judgment.
ಕವರ್ಡ್ ಇದ್ರು ಅದು ನೋಡು ಡು ಯು ಅಗ್ರಿ ಯಾರು ಒಪ್ತಾರ ಅವರು ಕವರ್ಡ್ ಬೈ ಜಡ್ಜ್ಮೆಂಟ್ ಅಂತ
It is regarding sanction of additional increment for having passed Kannada language examination minute.
ಕವರ್ಡ್ ಬೈ ಜಡ್ಜ್ಮೆಂಟ್ ಆಗತ್ತನ
Is
ರಿಸರ್ವ್ ಫಾರ್ ಜಡ್ಜ್ಮೆಂಟ್.
Through it, my lord. After vacation, it may be listed. I'll go through it.
After vacation
Please, ma'am, go through it.
ಕವರ್ಡ್ ಕಣಂಗ್ ಕಾಣ್ತದೆ.
Yes, my lord. Kannada, they have,
ಬೇರೆಯವ್ರಿಗೆ ಪರ್ಮಿಟ್ ಮಾಡಿದ್ರಿ ನಾವು ನೀವು ಅದ್ರಲ್ಲ ಯಾರೋ ಒಬ್ರು ಪೊಲೀಸ್ ಕಾನ್ಸ್ಟೇಬಲ್ ಅದೊಂದು ಮಾಡಿದ್ವಿಲ್ಲ ನಾವು ವೇರ್ ಯೂಸ್.
Serial number 25, my lords, the petitioner has been deprived of his employment on a ground of eligibility criteria, medical test, which is not applicable to his post, my lords.
Immediately after vacation ಆಗಿ.
no, my lord. Justice Arvind Kumar's judgment, my lord, is affirmed by Apex Court. Illa, motor vehicle height. No.
All right, after vacation.
This
Okay.
Two ladies give complaint. Two ladies given a complaint against him. That is why, that in Mysore, my lord, Mysore office, my lordship, I want to.
But on that note, you cannot transfer it unless it is approved material, not this material.
His complainant is working. A complainant is working under him, working under him. He is misused his supervisor, his official power. I got instruction, my lord. WhatsApp. Tomorrow, my lord.
Yes.
Yes, but Vishaka Jali.
It is after that. Now, because for the dismissal order, transfer order, they made.
There is no such.
The original allegations only against the financial irregularities. Low cost notice.
Therefore, because you are not placed before the committee. Without placing before the committee.
I will pursue with my lordship. They have referred the complaint in committee or not. They have referred the complainant complaint to committee or not. I will.
Complaint?
Nothing of that sort. Only allegation. Low cost notice that I have committed.
In other place will not be safe. Therefore, your purpose will not be.
This is so only additional ground.
Notification.
Not only one lady, my lord, two ladies given complaint.
ಅದ್ರಲ್ಲಿ 27/2024 ಒಂದು ನೋಟಿಫಿಕೇಶನ್ ಮಾಡಿದ್ದಾರೆ ಗವರ್ಮೆಂಟ್. ಕ್ರಮ ಸಂಖ್ಯೆ 1 ವರ್ಗಾವಣೆಗೆ ಸಂಬಂಧಿಸಿದಂತೆ HR ಸುರೇಶ್ ರವರ ವಿರುದ್ಧ ಸಾರ್ವಜನಿಕರಿಂದ ಬಹಳಷ್ಟು ದೂರುಗಳು ಹಾಗೂ ಮಹಿಳೆಯರೊಂದಿಗೆ ಅಸಭ್ಯ ವರ್ತನೆ ಕುರಿತಾಗಿ ಹಲವು ದೂರುಗಳು
Note ಇದೆ. That note is there.
ಆಫ್ಟರ್ ದಟ್ ಯು ಟ್ರಾನ್ಸ್ಫರ್ ದಿ ಅದರ್ ಸೈಡ್. ಆಧಾರ್ ಆದ್ಮೇಲೆ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್
ಅಂತ ಸೀರಿಯಸ್ ಇದ್ರೆ ಯು ಹೋಲ್ಡ್ ಎನ್ಕ್ವೈರಿ. ಈಗ ಹಿ ಹ್ಯಾಸ್ ಮಿಸ್ಬಿಹೇವ್ಡ್ ವಿತ್ ದ ಲೇಡೀಸ್ ಅನ್ನೋ ಕಾರಣಕ್ಕೆ ನೀವು ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದ್ರೆ ಅವನ ಗತಿ ಏನು? ಹಿ ವಿಲ್ ಬಿ ಡಿಫೆಮೇಟರಿ. ಇಟ್ ವಿಲ್ ಬಿ ಡಿಫೆಮೇಟರಿ. ನೀವು ಎನ್ಕ್ವೈರಿ ಮಾಡಿದಾನೆ ಇಲ್ಲ, ಮಾಡಿದ್ದ ಅಂದ್ರೆ ಶಿಕ್ಷೆ, ಮಾಡಲಿಲ್ಲ ಅಂದ್ರೆ ಓಪನ್.
Yes.
This matter is only my lordship, only suspension. He challenged the not granted the stay before this ESIT, my lordship. He challenged that order. This is my lordship. Presently, this is premature.
Suspension.
My lordship. Suspension.
Transfer.
Transfer, my lordship. Transfer. Sorry, my lord. Transfer. Let my lordship.
ಈಗ ನೀವು ಈ ಗ್ರೌಂಡ್ ಮೇಲೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದ್ರೆ ಅದನ್ನೆಲ್ಲ ನೀವು ಒಪ್ಕೊಂಡಂಗೆ ಆಗ್ತದೆ. ಅವನ ಗತಿ ಏನು? ಅಫಿಷಿಯಲ್. ನೀವು ಎನ್ಕ್ವೈರಿ ಮಾಡಿಕೊಡ್ರಿ, ಇದು ಮಾಡಿಕೊಡ್ರಿ. ಆ ಗ್ರೌಂಡ್ ಇಟ್ಸ್ ಎ ಸೀರಿಯಸ್ ಗ್ರೌಂಡ್. ಈಗ ಅಲ್ಲಿ ಇದ್ ಮಾಡೋದ್ರಿಂದ ಹೆಂಗ್ ಉಪಯೋಗ ಆಗ್ತದೆ? ಅಲ್ಲಿ ಹೆಣ್ಮಕ್ಳು ವಿಕ್ಟಿಮೈಸ್ ಆಗ್ತಾರೆ. ಮುಂದೆ ಅಲ್ಲಿಂದ ಮತ್ತೆ ಇನ್ನೊಂದ್ ಕಡೆ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡ್ತೀರಾ? ಏನ್ ಪರ್ಮನೆಂಟ್ಲಿ ಟ್ರಾನ್ಸ್ಫರ್? ಹಿ ಹ್ಯಾಸ್ ಟು ಬಿ ಇನ್ ವೆಸ್ಟಿಬಸ್ ಕಂಟಿನ್ಯೂಸ್ಲಿ. If that were to be the ground.
Actually, my lord, no, there is no such allegation against me. They have
ಇದೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಬಟ್ ಅದನ್ನ ವೆರಿಫೈ ಮಾಡ್ರಿ ಅನ್ನೋದು ನಮ್ಮ
ನೋಟಿಫಿಕೇಶನ್.
notification ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ.
ನೋಟಿಫಿಕೇಶನ್ ಆಗಿದೆ, ಪೇಪರ್ಸ್ ತರಿಸಬೇಕಲ್ಲ.
Complaint is there.
ಕಂಪ್ಲೇಂಟ್ ಇಸ್ ದೇರ್. ಬಟ್ ಕಂಪ್ಲೇಂಟ್ ಮೇಲೆ ಏನ್ ಆಗ್ಬೇಕಾದಾಗಿಲ್ಲ. ವಿಶಾಖ ಪ್ರಕಾರ ಇಫ್ ದೇರ್ ಇಸ್ ಸಚ್ ಎ ಕಂಪ್ಲೇಂಟ್, ಇಟ್ಸ್ ಎ ಸೀರಿಯಸ್ ಮ್ಯಾಟರ್.
Yes.
Nobody will be safe. No woman will be safe at the hands of such people. You should have taken action as per that.
ಅದ್ರಲ್ಲಿ ಇನ್ನೊಂದು ಏನಾಗಿದೆ ಅಂದ್ರೆ, ಆಫ್ಟರ್ ಟ್ರಾನ್ಸ್ಫರ್ ಮೈ ಲಾರ್ಡ್, he was in charge only one Manjunath. After that, Manjunath was challenged before the KET.
you are disposed. After that, I have transferred that fourth respondent.
After vacation now it goes, I'll take a disturb ಮಾಡ್ಬೇಡ್ರಿ.
Hello.
Call this.
Yes.
Hello.
Issue notice. Learned DG appears for the official respondents. Shri so and so appears for the private respondent. First. Having heard the matter for some time, wait a minute. Status quo as on this date.
Yes.
As on
Status
this.
quo is that I have been shifted already. All right.
3 months back, he has been
All right,
shifted.
that is,
Working over there
that is,
since from
that
3
is,
months.
I don't dispute. 3 months back I've been shifted.
Status, there is
Yes.
no status.
Yes.
Status quo. Till next date of hearing.
Please, please.
I take caveat, your lordship, my name.
Sorry, our name and authority.
Just 3 months back.
Sorry.
Whether interim order to continue or not will be decided on the next date of hearing by the roster bench.
Please, please, please. Oblige not.
Hello. Send ಮಾಡಿ. ಬೇಡವಾ? Okay. ಅಲ್ವಾ? Yes. Come brother.
One kind submission in serial number 31.1. I may be
1.1.
Please, my lord. I may be permitted to adopt the argument in 31.13, my lord.
ಅಂದ್ರೆ MR ನಾಯಕ್ ಆರ್ಗ್ಯೂ ಮಾಡಿದ್ದು ಅಂತನಾ?
ಅಲ್ಲ, ಇದು ಕೆ ವಿ ನರಸಿಂಹನ್ ಸರ್ದು ಇದೆಯಲ್ಲ, ಕೆ ವಿ ನರಸಿಂಹನ್ ಸರ್ದು ಇದು ಸೇಮ್ ಕಂಟೆನ್ಷನ್ ತಗೊಂಡಿದ್ದೀವಿ ಸ್ವಾಮಿ. ನಾನು I have
ಎಸ್ ವಿ ನರಸಿಂಹನ್.
ಕೆ ವಿ ನರಸಿಂಹನ್.
ಕೆ ವಿ ನರಸಿಂಹನ್.
Please, please.
Okay, all right. He also adopted other.
Yes, my lord, but the rest of the things what the ಕೆ ವಿ ನರಸಿಂಹನ್ sir submitted.
Alle Shri so and so appearing for the petitioner submits that he adopts the arguments of Shri K V Narasimhan, who in turn adopted arguments of Mr. MR Naik. Okay. Next.
10 minutes.
Yes. Abhinav.
Yes, I'll just take 10 minutes, my lord. I will not.
ಅಂತ ಏನಿಲ್ಲ ತೊಗೊಳ್ಳಿ, ನಿಮ್ಗೆ ಕರೆಕ್ಟ್ ಎಷ್ಟು ಬೇಕಷ್ಟು ತಗೊಳ್ಳಿ, ಆದ್ರೆ ರಿಲೆವೆಂಟ್ ಇದೆ, ನೋ ರೀಐಟರೇಷನ್ ಇದೆಲ್ಲ ಹೊಸದು.
I have compiled all the
judgment
for ready reference, my lord. I'm not repeating it. The
ಕೊಡಿ.
circulars,
No.
2 circulars probably, ತಗೊಳ್ಳಿ. 2 circulars have not been brought to the notice of this honorable court. There is a 2014 circular.
Who should have brought it to the notice of this?
Both of us should have brought it to the notice of the court because it is relevant. My lord, what I have done is, my lord, first one is the amendment itself, constitutional amendment, which I have, my lord.
What is your prayer?
My lord, prayer is, my lord, we all, my lord, are persons who are, my lord, eligible for recruitment to the pre-university college, my lord, recruitment.
Prayer odi.
Yes, my lord. We are challenging the order of, my lord, the KAT.
That's all.
Yes, my lord.
What is your prayer before the KAT?
KAT is, my lord, that the selection made in both the HK and non-HK and filling up of the post is not correct. First point. Second point is, my lord, they have
No challenge to the
we have challenged the 2016 circular.
circular you have challenged.
Yes, my lord. 2016 circular we have challenged. My lord, 2016 circular straight away should go because, my lord, this recruitment, my lord, commenced on 8/5/2015.
8/5/2015.
15. For, my lord, filling up posts to the government pre-university colleges situated throughout the state of Karnataka. I had given one synopsis and judgments, my lord.
ಕೊಟ್ಟಿರಾ?
ಮುಂಚೆ ಕೊಟ್ಟಿದ್ದೆ, ಅದಕ್ಕೆ ಅದನ್ನ ರಿಪೀಟ್ ಮಾಡಕ್ ಹೋಗಿಲ್ಲ.
8/5/2015 ಗೆ recruitment process began.
ಹೌದು. Annexure A1 page 93. When this recruitment process, my lord, began, the rules that were in force were the 17/6/2014 rules.
17/6/2014
rules. In the compilation, which I just now gave to my lords, it is at page number 44.
17/6/2014 rules.
Circular is given, my lord, explaining the manner in which, my lord, post must be filled up.
Okay.
It is a circular.
17/6/2014 is a circular.
Yes, my lord, circular.
Yes.
That is at page number 44 in the compilation which I just now gave to my lords.
Page number?
Page number 44, 44.
44.
This, my lord, is operational guidelines for organization of local cadre for Hyderabad, Karnataka region and allotment of persons in implementing Article 371J of the Constitution of India. Lord, this remains intact even to this day. So therefore, my lord, the recruitment should have been in pursuance of this circular. What they do, my lord, in between is they apply, my lord, the circular dated 13/6/2016 after the recruitment process has commenced. That is the circular which has been brought to my lord's notice, my lord, 13/6/2016, which is recalled in 2020.
Correct.
I will not repeat all those things. I'm only pointing out that in the midst of the recruitment process, they changed the rules by, my lord, adopting the circular dated 13/6/2016. And that they could have not done. So therefore, my lord, this circular was challenged.
Circular dated
13/6/2016. And, my lord, 16/11/2016. Two circulars, my lord.
both.
Yes, my lord.
16/11/2016.
Both of these circulars, my lord, come into force after the recruitment process has commenced. They could not have done it, my lord. The rules of the game cannot be altered.
Yes.
Once the game has begun, my lord, all those series of judgments, arguments, my lord, I will not repeat. Now, my lord, two important aspects, my lord, I will show factually where they are committing a mistake. My lord, now law was argued. How it is, my lord, implemented in an incorrect manner, I will just demonstrate, my lord. Before that, my lord, vaguely, my lord, they use the word HK and non-HK.
Correct.
My lord, the actual wordings are, my lords may kindly take the notification. Please take, my lord, page 6 of the compilation. This is an order, my lord, which is given by the governor himself, which is called the Karnataka Public Employment Reservation in Appointments for Hyderabad, Karnataka Region Order 2013. Page number 6. My lord, this defines local cadre. Please see, my lord, para 2E. Local cadre means any local cadre under the state government or in any local authority or body or organization organized in pursuance of paragraph 3. Then, my lord, local person also has, my lord, bearing. Local person in relation to any local area means a person who qualifies under paragraph 6 as a local person in relation to such local area. Non-local person means person other than a local person. Then region is defined, my lord. Then now please come to, my lord, paragraph 3. This is important, my lord, as to how the local cadres are organized. Para 3. The governor, my lord, this is important.
Governor will do
the
it by-
governor
that
should
he
do
does
it
by notification.
Yes, my lord. Governor should do it by means of a notification. The governor shall, within a period of 3 months from the commencement of this order, by notification identify posts in civil services or civil posts under the state government in the Hyderabad, Karnataka region, or posts in the local authority or body or organization under the control of the state government in that region into local cadre to the extent and in the manner hereinafter provided. So therefore, my lord, whatever districts fall within Hyderabad, Karnataka, a local cadre, my lord, is to be carved out. What is the percentage, my lord, is provided? 75%, my lord, if it is Group A, junior scale. If it is Group B also, 80% of the posts if it is Group C, and 85% if it is Group D. This is the basis, my lord, for everything. So therefore, my lord, in all the posts, my lord, which are identified in the region, a local cadre is to be made. How this local cadre is to be made is in this ratio. So therefore, 75% of the total number of posts in Group A junior division or Group B, my lord, present case, my lord, I am arguing for Group B.
Your clients are Group D.
B for Bangalore.
Okay.
Then, my lord, 80%.
75%, 25%.
Yes, my lord. So therefore, my lord, just to put it, my lord, in a crude manner, in the Hyderabad, Karnataka region, let us assume, my lord, there are 100 posts. A local cadre is to be made. That is 75 posts. If it is Group A and Group B are to be specially reserved only for local persons. That is persons who have their domicile in these districts. 25 of these posts, my lord, only will be available for the rest of the persons throughout Karnataka. That percentage, my lord, varies. This is, my lord, how a local cadre is to be, my lord, made. This is the basis, my lord. This is a governor's order, and governor should do this. Now, my lord, please turn to the next para 4(2). This is where, my lord, the option comes. Local persons may be given an opportunity to opt for being allotted to the local cadre and may be allotted to the local cadres in that region. So first, you please give him an option. Lord, I'll just explain how this works. In the Hyderabad, Karnataka region, my lord, once the posts are identified, 75% you have to give it exclusively by making it a separate cadre. Give it only to HK persons. Then, my lord, in the rest of the state, after excluding these 7 or 8 districts, my lord, you have to carve out another 8%. I will show that also. So therefore, my lord, you are making a separate cadre comprising of 75% of the posts which are there in the 7 or 8 districts and 8% of the remaining state posts, and you are carving out a separate, my lord, cadre only for HK persons who have domiciled in HK. That is a local person. Nobody else can enter into that cadre. You have to be exclusively a person who is belonging to the HK region. So therefore, my lord, in the 7 or 8 districts, residue of 25%, or my lord, depending on the other percentage, and my lord, all throughout the states except the 7 districts where there is 92% that is left out. Let us assume, my lord, Bangalore, I'll take Bangalore. Bangalore does not, my lord, lie in Hyderabad, Karnataka region. Suppose there are 100 posts. I have to take out 8% and reserve it exclusively for Hyderabad, Karnataka. Only, my lord, 92 will be available for other persons. So therefore, my lord, a statewide local cadre will be prepared. What is the statewide local cadre? 75% of the posts in the district and 8% in non-Karnataka districts. So 75 plus 8 will be combined and a separate cadre will be formed. It is like a separate regiment. In a military, my lord, if you can see, it is a separate regiment. This is a separate, my lord, cadre in itself, amenable to all rules of recruitment. Reservation will be there, again 50%, 50%. Within the 50%, how there has to be subdivision, all that will happen.
You will operate
in the 2 cadres. Yes, my lord. And in this, my lord, 75 plus 8, which will make the state-wise cadre, only HK persons can be, my lord, selected or filled or promoted. Now, my lord, 4(2) gives an option to the person, saying that you please decide whether you want, because it is a separate cadre. Question of shifting, my lord, here and there will not arise because there will be other complications for promotion, transfer. So therefore, my lord, 4(2) says, you please give an option to this local person. It is a special privilege given. So he can say either I will go to this HK region reservation or I will compete in the
non-HK region, which we crudely say HK region and non-HK region. So, my lord, there are two separate cadres that are to be, my lord, made. In this case, my lord, I'll just give the numbers. Total number of posts were, my lord, 203.
203 plus.
No, my lord, this is PU, my lord. This is PU lecture. That was, my lord, different. Out of this, my lord, 701 posts were sanctioned in the residual parent cadre. 701 is the residual parent cadre, which they crudely call it as non-HK region. 502 posts are the local cadre, my lord. That is exclusively reserved for, the word that they use is a local person. HK.
Yes.
Now, my lord, when the recruitment takes place, my lord, it takes place with the same rules applicable to two cadres. One is the local cadre, which comprises of, my lord, 502 posts, which is exclusively for persons belonging to HK region. And there is a residual cadre, parent cadre, which has 701, my lord, posts. So therefore, there is bifurcation. And, my lord, there cannot be any intermingling or interplay between these two. So two separate regiments, that's why I use the, my lord, analogy of an army. Two separate regiments are there. So therefore, my lord, when you apply reservation, when you apply, my lord, inter se seniority, inter se merit, it applies to two separate cadres. So therefore, my lord, what they should do is, my lord, drop two separate merit lists. Because once, my lord, my option is taken, I may either opt for the local cadre or that. So therefore, my lord, I am put into that cadre. Why I am put into that cadre is, my lord, to see how my seniority comes. So once, my lord, I assume I opt the local cadre, that is HK cadre, my seniority will be, say, inter se between the persons who have opted for the local cadre or HK cadre. My seniority or merit in the recruitment cannot be compared with that who are appearing in the residual local cadre. Suppose I get out of 100 marks, 70 marks in the HK category. That cannot be compared with the residual cadre. And say there is somebody who has got
more than you, and
so therefore that cannot happen. That where my lords will get is, my lord, please turn to page number 17. That my lords will get at page number 17. I'm just, my lord, showing how it practically happens, my lord. Because, my lord, law cannot be applied in vacuum.
Yes.
My lord, now please take page number 17. Lord, this is the Karnataka Public Employment Reservation in Appointment for Hyderabad Karnataka Region Organization of Local
How page?
17.
Chapter 3.
Chapter 3, please, my lord. Please see, my lord, para 4. The residual parent cadre, I will just take my lords to the definition. I'll read this first and then take my lords to the definition. The residual parent cadre and the local cadre carved out of it shall be treated as a separate unit for the purposes of recruitment, appointment, seniority, promotion, and for operation of reservation. Two parallel roster cycles shall be operated for the residual parent cadre and local cadre. Now, my lord, please see the definition of residual parent cadre, which my lords will get it at the previous page, page 15, para 2E. Residual parent cadre means the cadre with posts which are not identified as local cadre and continue to be remaining in the parent cadre. My lord, local cadre is, my lord, page 7. Please take page 7. My lords will get local cadre.
which I just now, my lord, pointed out.
Means any local cadre under the state government or in any local authority or body. or
Organized under para
organized
3.
in
So
persons
that
of
is how,
para
my
3.
lord, I am making the
That
link.
is after the president issues the notification in terms of para 3,
Yes, my lord, governor.
governor.
Yes, my lord, yes.
All right. Then the cadres are created.
2 cadres are created. How they are created is depending on the post ABC, that percentage, that district is taken out. 8% is taken out from the rest of the state. Apart from the 7 districts, it is merged and it is made as state-wise local cadre. That, my lords, will get it at page number 16. Page 16. These are the words, my lord. The manner of constituting local cadre which may consist of the following units, namely, state level cadre means a cadre carved out of respective Group A, Group B, C and D posts in the state level offices or institutions in the government or body or organization to the extent of 8% of the local cadre. So there, this is what I was giving. Suppose we are in Bangalore, 8% you must reserve for HK. Suppose, my lord, it is a district which comes under, my lord, Hyderabad, Karnataka, maybe Ayadgir or somewhere. There, my lord, it is not 8%, it is 75%. So that 75%,
75 plus
8% constitutes a separate cadre. So all your reservations, my lord, say SC, ST, my lord, all that, vertical as well as horizontal, my lord, everything falls within the separate cadres.
701.
Yes, my lord. Yes, my lord.
In that 8% has to be carved out.
No, already carved out. 701 is after the 8%
itself.
Yes, my lord. 701 is after the 8% is removed.
Cadre itself.
8% is included in the 502 posts. 502 posts. So, my lord, the other way of looking at this is, if you don't maintain 2 separate select lists or merit lists, and if you intermix it, yes, my lord, this ratio will obviously not be achieved. This 502 plus 701 will not be achieved because there will be intermingling, interplay.
Another, because I was telling about the 2 silos which are to be kept.
Yes, my lord, exactly. Please, my lord.
Different silos which are to be kept.
Correct, my lord.
Now, person who is eligible in the local cadre,
Yes, my lord.
whether he can apply.
No, my lord, that is why I said he has to make an option.
Option is provided.
4-2. Otherwise, my lord, what will happen is, he will, my lord, again this demarcation into cadres will not, my lord, happen.
Non-regimentation.
Yes, my lord. And my lord, this is explained in detail in the 2014 circular.
But simultaneously, that.
So therefore, my lord, 2 merit lists will be prepared. 1 merit list for 701, 1 merit list for 502. That is.
That will be identified.
My lord, I have to say whether, my lord.
Because it's entirely 2 different cadres.
Yes, my lord.
In isolation to each other. Then if a person applies there, saying that I am exercising my option there under 4-2, and then he makes another application because it is totally different.
My lord, that is explained, madam. That my lords are saying about existing posts. My lord, I am arguing from the viewpoint of recruitment. I will answer what my lords are saying. That is, my lord, clarified in the circular itself. Please see, my lord, that is clearly clarified in the 10/4/2014 circular, page number 194, 195. In the paper book which I have given, my lord, now, please take page number 195. That is clarified. This is the official memorandum of balancing roster points and operation of roster consequent to formation of local cadre, allotment and transfer of local persons to the local cadre and implementing 371J of the Constitution of India. So my lord's answer, my question, my lord, is answered here. I will just read, my lord, second paragraph. I'll read second paragraph. Consequent to the formation of local cadre, the appointing or cadre controlling authorities are required to identify the local persons from among the incumbents working in the parent cadre. In doing so, the entry in the service register before 1/1/2013 as to their hometown or place falling within the local area
shall be considered to be conclusive proof of their domicile. Domicile again is, my lord, then.
Fine.
Such of those who qualify for being classified as local persons shall be given an opportunity to opt for being allotted to the local cadre, and the lien of such of the incumbents opting for the local cadre shall be fixed in the local cadre, and as such, they would move to the local cadre along with their seniority and roster points. So I think this is what my lords were asking me. This is the answer. Lord, interestingly, this official memorandum as well as the circular is not referred in any of the subsequent circulars. 2016, 2020, nowhere, my lord, it is referred, overruled, my lord, abdicated, or even repealed.
This is issued by whom?
Lord, this is issued.
Cell.
Yes, my lord. Of course, this would be, my lord, for existing persons who are, my lord, serving.
Not for
This will,
recruitment.
when it comes to recruitment, my lord, all these can be applied afresh because there is no confusion at all. You have to maintain 2 merit lists and then, my lord, fill up as per, my lord, the other rules of, my lord, recruitment. Then, my lord, I will show the rules. 2014, sorry, circular. Page number 44. There's a detailed circular.
(17/6, 2014).
Yes, please, my lord. I will just read the first paragraph so that we get the context. Consequent upon the amendment to the Constitution of India by insertion of Article 371J, the Parliament has authorized His Excellency the President of India to entrust special responsibility to His Excellency the Governor of Karnataka to initiate all that action required for area development, reservation of seats in educational institutions, and reservation of posts in public employment to local persons of Hyderabad, Karnataka region. In pursuance of this, His Excellency the Governor of Karnataka has approved consequential notifications, one of which is the Karnataka Public Employment Reservation Appointment for Hyderabad, Karnataka Region Order 2013. This order provides for regional and state level reservations in civil services or civil posts under the state government in local authority or body or organization under the control of the state government in that region, as well as the state level offices or institutions or apex institutions by forming separate local cadres in respect of reserved posts within 3 months from the date of the order. As such, the appointing authorities can undertake the process of filling up the post only after local cadre is organized and a notification to this effect is issued. So therefore, my lord, they have made it very clear. Of course, my lord, this runs in detail. I will not read it, my lord. But then, my lord, how the local reservation is to be made, my lord, please see, my lord, here, Rule 5. After having classified the offices located in different parts of the state into state level or regional level offices or other offices, the posts in respect of each of the offices located in Hyderabad, Karnataka region are to be identified along with their cadre strength in the offices of Hyderabad, Karnataka region vis-a-vis the overall cadre strength along with the working strength as per the cadre and recruitment rules of the concerned organization, indicating in detail the time scale of pay, nomenclature of each of the posts, besides classifying the posts as Group A, Senior or Junior, Group B and C. Such of the posts falling under Group A, B, C, D in respect of all the offices of a particular organization located in Hyderabad, Karnataka region shall be identified to arrive at the admissible regional reservation. While in respect of Group C and Group D posts, the posts in the district level are considered to arrive at the admissible reservation to enable organized local cadre at the district level, besides ensuring recruitment of Group C and D posts to be dealt as district-wise cadre. In respect of organizations, establishments, universities, institutions located in the region are concerned, which qualify the definition of state-level institutions, various categories of posts in the head office, corporate office, registered office, administrative office, so and so, where the office of the head of the institution is located, are considered for the purposes of providing state-level reservation of 8%. In respect of
the units, establishments, offices of such organizations, establishments, universities, institutions falling within the region of Hyderabad, Karnataka. Various categories of posts in these units, establishments are considered for the purpose of providing reservation to the local persons at the rate of 75, 80 and 85. This is what I just explained to my lord. So this is in detail a working manual, my lord, to implement that order. Then 8, local cadre formed by grouping the reserved posts in the state level institutions and also in respect of reservation provided the district, sub-district, regional offices can be merged together if need be, forming a statewide local cadre. So this is what I said, my lord, 8% here and 75% there. That is merged and it becomes a statewide local cadre, taking into consideration the administrative convenience in managing the cadres. Otherwise, my lord, if it is Group C and Group D, they are saying you have district-wise, my lord, cadre. District-wise cadre. Only if it is, my lord, a institution which is span Karnataka or throughout Karnataka and above Group C, then, my lord, this will have to happen. Then, my lord, para 9, for the purposes of formation of...
Bidar, Gulbarga, Raichur, Koppal, Yadgir, Bella.
Yes, my lord. So that is also identified. Posts in respect of each of Group A, Group B in each of these offices, so and so, so and so, so and so, shall be arrived at regional reservation. Then, my lord, lords will kindly take, my lord, that percentage is carved out in page 47. Then, my lord, please see Rule 11. After providing for reservation as above, in respect of the posts in the office establishments located in Hyderabad, Karnataka region, the balance posts in the region shall be filled as if it was not reserved.
As if it has not been reserved.
Yes.
Yenandre?
Hagandre, adana separate cadre madadmele, adike neevu fill ಮಾಡಿದಾಗ ಇದನ್ನ as if it is not reserved ತರ ನೀವು fill ಮಾಡಿ ಅಂತ. That is, my lord, the state-wise cadre. Such of the reserved posts are grouped together to form a local cadre, and the balance posts shall form the residual parent cadre. The two cadres so arrived at shall be dealt as separate units for the purpose of direct recruitment, promotion, seniority, operation of roster points, so on and so forth. The instructions issued by the DPAR in regard to operation of roster points from time to time shall be followed mutatis mutandis. So therefore, my lord, you have to operate all these things in two cadres. And my lord, this is nothing but Rule 4.1, which I just now read to my lords. In this recruitment process, my lord, which is undertaken, my lord, state-wise local cadre was carved out, as could be seen from the notification itself. Notification, page number 24. If my lord sees the notification, page number 24, my lords will kindly see.
8/5/2015.
Yes, my lord. That is the recruitment, my lord, under which we fall, my lord. Here, my lord, it is already organized. If my lord kindly sees, residual parent cadre is carved out, 106 posts are identified. Then my lords will also see Rajyavapi Sthaliya Vrinda, that is statewide local cadre, which comprises of 8% of the state level and regional local cadre of 75%. So the posts are identified. So two separate, my lord, cadres are carved out. Now for the purposes of, my lord, how they do the recruitment process, I'll just give an example. Kindly see page 38, my lord. Page 38. Two cadres are carved out. Page 38, please, my lord. Two cadres are carved out. HK local cadre and non-HK, that is the residual cadre. What are the posts? What is the reservation? Horizontal, vertical, everything is spelled out. So, my lord, it is
treated as two separate cadres, which is correct. Up till this point, my lord, the recruitment is correct. After this, what they do is, my lord, I'll also show, my lord, here. My lord, please turn to page number 43, 42 and 43, where applications are, my lord, called for. My lord, page 43, my lord, somewhere just, my lord, above the box, my lord, are you claiming reservation under Hyderabad, Karnataka region, Article 371J? Yes. So that option is there. That is the option that is exercised. Yes, my lord. Are you claiming reservation under Hyderabad, Karnataka region 371J? Yes. So therefore, automatically this candidate will get into, my lord, the HK roster. Yes, my lord. Local cadre roster, he will get into that. If he says no, then, my lord, he comes to non-HK cadre, my lord, his inter se merit will be treated amongst those persons who, my lord, will be there.
Who all come there.
Who all come there. So therefore, my lord, a person who is in Hyderabad, Karnataka has two options. He can compete exclusively in Hyderabad, Karnataka region,
Local region.
local area, local region, or, my lord, his sweet will, he can say, no, I will
Up to the other, section.
because, my lord, other section has 7, as I pointed out in this example, 701 posts are there. Probably he may feel he may get a better chance there. Because what is HK is only 502 in this particular case as an example.
Whereas that will be 701.
Yes,
That
my
is,
lord. So,
By this, yes, no,
yes, my lord.
it will decide whether.
Which cadre? Exactly, my lord. Exactly, my lord.
for the
Exactly.
purpose of choosing
Which,
this or that.
that's all. Now, my lord, in this recruitment till here, my lord, so far.
Suppose if nobody he does not tick mark it.
Yes, my lord.
ಅವಾಗ ಎಲ್ಲಿ ಬಿಡ್ತಾನೆ?
Application accept ಆಗೋದಿಲ್ಲ.
Because
First point.
it's, okay.
Assuming, my lord, it is accepted, then, my lord, he must be given the benefit of, my lord, an exclusive cadre. Yes, local cadre. That is specially carved out for him. He may choose to say, I don't want it. That is left to him. By default, my lord, it should go to him. That is what, my lord, that is the entire intention of 371J. To provide equitable, my lord, employment opportunities. Not equal, equitable. That is, you give them opportunities so that they can compete with the other regions of the state. Correct. Now, my lord, what happened in this recruitment is, my lord, after this, they prepared a single merit list. And then, my lord, started filling up. So what happened, my lord, is
They could not have done that.
they could not have done it. And that was what was ultimately challenged. The justification was 2016 circular. We said you can't rely on that circular because the recruitment started in 2015. Then the, my lord, KIT says, no, we will treat this similar to caste-based reservation. So therefore, whoever is more meritorious, he will automatically get allotted. That argument.
Concept apply.
Concept apply agodilla. All that, my lord, they have argued. This is the clarity I just wanted to, my lord, give. So there.
The operational levels.
Operational level, how? So therefore, my lord, I only supplanted the facts. Rest of the law, my lord, I will not bother you, my lords. Only one judgment, my lord, which is there, where this has been, my lord.
I was under impression you know only civil law, which I do not know either law.
So, my lord, this has been, my lord, in the compilation that I have given, my lord, the fact that once option is exercised, it becomes irrevocable. My lord, page 111, coordinate bench has held so. Page 111.
ಅದು ನಮ್ಮ ಜೋಶಿಯವರ ಜಡ್ಜ್ಮೆಂಟ್ ಅದು.
ಅದು ಪಂಡಿತ್ ಸಾಹೇಬ್ರ ಜಡ್ಜ್ಮೆಂಟ್. Page 111 is, my lord, writ petition. And now, my lord, please come to page number 122. Para 12. The option so exercised becomes irrevocable. And that is in tune with the provisions which I pointed out. I mean, there is no, my lord, ambiguity in that, but only to show that, my lord, one more bench.
Not go on oscillating this,
Yes.
that, etc. Because no, working out logistics.
Yes, my lord, because if they do a single, my lord, that entire demarcation, my lord, becomes illusionary. So there may be a case where there out of 500 posts, you are putting only 300 posts for HK Karnataka persons are getting filled up because you are making a common seniority list. So therefore, that entire cadre system, my lord, vanishes if you don't, my lord, maintain two separate.
Regiments have to be maintained.
Yes,
is your-
yes, ma'am. That is, my lord, a crude example, my lord. That's why I gave, my lord, a army example of regiments. That's my lord. Anything is there, my lord, which there is, I'll. And my lord, how it has happened, my lord, I can give a synopsis where, my lord,
Just give.
my lord, where
small
marks,
right.
which reference to marks, my lord. How, my lord, a more meritorious HK person, my lord, does not get appointed because they have maintained a, which he otherwise could have got into the local cadre. How, my lord, if.
Merit he will go elsewhere.
Yes, my lord. I'll give those examples, my
That
lord.
defeats the very purpose.
Yes. So that I will give with specific examples.
So all talented people should not be in
One team.
Hyderabad, Karnataka.
Yes, one team, my lord. So that is why, my lord, in the IPL, they devised a different system for seeing that the two best team comes. My lord, in the table, the third and fourth team, whoever, my lord, wins, will play the loser of the first and second team. So that, my lord, the best two teams, my lord, ultimately reach the IPL. So this is also similar to that, my lord.
In the negative way.
Yes, my lord. Grateful, my lord.
When you use the terminology of defense people,
yes, ma'am.
regiment, etc.
Yes.
By seeing your tallness, I thought that you are an ex-serviceman also, which you were not.
Any other clarification, my lord, after that? Grateful.
ಎಲ್ಲರದು ಈ ಕಡೆ ಮುಗಿತಾ?
This team is over.
ಯಾಕಂದ್ರೆ ಚಂದ್ರಶೇಖರ್ ಏನಾರ ಇವರೆಲ್ಲ ಮುಗಿಯವರೆಗೆ ನಮ್ಮನ್ನ ಕರಿಬಾಡ್ರಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟಾರ ಅವ್ರು. ಅದಕ್ಕೆ ಮುಗಿದಂಗೆ ಕಾಣ್ತದೆ. ಹಾ. Bani, let us start.
I will present this team till the others come.
If Kantraj comes, at least phone ಮಾಡಿ ಕೇಳಿ ಬರ್ತಾರೆ ಹೆಂಗೆ ಅಂತ ಒಂದು ಕ್ಲಾರಿಟಿ ಸಿಗ್ತದೆ, ಒಂದು ಫುಲ್ ನಿಮ್ದು ಏನಾಯ್ತು ಅಂತ ಗೊತ್ತಾಗಿ ಹೋಗ್ತದೆ. ಮುಂದೆ he will be able to meet ಅಂತ. ಬಟ್ ಇದು ಏನೋ ಡಿಸೆಂಬರ್ನಾಗ ನಮ್ದೇನೋ ಒಂದು ಮೆಥಾಡಿಕ್ಕಾಗಿ we store in our.
Because my lords will exactly know what we are canvassing. And then, my lord, when my lords are
That
considering other
becomes
side
easy
again to.
for the other side.
Yes,
Good point. So previously may not be related to this.
yes, my lord.
If for teachers, during this notification, he chooses that he wants to be in Hyderabad, Karnataka.
Yes, my lord.
There will be another notification.
Yes, my lord.
In that, he will choose, I will not be in that.
Yes, my lord. Lord, that is second one is, my lord, because he has not been selected in the first notification. So second one, my lord, he is saying I will go to that because, my lord, number of posts are more, which is what I said.
Prospects ಜಾಸ್ತಿ ಆಗ್ತದೆ.
Prospects ಜಾಸ್ತಿ ಇದೆ. So ನಾನು ಅಲ್ಲಿ ಹೋಗೋ ಚಾನ್ಸ್ ಇದೆ ಅಂತ.
ಅವ್ನಿಗೆ ಅಲ್ಲಿ ಇಲ್ಲಿ ಎಲ್ಲಿ ಬೇಕಾದ್ರೂ ಹೋಗ್ಬೋದು ಅವ.
ಹೌದು, my lord, ಆ ಬೆನಿಫಿಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ. That is why, my lord, equitable. That is why, my lord, equitable. That benefit is given to him. My lord, even while applying caste reservation, my lord, a meritorious person who belongs to SC, ST,
He goes to the general
he
merit.
goes to the general merit. So same analogy here also. If he, my lord, competes on its merits, why should he, my lord, see?
In the
So therefore, region is immaterial for him. He says, for me, I will compete. I don't want region-based reservation. I will compete in the open merit because he feels he has got that talent, or, my lord, opportunity is also more because the cadre strength is more. Yes.
ಹಾ, ಕಾಂತರಾಜ್ ಅವ್ರು ಬಂದ್ರು. ಬನ್ನಿ ಕುತ್ಕೋಬೇಡ್ರಿ, ಬರ್ರಿ, ನಿಮ್ ಸಲುವಾಗಿ ವೇಟ್ ಮಾಡ್ತಾ ಇದ್ವಿ ಎಲ್ಲರೂ. Please start.
I am this side only.
ಆ ಸೈಡ್ ಅಲ್ಲ,
in our petition.
State is the petition.
State is the petition.
So you are this side only.
Yes. Therefore, my lord, in my petition, my lord, the one petition is filed by the KPSC and the other one is by the government. And another petition is there. So therefore, my lord, I wanted to reply after there, the petition stand. So can I do next date of hearing, my lord?
ಹಂಗಾರೆ ಇದು ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಇದೆ.
Not in that way, because there are two conflicting orders.
ಒಂದ ಓಕೆ.
In that way, he is saying. So
he will be this side only.
He's that side only.
He should be asked, my lord.
You-
whether He is for HK or non-HK.
Ah,
Non-HK.
And later when, my lord, he can exercise that option after the argument.
the notification itself provides that.
Let's,
But I am not HK, that we have succeeded before the tribunal, relief is granted to me. That is what the challenge by the KPSC as well as the government. So.
these are
in
cases.
My petition, if you argue, I will start my argument.
These are cases where, my lords, the circular has been struck down. The 2023 circular has been struck down. So in principle, my lords, they're on that side. But insofar as the party status is
Status
concerned,
is concerned, they are.
so whatever the other side has argued, I think that is what principle is, sir. Maybe after we come.
You adopt the principal arguments of this side. So far as your,
Circular is concerned.
circular is concerned. But for status is concerned, you will be here.
If he goes there, he will be here.
Maybe, sir.
Because that first
Because he will
judgment
have
of challenge,
for the-
because this arises because of two conflicting.
Conflict.
That in fact, that was our understanding that he would argue the matter and KPSC would argue the matter and.
All right, yeah, Rob, start.
No, no, no.
I will learn whether they do it or not next date of hearing. but I-
Yeah, insofar as they're concerned, reserve the right to reply. Now,
You can
ಮಾಡಿದ್ಮೇಲೆ
reply. You
reply.
can reply after.
ಅದೇ ಆಮೇಲೆ ಮಾಡ್ಬೋದು.
That's right.
I will sit here only.
All right. Yes, sir.
First, my lords kindly say 370 one day. My lords have
Buddy.
read it so many times.
No, we'll see. Okay, no.
Read, my lord,
Very often I
in the
say-
way in which I have understood, my lord, so as to convince my lords.
After all, res judicata applies only to the judgments, not for reading at all.
Yes, my
We
lord.
can read it any number of times.
What I would like to emphasize, my lord, is responsibility is imposed upon the governor. My lord, to ensure that, my lord, the imbalance in these two areas, that is, my lord, Karnataka and
Hyderabad.
Karnataka are eradicated. This is the responsibility.
The very object of this provision is
Yes.
that.
371J, my lord, is intended for that. ಈಗ ಮಧ್ಯಾಹ್ನ ಮಾಡಿದ್ದು ಇವೆಲ್ಲ ಮಾಡಿದ್ದು.
Yes, sir.
Before this amendment has taken place, my lord, lot of inputs have been given, my lord, to the parliamentary, my lord, Department of Parliamentary Affairs. My lord, the government of Karnataka has sent their request, my lord, to give special status to Hyderabad, Karnataka region. And they have taken into consideration, my lord, various statistics that are already there, my lord, existing with the government of Karnataka. One such report was, my lord, by Nanjundappa, Commission's report.
Professor D.N. Nanjan.
Yes. His report was the main basis, where, my lord, the statistics were there in that report. And he also suggested, my lord, North Karnataka, there is imbalance, which includes, my lord, even Hyderabad, Karnataka, and, my lord, the Bombay, Karnataka. He gives the statistics.
And he emphasizes more particularly Hyderabad, Karnataka. The data that he gives, my lord, is for the entire North Karnataka. And he special emphasis is, my lord, Hyderabad, Karnataka. The statistics are,
He was Vice Chancellor of Karnataka University.
yes.
And,
That's how, my lord, he knows, my lord, he knows the northern part of Karnataka, my lord. Your lordship, when he was the Vice Chancellor, even Gulbarga also, my lord, was part of
Karnataka University
Yes.
reason.
Therefore, my lord, he had the knowledge of
knowledge of that.
the backwardness and, my lord, both educationally, economically. My lord, he must have toured, my lord, extensively, my lord. He knows the way of life in both the areas.
No, wherever he was in China for 1 month or so,
Yes.
while coming back, he wrote a book on China economics and published it
Yes.
within 1 month.
Yes.
It's a very special
Yes.
brain. Yes,
Lord, he was trained in that way, my lord.
that way.
He used to, maybe he used to find, my lord, only those things, my lord, emerged to his mind. Because his mind was trained in that way to find out the backwardness of a particular region, the reasons for their backwardness.
But
My lord,
basically, he was an economist.
yes,
Economist.
yes. My lord, the Department Parliamentary Affairs Standing Committee, my lord, had all these reports, my lord. May I just pass on, my lord? Photos. No, no. Photo. My lord, this report also suggests, my lord, that they have taken into consideration Nanjundappa's report also.
Why you are taking us to report? Because settled legal position is the courts will go to the reports of the committees only when doubt arises
Yes.
as to the true meaning and scope of Article 371.
This
or
endeavor
such
is, my lord,
articles.
this endeavor of mine is, my lord, to show, my lord, ultimately the whole object is to see that you bring about a balance between these two reasons.
Instead of that, to
Instead of going strictly,
bring Hyderabad, Karnataka to the level of rest of the state.
yes,
That
without strictly adhering to, my lord, the rule of law or, my lord, the convention or, my lord, the rules and regulation which are applicable. If you put me on those rules, my lord,
you are going to bring at all.
yes,
This is your question.
yes. There has to be some leverage. There has to be some, my lord, soft corner for all these aspects, my lord. Ultimate object is to be achieved. Objective interpretation of 371J.
Yes.
My lord, in this, my lord, page number. 3.11, my lord, which we are concerned. There are other backwardness also. 3.111. 3.111. Government employment under the heading of government employment. You will, lordship will have the tabular column.
Pagination illa, okay.
Pagination illa. Paragraph number 3.1.
Government employment.
Yes, yes.
Correct.
Yes. Same thing, my lord. Look at those figures, my lord.
Is it your, from this angle, are you saying all this just to know that once the game begins, rules of the game cannot be changed, all these things will not be applicable at all?
Not for that. Not for that. Niceties of law should not be made applicable.
Come in the way of achieving the object of the.
It is
That
only,
particle
yes,
itself.
it is only with that endeavor, my lord, I will be citing.
In other words, we should not much worry about the means,
Yes.
but we should worry about accomplishment of
The
the
object.
primordial object of 371
Yes,
J.
it is only for that purpose, my lord. Belgaum Division, my lord. According to the Ministry of Home Affairs, the latest appointment.
Yes.
This also becomes relevant, my lord, when the governor has fixed the proportion of reservation.
75,
Yes.
8,
Yes.
that way,
Yes.
and 25.
Yes. Lord, that has again a different principle, my lord, if I have understood in a right way, my lord. When 75 is given to HKE for the vacancies of HKE,
For the cadre of HKE.
for the cadre of HKE, those vacancies are in the HKE division, HKE region. For that 75. If there are 100 posts, 75 for locals, 25 for the non-locals, residue. Because you have gained 25 there, that is non-HKE. You have gained 25 in HKE. Reciprocal, my lord, is 8%, my lord, in the state. In those vacancies. Lord, he has only put it, my lord, 75 plus 8.
Not that way.
I will put it in this way, my lord. 25 plus 100 minus 8. That is 92 plus 25.
92.
Your
99. Portion is also that or no?
Portion is also.
You made it more clear.
Yes. Ultimately, what is the loss cause, my lord? In this bargain, 75 plus 8, one gets. In the bargain, my lord, he loses, my lord, about 19.
He does not lose 90. He gets an option.
No.
Because he has option also.
They are not saying, no, you don't come here.
Then he will be losing that.
So
That itself is.
My lord, that is not
If
how
he
we
is
should look at
allowed-
it.
If he is allowed, there is no question of losing it all.
Yes.
Since you want to block it, this question arises.
Yes. My lord, that should not be how it should be looked at it, my lord. Equitable ಅಂದ್ರೆ ಏನು? ನೀವು ಅಷ್ಟು ಕೊಡ್ರಿ ನಾವು ಅಷ್ಟು ತಗೊಳ್ತೀವಿ, ನೀವು ಅಷ್ಟು ಬಿಡ್ರಿ ನಾವು ಅಷ್ಟು ತಗೊಳ್ತೀವಿ.
Some bargain like
Yes.
this happen.
ನೀವು ಇಷ್ಟೇ ತಗೊಂಡು ಮುಗಿದು ಹೋಯ್ತು, ಇನ್ನು ಈ ಕಡೆ ಬರಬೇಡಿ ಅಂತಂದ್ರೆ ನಾಟ್ ಈಕ್ವಿಟಬಲ್. Lord, I have not gone to that argument, my lord, to consider that. It's only for the purpose. Yes, yes,
Only clarificate.
yes.
ಸ್ವಲ್ಪ amplify ಮಾಡ್ಕೊಂಡು ಹೇಳೋದು.
ಹೌದು. ಆ ವಿಷಯ ಬಂದಾಗ ನಾನು ಡೀಟೇಲ್ ಆಗಿ ಮತ್ತೆ ಹೇಳ್ತೀನಿ.
Now at this stage it may not.
Yes.
But to start with, it will be like.
Yes. How you should look at 371J. How the governor has understood 371J when he issues 2013 notification. In what way he makes this proportion of reservation. For that, these statistics may be necessary.
Yes.
To exercise that parliamentary wisdom, what were the materials before the parliament to give a special status to this is evident, my lord, from these statistics. Now kindly see, my lord, in this.
This statistical data prompted the parliament to go
Yes,
for this.
exercise their wisdom, my lord, to give a status. Belgaum, first column, my lord, Belgaum division. According to the Ministry of Home Affairs, the latest appointment of gazetted officers by Karnataka Public Service Commission, KPSC, in Group A, B, C shows a very dismal picture from Gulbarga division compared to other divisions as shown in the table below. Belgaum division 14. Kindly see, my lord, only 2 class A officers, only 2 selected.
In Gulbarga.
Yes. Gulbarga division, per entire Gulbarga division.
Division 6
That is, my lord, a HKE.
6 districts.
Yes, my lord.
6 districts.
Yes. Bangalore division 27, Mysore division 7.
This disparity they want
Yes.
to address. Yes.
And nextly, my lord, the vacancy position as on that day, my lord, is also indicated. This is for the past situation. This is for a situation which is going to emerge after 2011. Vacancy position, how it has to be filled. How many vacancies are there in this region? The vacancies in HK region. Kindly see Bidar S to Gulbarga S to Yadgir S to Group 1, Group B. Sanctioned, filled up, vacant.
Yes. Yes.
Yes, Nagar. Lord, summary of Nanjundappa's report, my lord. Lord, I will give one more set, my lord. They have only one copy now. Page 44, my lord, the relevant portion. Page 44, adರಲ್ಲಿ. Representation in public service, sports, committees, cultural organization. The High Power Committee, para 2 I am reading, my lord, in this page. The High Power Committee has analyzed the facts and figures of the above aspect. It found that due representation has not been given to the areas of North Karnataka, especially to the Hyderabad Karnataka region, in the matter of recruitment to government services, political appointments in public undertaking, corporation, boards, committees, commission, and like.
Yes.
And it goes on, my lord, giving all these statistics.
Okay.
And the parliamentary committee also refers to this Nanjundappa's commission report, my lord.
Yes. We have understood that 371J
Yes,
is structured on a premise that there is disparity.
yes.
What disparity, how it should be eradicated, the factors are given by experts.
Yes.
We can proceed.
Now your lordship will kindly see, my lord. What is that required to be done, my lord, under 371J? How it has to be done?
Yes.
How it has to be achieved? What is the responsibility of the governor, my lord, to undertake, my lord, undertake the exercise, my lord, in achieving that object?
Yes.
Now kindly see, my lord, what is that is required to be done, my lord, is establishment of a separate development board that is achieved, my lord, simultaneously on making this 371J.
No.
B is
371J empowers the governor because it empowers the president to do that.
the president, the article 371 itself dictates, my lord, that this is what you are required to do.
Correct.
Establishment of the board.
Board.
Simultaneously, the establishment of the board has also taken place, my lord, once the governor, my lord, assumes the charge of discharging the responsibility. Then the second object is equitable allocation of funds. Funds were not given to this area. Therefore, give equitable funds.
Yeah.
Then the next one is, my lord, equitable opportunity and facilities for the people belonging to the said region in the matter of public employment, education, vocational training. To achieve the C, then your lordship will have two. C is elaborated.
Vocational training
C is elaborated in two.
in two.
Yes. An order made under subclause C of clause 1 may provide for. Further emphasizes how it has to be done. A, reservation of portion of seats, that is education institution. We are not concerned with that. Now we are concerned with B. Identification of the posts or class of posts under the state government and in any body or organization under the control of the state in the Hyderabad, Karnataka region. It specifies.
By birth or domicile.
No, my lord. I would stop here only, my lord. The identification of the post will have to be, my lord, only in that region. You identify them. Your lordship will see, my lord, in the 2013 order. After identifying this post, what is to be done? The existing staff, they will be asked, existing staff who are domicile of Hyderabad, Karnataka, they will be asked. For example, he is working in Bangalore. He will be asked whether you would like to opt for that order. First exercise, identify. Second one, ask the option of these officers whether you would like to go there. Whether your seniority will be there, you are taken care of there. Whether you will be posted there, that is done. Remaining vacancies or the post that is required to be filled, they will be reserved. The past vacancies, posting of these officers, and future vacancies making a direct recruitment will make one cadre of Hyderabad, Karnataka area. In that context, the judgment of their Lordship Justice Pandit, my lord, is in respect of exercising option after identifying the post. If he is working in Bangalore, he gives an option. He goes to Gulbarga, that is Hyderabad, Karnataka area. Then in that context, their Lordship said, you have already exercised the option. There is irrevocable. It is irrevocable.
So,
not in that option is not with reference.
Only one seat, he gets it.
My lord, that is in respect of, my lord, opting for that cadre. Yes.
Those who are already in the employment.
That analogy, my lord, cannot be made applicable, my lord.
For recruitment.
Recruitment. He is still, yes.
Obviously, it will not be applicable. Therefore, you want to find fault with that giving option, etc.
Yes. ಇನ್ನ ನಾನು ಹೋಗೋದಕ್ಕಿಂತ ಮೊದಲೇ ನನಗೆ ಆಪ್ಷನ್ ಕೇಳೋದು ಹೋದ್ಮೇಲೆ ಬೇಕಾದ್ರೆ ಕೇಳಿದ್ರೆ ಅಲ್ಲಿ ಹೋಗ್ತೀನಿ ಇಲ್ಲಿ ಹೋಗ್ತೀನಿ ಅನ್ನೋದು Even before I could enter the, my lord, the employment.
Yes.
Now the second part, and reservation, kindly, third line, my lord, in clause B. And
And
the
reservation.
reservation of proportion of such post for the appointment thereto by direct recruitment or by promotion or in any other.
One line harshide. Proportion of such post for
Houdu.
persons who belong to that region
Yes,
by birth or by domicile.
yes. And for appointment thereof
Thereto,
by a direct recruitment or by promotion.
or in any other manner as may be specified in the
Order.
order.
The governor is required to make rules and regulations for the purpose of providing reservation, both for recruitment, even for promotion. That proportion will be decided by the governor. In what proportion it has to be done.
In his individual discretion or aid and advice.
Lord, I will come to that later, my lord. There is nothing like aid and advice.
Individual level. Lord.
My lord, I do not want to say individual, Lord, as required under 371J.
Yes.
Lord, I will fall into the trap of 163. I do not want to fall in the trap of 163. It is very liberal, very, my lord, ultimately the object is to eradicate, my lord, the disparity.
Yes.
It can be, my lord, from the aid and advice of the minister. It can be from the advice by the Hyderabad board. It can be from his own knowledge, from his own experience. Ultimately, my lord, he has to discharge his responsibility. When he is asked, my lord, should be in a position to tell, I was justified in taking this decision.
Yes. But that question arises, whether in his.
Lord, it is a special case, my lord.
That's right.
We cannot fall into those cases where it has been, my lord, provided, my lord, under the constitution, which are the matters, aid and advice, which are the matters which fall outside the aid and advice. My lord, it is a special case in itself. Sometimes it may require the advice of the cabinet. Sometimes it may require the advice of the experts.
Aid and advice andre, as excluding his individual discretion, Arthadali, Maruram versus Union of India. In that context, we are asking that question.
My lord, my lord, that is what has been, my lord, canvassed by the other side also. My lord, I do not want to fall into that principle. Either individual or aid and advice.
That would not make much difference to you at all.
No, it should not make. Ultimately, the object. When he takes a decision, it is the conscience of this honorable court to adjudicate upon whether, my lord, if I say, my lord, it is individual discretion, then the judicial review is taken away. Under Article 164. It is the order of the governor, it shall not be called in question. That would be end of it.
But perhaps exactly contrary the apex court decision.
My lord, the
Anyway, we'll come to
article
that.
itself says, my lord, that
Since
if it
you
is If it is done in his personal capacity, if he says that he has taken a decision and there is no judicial review, my lord, of course, my lord, the article says like that. My lord, the courts have held, my lord, no, if it affects somebody, my lord, and we can, yes.
Naturally. There is nothing which, we are very selfish, in fact.
No, it has to be, my lord.
Nothing which escapes our gauge.
Yes. Ultimately, it has to test the rule of law, my lord.
That's what.
Yes.
So this should be the approach to.
My lord, one other thing, my lord, my lords may note, the governor's order 2013 or amendment made in 2014 is not the subject matter of challenge before this honorable court. My lords are going within the boundaries fixed under 2013, whether it operates, whether the action taken satisfies.
Take it with face value.
Yes,
Because
yes.
not put in challenge.
Yes.
Although they can place their interpretation.
Yes.
As to what the order
Yes.
means.
And my lords will also have to take into consideration whether all those orders are circulars, which emanates, my lord, from the 2013 order or outside 371J. It has been issued by a person who is unconnected with 371J, or it is from, it emerges, my lord, from 2013 order or by the governor. All those government orders, my lord, 6/6/2022, 15/6/2022, and 1/2/2023, they are all government orders. They create a restriction upon the, my lord, candidates of, my lord, HKE. It is not from the governor's office, or it is not from Hyderabad, Karnataka area, which can be said that it is from 2013, you cannot violate, you cannot call in question because it is final, because it is by the governor. One of the argument is that the order of the president is final, you cannot meddle with it, you will have to read it as it is.
Mr. Lakshmi Narayana's argument.
Yes. If it is, if any circular or the guidelines or, my lord, from an order it comes, it has the flavor of a president's, governor's order. It is in that context.
Yes.
Lord, if it is a governor's direction or a governor's order, how can 15/6 be sustained, or how can 6/6 be sustained? It is issued by the government in respect of which vacancies. The government may have the power as far as residuary is concerned.
But not
HK. It is exclusive prerogative of the governor and his officers.
So you answered the question now. That governor will be doing it independent of the government.
Ultimately, for the object that is to be achieved, my lord, under 371. Your lordships have seen, my lord, identification of the post, reservation of the post in the reason.
Correct.
If that is
By whom?
by the governor, my lord, he has to make provision for this in respect of the vacancies in that region, Hyderabad, Karnataka region. Creating an embargo, once you give an option, you are not going there. Better think now only. Who has said? 2013 has not said.
Government circular said.
Yes. That is by creating an embargo on the candidates of 371J. That is, my lord, Hyderabad, Karnataka reason. The existing right, in a way, is being deprived of or taken away. Of being considered, my lord, for the post in the state of Karnataka. As far as the embargo for non-HKE person, there is a provision 371J. You cannot go. You can go only to the extent of 25%. There is a constitutional, my lord, protective umbrella under 371J as far as the 75 posts are concerned.
So what circular did achieved this.
Yes.
Therefore, not vulnerable for challenge.
Yes.
Contention.
They have no right at all. The benefit that they got by creating an embargo on HKE candidates, they want to retain it. By what method? By saying governor has no power, it has the sanctity of the government order. Once you have exercised the option, you cannot go there. You must remain there. A separate cadre is prepared for you. You should not come. Therefore, my lord, the learned single judge, my lord, in that matter, said it is not like a pigeonhole. Once a cadre is created, you must be there only. You should not come outside that cadre. Nobody created that, my lord, the restriction.
That is Sanjay Gowda's judgment.
Yes.
Yes.
Therefore, this creation of cadre is in respect of the vacancies of Hyderabad, Karnataka region. It is meant to be utilized for the person of that domicile, exclusively for them.
Yes.
And the reading of 2013 order will also make the object of 371J is reflected, my lord, in 2013 order. I will be able to show, my lord, from each of the provision mentioned in 2013, it is aimed at achieving the object. It does not speak of the vacancies outside. My learned friend was saying about, my lord, 8%. If your lordship would see, my lord, 8% from where? Which post? Just for a minute, your lordship will kindly see, my lord. 2013 order. I will elaborately deal with that, my lord.
Six 2013.
13 ರಲ್ಲಿ page number 17, my lord, in this book. Page 17, my lord, book page 17. 13. Clause 13, my lord. Paragraph chapter 2, paragraph 13.
State level offices or institutions.
An apex institution. 8% of the post in the following state level offices or state level institution or apex institution reflecting the, kindly see mark this, my lord. Reflecting, this is
Population percentage.
population first time use ಮಾಡಿರೋದು. Reflecting the population percentage of a region in the total population of Karnataka in all departments, body or organization, and put to level of up to a level of group A, junior scale, post shall be reserved for local person of the region, namely, and the department is also given.
Yes. High Court ಇದೆ.
High Court ಇದೆ.
Yes.
My lord, this was a subject matter of a challenge before this honorable court, and this clause 13, my lord, is upheld by this honorable court. By their lordship justice, Chief Justice Oka.
ಅಲ್ಲಿ ಇದ್ರ ಬಗ್ಗೆ ಸ್ಕೋಪ್ ಗಿಪ್ ಏನಾದ್ರು ಡಿಸ್ಕಷನ್ ಮಾಡಿದಾರನು?
Population substituted.
2014 that has been substituted.
ಅದಾದ್ಮೇಲೆ ಅಮೆಂಡ್ ಆಗಿದೆ. ಅದೇ
Population ಅನ್ನೋ ರೆಫರೆನ್ಸ್ ಇಲ್ಲ ಈಗ. In
ಅಮೆಂಡ್ 25 ಬನ್ನಿ ಪೇಜ್.
'31, 2014.
But I stand corrected, my lord, if it is so.
ಇರ್ಲಿ ಸಾಲ್ವ್. But that was there at least when
Yes, yes.
it was made.
But fact remains, my lord, that it is.
All right, vacation ಆಗಿ ಇದು ಇಷ್ಟು ದಿವಸ ಹೇಳಿದ್ದನ್ನೆಲ್ಲ ವಿಲ್ ಪ್ರೊಸೆಸ್. After vacation, we'll have this matter. So you have given the approach to the gate of 371J.
Yes.
Approach to Hyderabad, Karnataka. It should be, this way it should be read.
It should be read only with reference to the vacancies in the Hyderabad, Karnataka area. Thrust is, my lord, don't create restriction for them. It is a special protection given to them. It is a protected umbrella as far as those vacancies are concerned.
Yes. Which did when we sit, we have to import our brother from Dharwad. Perhaps that way. ಸ್ವಲ್ಪ ಬೇಗ ಮಾಡೋಣ ಅಂತಿದ್ನ. All right, we'll also we'll have time to read all arguments.
May I renew my request, my lord, for an interim order, my lord? Just to appear, my lord, for counseling.
ನಿಮ್ಗೆ ಅದೇ ಬೇಕು.
ಎಲ್ಲರಿಗೂ ಬಂದಿದೆ.
ಇಲ್ಲ.
ಎಲ್ಲರಿಗೂ ಕೊಟ್ಟಿದ್ದಾರೆ. It's only for those persons, the petitioners who are here.
Court has already rejected, but fact remains that there is a provisional select list. Anything that is done will upset that. In
ಆಪರೇಟ್ ಮಾಡೋದು ಬೇಡ.
no, in any case,
ಹೋಗಿ ಮಾಡ್ಲಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
no, in any case, that will duplicate the process. And your lords have heard this matter, and your lords are continuing it immediately after the vacation. Lords, successive benches have rejected this. There's a detailed order made earlier. So therefore, this is not a case, my lords, where they can ask for an interim order of this nature and then say that we should be counseled. It may look, my lords.
ಎಲ್ಲದರಲ್ಲೂ ಕೊಟ್ಟಿದೆ. ಅವ್ರು ಕನ್ಸಿಡ್ ಮಾಡಿದ್ದಾರೆ ಇನ್ನೊಂದು ಪೆಟಿಷನ್ ನಲ್ಲಿ. If your lordship would kindly see the autographs, my lord, I have the copies of the order passed.
ಬೇರೆ ಮ್ಯಾಟರ್ಸ್ ನಲ್ಲಿ ಕೊಟ್ಟಾರ.
ಬೇರೆ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲದರಲ್ಲಿ ಕೊಟ್ಟಿದೆ except, my lord, for 12 posts, my lord, 40 vacancies are, my lord, held up. 17 petitioners are there, whereas, my lord, the vacancies which are to be filled up, my lord, are in the nature, my lord, to the tune of 40 and odd. And we are not seeking, my lord, appointment orders. We are only saying.
ಮ್ಯಾಟರ್ಸ್ ನಲ್ಲಿ ಕೊಟ್ಟಿದಾರ.
when the matters came up before this honorable court, this honorable court stayed the final select.
Stayed the final select list.
It was subsequently modified when the final select list will be stayed only insofar as those posts from which the petitioners who are in the unnamed fraudulent select list got replaced. So therefore, my lords, I cannot issue appointment orders to them. But wherever the circular was quashed in two other cases, where circular was quashed, tribunal directed us to redo the entire exercise. Though in those matters, my lords, there were already appointment orders and this honorable court stayed the orders of the tribunal. So it is, without appointment orders, if I consider, my lords have actually considered this.
And your lords have rejected it earlier by your lords' order.
Anyway, we will hear ಬೇಗ ಮುಗಿಸೋಣ ಸರಿ ನಿಮ್ಗೇನು ಅನ್ಯಾಯ ಆಗ್ದಂಗೆ ಏನೋ ಒಂದು ಸಮಥಿಂಗ್ ಅದೇ ಮಾಡ್ಲಿಕ್ಕೆ ಹರ್ಡ್ ಫರ್ದರ್ ಈಗ ಯಾವತ್ತು ಹಾಕೋಬೇಕಾಯ್ತು ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡ್ಲಿದ್ರೆ ನಿಮ್ಗೆಲ್ಲ
Please,
ಫಾರ್ ಯು ಇಟ್ ವಿಲ್ ಬಿ ಡಿಫಿಕಲ್ಟ್
Friday, my lord, so that
Justice Joshi, sir, if it's coming
tentatively on Friday, my lord, first Friday.
full day. But we can start from 10:30 and finish it. In case Justice Joshi is coming from Dharwad. Full day it can be Friday, any Friday if my lords give physically it can be. 17th.
ಎಲ್ಲಿಗೆ ಹಾಕೋಣ
10th. Yes.
10th.
10th ಮಾಡ್ಬೋದಾ
10th, please. 10th is.
Call these matters on 10/1/2025. ಆ ರೀತಿ ಇರ್ಲಿ ಸಪೋಸ್ 10/1 ಇವರು ಇಲ್ಲಿಗೆ ಬರ್ಲಿ ಇಲ್ಲ ಧಾರವಾಡದಿಂದ ಆಗಂಗಿದ್ರೆ ಇಲ್ಲಿದ್ರೆ ಅನುಕೂಲ ಆಗ್ತದೆ.
Yes.
Just will speak, will request honorable chief justice also.
The time of 10:30 or 2:30 will be decided, my lord, in the cause list. That will.
Bandre full day.
My lord, one stretch it can probably get.
ಅದು ಬೇರೆದು ಏನೇನಿದೆ ಅಂತ ಗೊತ್ತಿಲ್ಲ ನಮ್ಗೆ ಅದು ಸಿಟ್ಟಿಂಗ್ ಲಿಸ್ಟ್ ಮೇಲೆ ಡಿಪೆಂಡ್ ಆಗ್ತದೆ.
Now that this will be constituted specially for this case, it can come at 10:30 and complete it. Need not necessarily, lords, 2:30 is only to facilitate. Your lords is dealing with the other work interested. But this combination will be dealing only with these matters. So it can commence at 10:30, subject to your lordship's convenience.
ಮಾಡೋಣ. Hopefully we will do that way.
Yes.
Subject to what honorable
Yes,
judges
your
say.
lordship's
But ಅವ್ರು
convenience.
ಇಲ್ಲೇ ಬಂದ್ರೆ ಇದು ಇಂಥ ಮ್ಯಾಟರ್ ಜೊತೆಗಿದ್ರೆ ಒಳ್ಳೇದು
Yes.
ಅನ್ನೋದು.
No, therefore, on a Friday, my lords,
That's
bench
what-
can assemble here and then deal with it.
ಇಲ್ಲ ಕನೆಕ್ಟಿವಿಟಿ ಅಷ್ಟೇ ಅಲ್ಲ ಅದು ಒಂದ್ ರೀತಿ ಇನ್ಕಮ್ಯುನಿಕೇಟ್ ಅನ್ನೋದು. I am absolutely unhappy with
Lord festival, so.
Friday